A very good morning to all officers. I hope I'm audible. If somebody can just reply that we are audible. Okay. Very good morning, everybody. Today we are beginning the second day of this online seminar. And in this, we are going to be initially covering BNS, and then we are going to go towards the practical aspects of implementation of BNSS. With me, I have my colleague and my faculty member here in NPA, Shri Abhinav. It is my honor to introduce him to you. He'll be taking the class on the BNS. Abhinav is an IPS officer, 2014 batch, born on the Tamil Nadu cadre. He hails from Hyderabad and is an engineer, BTech in IT, and also masters in police management. He is also the recipient of the Sword of Honor during his training here. During his stint in Tamil Nadu, he has served in various districts, including Chennai city as well as Kadalur and Salem district. He's also received the Chief Minister's Special Duty Medal in 2019 and is also a very avid rifleman and sportsman. With this, I welcome Abhinav to this session and I hand it over to him. Thank you.
Thank you, ma'am. Good morning to all the participants from Jammu and Kashmir Police as well as throughout the country who are joining us in the second day of this two-day online course on the new laws. So I think yesterday would have been a very good session by DC Jain sir, who would have given you an overview, the philosophy behind the changes brought about in these three laws. So today we are going to focus for the next 40 minutes or so on the more important changes in the Bharatiya Nyaya Sanhita, which is the new penal code. And post that, we will be focusing on two aspects of BNS in a little bit more detail. First is the inclusion of a section on organized crime and petty organized crime. And post that, the section on Terrorist Act, which is interesting for this cohort because I think that Jammu and Kashmir Police probably registers the most number of cases under UAPA Act. So the similarities between section 113 of the BNS, which talks about Terrorist Act, and the UAPA Act also we can go through and we can take some questions. So we had co-opted a senior advocate who specializes in Makoka to take the session on organized crime, but this morning he came down with heavy fever. So I'll be continuing that session for you and I'll be taking any questions regarding to organized crime as well. So generally enhanced punishments, but also focused on reformation. There is codification of certain judgments. So certain judgments over the course of the last 3-4 decades, which have been passed by Supreme Court and were actually in force. That is, the prosecution as well as the investigative agencies were already complying with those judgments. Just to remove any ambiguity, the penal code has been updated incorporating certain judgments. Treason is now used instead of sedition, and we'll talk a little bit about that. While certain offenses have been added, a few have been deleted. And most prominent, for example, I would say is decriminalizing suicide. So suicide is now completely decriminalized. There is only one section, which is section 226, that has been introduced, and we'll talk about that as well, where it is an attempt to commit suicide in order to threaten any public servant from doing or not doing his legal duty. So we'll be talking about that, but other than that, suicide has been completely decriminalized. The new BNS is in 20 chapters, and there's a rearrangement of the sections and the chapters so that they make more sense logically. You don't have the same kind of offenses now distributed over various sections. They have been brought together, and there's been a certain reordering based on the importance that should be given to a particular kind of offense. There are 358 sections versus 511 sections on the IPC. It does not mean that so many sections have been removed. more or less they've been included as subsections, or they've been brought about under one major section. For example, the definitions are now brought about as subsections, but in IPC you had them as separate sections. So it's just because of that. This is just for general knowledge that the number of sections have in fact reduced. Punishment has been increased in 33 offenses, and more importantly, mandatory punishment has been introduced in 23 offenses. So in most of the major or the often used sections by law enforcement, you will see that a minimum punishment has now been prescribed, which means that erstwhile the courts would, award fine and get it over with. But now we have minimum jail term also included in most of the important offenses. Now we come to the major changes that happen, and anybody has a question or any point, you can type it in the chat box, or you can raise your hand and I'll have a look at it and we can address it. So first is the definition of a child. This has been introduced in section 2.3 to bring about some uniformity. So child is now universally, now it's going to be recognized as any person below the age of 18 years. But in spite of this section, there are certain offenses, not just in the IPC, but maybe some special laws, which may prescribe another age limit. But wherever it is going to say child, it is now, you can take it to mean as any person, boy or girl, below the age of 18. So that has been standardized now. Documents. This is an important change that has been made. Documents, if you see, and I can go over the definition if you want. It includes the phrase electronic and digital record has been inserted into this particular section. So previously you had to resort to maybe the IT Act to kind of bring about this definition of electronic and digital record and how they should be brought about as documents. And this change is important, and I think the faculty who's going to take the session on Evidence Act and all, you can put up a question to them and I'm sure they'll cover it as well, that now documents can be, even electronic documents, digital records can be primary evidence in court. So that kind of helps us. Gender, now there are 3 recognized genders as per the penal code: male, that is man, woman, and transgender, male, female, and transgender. So transgender has been included as a separate, has been mentioned as a separate gender. Now, what is the significance of this? Apart from obviously, recognizing transgenders as a separate group, the impact will be in terms of wherever there are offenses against women. In the IPC, you would remember, and in the BNS as well, there will be 2 categories. One would be anyone can be the offender, right? So it will either be whoever or anyone, and the other would be any man. So the offender would be prescribed as a man. For example, if you take the offense of rape, then it is clearly that the offender should be a man. Now, the importance, the significance of this is, since they have recognized 3 separate genders, when it says man, there cannot be any ambiguity that a transgender cannot be included, cannot be called as a, brought under the ambit of the gender of a man. So that is going to have some relevance. Same thing with respect to victim. If you take the offense of rape, then a woman can only be the victim. And now when you have 3 separate genders, is rape of transgenders, is it recognized? Now that will be elaborated in the days to come by various court judgments. So I think we'll have to wait and see for that. But that is probably, in most of the classes that we've taken on this session and most of the discussions, syndicate groups, etc., this was the point that had evolved, which required more clarity. Movable property. Movable property, in the previous penal code, you had the word tangible assets. If all of you have the book in front of you, or if you have your computer, obviously, and you can open up the old penal code and the new penal code and just keep it with you, Movable property said anything not attached to the land or the ground, which is tangible. So tangible word has been removed in Bharatiya Nyaya Sanhita. What that means is even intangible items such as cryptocurrency, patents, any other digital property, copyrights can be brought under the definition of movable property. This means that they need not be corporeal, they need not be tangible. I'm sorry, in the IPC, the word corporeal was used, which basically means tangible. So the word corporeal has been removed in Bharatiya Nyaya Sanhita, which means that intangible assets like patents, copyrights, etc., obviously cryptocurrency and all can be used as under the definition of movable property, which means that your regular sections of offenses against property can now be invoked for the theft, robbery, dacoity, or loss of these intangible assets as well. So that is going to be an important change going forward. We do not need to rely solely on the IT Act to proceed against offenses involving intangible assets. Community service has been introduced as a new form of punishment under the Bharatiya Nyaya Sanhita. Community service, apart from the regular forms of punishment, which included just one second. Yes. So, sorry. Rigorous simple imprisonment, life imprisonment, death penalty, and fine. These were the forms of punishment, and now a new form of punishment, which is community service. Community service is not defined as a punishment under the BNS, but you have its definition under the Bharatiya Nagrik Suraksha Sanhita. And it is basically any work that is ordered to be done by the court for which, for the betterment of the community, for which he or she will not be paid. So previously also, Motor Vehicle Act had the option of community service. And apart from that, High Courts and Supreme Court, in a lot of cases, especially involving accidents, would order community service as a precursor or prerequisite to a person, to an accused obtaining bail. But now, since it's included as a form of punishment, the trial courts will be able to award community service as a punishment in the offenses for which it is prescribed on completion of trial, or when some cases are commuted in the Lok Adalat, etc., etc. So this is also going to help in reducing the burden. Throughout the code, the words by night. We were used to housebreaking by night, housebreaking by day, criminal trespass by night, lurking house trespass by night, etc., etc. Now the words by night have been replaced with after sunset and before sunrise. And this may help because India is actually 3 different time zones, supposed to be 3 different time zones, but from Gujarat to Arunachal, we have the same time zone, so it will probably help us with that. Section 48, abetment of an offense by a person outside India. Yes, there was no bar on invoking abetment section against people who are residing outside India. But by including it as a specific offense, it is going to help us, especially in international fora. It is going to help us in any court proceedings or any proceedings of any international tribunal when we want to bring about any financial sanctions, when we want to declare any person or entity as an unlawful entity or as a terrorist entity, because now this is specifically, without any ambiguity, an offense under the criminal law in India. So any person who is completely outside India but is abetting offenses in India can be charged under this section. Again, I'm repeating, it was not like there was a bar against invoking abetment previously or criminal conspiracy previously, but this gives us more strong legal footing. And I'm sure this will be useful for Jammu and Kashmir police and Punjab police and Tamil Nadu police and police forces of northeastern states as well, and of course Maharashtra police, where you have involvement of persons or entities outside India into offenses and crimes within India. Sadly, this is still not an offense. So that is why I wanted to bring it out. Marital rape is still not considered as an offense, and it is still included as part of an exception to section 63 of the Bharatiya Nyaya Sanhita. This is a new section that has been brought about, section 69. So it basically talks about a person is accused of this particular offense under section 69 if he has sexual intercourse with a lady by employing deceitful means. So the word deceitful means is important. And secondly, this section clearly mentions, which I will read out in a bit, that this offense does not amount to rape. So I'm just going to read out the section for you. Section 69, whoever by deceitful means or by making promise to marry a woman without any intention of fulfilling the same has sexual intercourse with her, such sexual intercourse not amounting to the offense of rape shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. So I'll talk about the ingredients of this section, and I'll also talk about how this is going to help us from a policing or a law enforcement or a supervisory officer point of view. First of all, this offense is not the same as rape. So if any of the ingredients of rape attract to that particular offense, then section 69 cannot be invoked. I repeat, this offense is not a form of rape. If any ingredients of the offense of rape get attracted in that complaint or during investigation, then section 69 cannot be invoked. That is the first point. The second point is, it is not restricted to only false promise of marriage. It also includes the words deceitful means. So first I'll talk about false promise of marriage. False promise of marriage, there is a further requirement where it has to be shown that there was never any intention of fulfilling the same. That has been included, and yes, you might argue that it's very difficult to prove intention, it's very difficult to establish intention. It is difficult, but it is not impossible. Now that particular phrase has been included so that in case there is a genuine relationship and the relationship does not materialize into marriage or whatever, then there is some protection given in that you will have to establish that he never had the intention. Okay, he or a transgender. Okay, the section includes whoever, it does not include only a man. Never had the intention of fulfilling the same. So right from conception, right from inception of that relationship, there was never any intention to fulfill the same. Now, if you draw parallel to some sections that we're using, you can maybe take cheating or criminal breach of trust. So cheating also we kind of look at ki pehle se when they entered into the contract or when they entered into this, right from inception, he did not want to fulfill that particular contract or he did not want to fulfill his side of the bargain. And then we kind of established that yes, there was intention. So similarly, in this, when you want to invoke this section against false promise of marriage, then there has to be intention that has to be established, and that intention is right from the beginning, he never had any idea of fulfilling his promise of marriage. So that covers the first part. Now next comes deceitful means. What are deceitful means? So the explanation to the section says, and I am reading, quote, deceitful means shall include inducement for or false promise of employment or promotion or marrying by suppressing identity. There was always an offense for sexual intercourse by a person in authority. Now that is still exists. That is not the same as this offense. Okay. What does this offense means? It means, first of all, the inducement or false promise of employment or promotion need not be given by your supervisor, by the manager, by the owner, by the CEO, by anybody. It can be by anyone. So the promise or inducement of a job, of an employment, or of getting promotion in that particular thing can be given by anybody, right? That does not matter. Whether he is capable of giving it or not also does not matter, because that is not given as a requirement. But he has had sexual intercourse on the basis of that, and the victim has had sexual intercourse with the accused, believing that, or no, or believing his words that he is going to get them employment or promotion. So this section will be used often, I feel. Now the next part of it is, how does it help supervisory officers? Because when you try to analyze instances of rape to find out whether they are on a rising trend, they are on a declining trend, etc., etc., then you would always get this issue where which one is technical rape and which one is, actual rape. These kind of explanations would be put out, and you couldn't make head or tail of it. Now it is very clear that rape is going to be invoked under rape, and then you will have these other cases, okay, where the consent actually is there as per section of rape, but still it is an offense under section 69, and it will not be brought about under the statistics of rape. So I think this is going to be a useful section. Gang rape, death penalty. Previously, there was a 12-year, 16-year victim rule. Now it is clearly brought out that gang rape of a girl under the age of 18 will be punished with death. So death penalty has been brought about for gang rape, and the age is universal now. These are important sections. In IPC, these were the 354, 354A, B, C, and D, which talked about harassment, women harassment, sexual harassment, and stalking, voyeurism, disrobing a woman, etc. Now, there has been some form of gender neutrality of the accused that has been brought out under these sections. So if you look at stalking, stalking can still be only done by a man. The accused is obviously a woman, and the victim is obviously a woman, and the accused can only be a man for stalking. That was the case with IPC as well. When you look at voyeurism, the accused is now gender neutral. That means under the IPC, if I give you a scenario, in a ladies' hostel, one lady inmate takes a video of another inmate in a compromising position, then they could not be charged under voyeurism under the IPC, because it mandated that the accused had to be a man. Under the BNS, it has now been made gender neutral from the point of view of the accused only. So now the lady inmate can also be charged with voyeurism if she takes a compromising video of another fellow inmate, right? So voyeurism is now gender neutral. Similarly, intent to disrobe, criminal force or assault with intent to disrobe the accused is again gender neutral. Under the IPC, only a man could be charged with an offense of use of force, criminal force or assault with the intent to disrobe. But under the BNS, it is whoever. So that is important for us. Sexual harassment is again only a man. So I'll repeat, sexual harassment and stalking are only man. Intent to disrobe and voyeurism can be anyone, man, woman, or transgender. Next, we have section 95, which is a specific offense included to included for criminalizing hiring a child to commit an offense. Again, you can tell me that yes, there was always this option of including invoking abetment or invoking conspiracy. That still exists. But once I read this section, you will realize the significance of this section as a separate offense. So I'm reading section 95. Whoever hires, employs, or engages any child to commit, I'm repeating, hires, employs, or engages any child, and again, child means boy or girl below the age of 18, to commit an offense shall be punished with imprisonment of either description, which shall not be less than 3 years, but which may extend to 10 years and with fine. And if the offense be committed, shall also be punished with punishment provided for that offense, as if the offense had been committed by such person himself. Explanation: hiring, employing, engaging, or using a child for sexual exploitation or pornography is covered within the meaning of this section. Now, what is the importance of this is, if you see, there are two different punishments provided. The first one basically means that even if the offense has not taken place, you can charge that particular person. And the second part deals with if the offense has taken place. So if the offense has taken place, then the person, the man who had hired, not the man, whoever who has hired that child or engaged that child will be punished as if he himself or she himself has committed the offense. That is no problem. But the previous thing is very important. 3 to 10 years punishment for hiring, employing, or engaging a child to commit an offense, even if that offense has not taken place. And there is no requirement for it to be an attempt also. ऐसा नहीं है कि attempt होना है, unsuccessful है and फिर invoke कर सकते हैं. It is if you are able to establish that they have engaged, hired, or employed a child to commit an offense, that is sufficient. Which stage of the offense, which stage of commission of the offense, that is you have, of course, preparation and then attempt and then final commission. You don't need to show any requirement of that stage. Right? If you are able to establish that he or she has hired or employed or engaged a child to commit an offense, that will be sufficient to invoke this section. So I think this is going to be an important section, especially to tackle low-level mafias that go on. In many states, begging is also an offense. In many states, lottery ticket selling is an offense. And of course, narcotic selling is an offense everywhere. And they employ children, to kind of do this. So I think this will be useful for us to tackle. And in conjunction with organized crime that we'll be talking about later on, it really gives us a shot in the arm to tackle all these mafias or rackets, etc., that go on in our jurisdictions. So this I'm just skipping. This is gender neutral because it is no more procuration of a minor girl. If you remember 366A used to say that. Now it is a procuration of minor child, which basically means whether it's a boy or a girl. 366, the erstwhile 366A would apply to in the BNS, okay, which is covered under section 96. So this mob lynching, again, this is an example of codification of Supreme Court judgments. If I'm not wrong, it was the Tehseen Poonawala case, I think, in which there was a verdict against regarding mob lynching. So now the punishment section for murder is 103. So as part of that, and again, I'm not talking about culpable homicide and murder, which are dealt with 100, 101, 102, 103. The reason is it's the same as the IPC. So there's no change under the definition of culpable homicide amounting to murder and culpable homicide not amounting to murder. There's no change in that. So that is why I'm not going over that section. But there's an additional subsection under punishment for murder, which is 103(2). So 103 is equivalent to section 302 of IPC, and 302 did not have any subclause. But now just imagine if 302 had a subclause. Similarly, 103 now has a subclause. So 1032 says, when a group of 5 or more persons acting in concert commits murder on the ground of race, caste, community, sex, place of birth, language, personal belief, or any other similar ground, each member of such group shall be punished with death or with imprisonment for life and shall be liable to fine. Now, ऐसा नहीं है कि previously 5 or more people आते तो we had a problem with invoking 302 against them, or 302 read with 34 or 120B or 109 against them. We would still do it. But the advantage of this section is that if you are able to establish that the murder was committed on one of these grounds, and by having any other similar ground gives us a lot of scope, then you do not need to exactly establish what role at the time of murder each person had. Like the courts in many judgments, at least I have seen in my state, a person who actually slashed the knife, or the person who actually threw the acid, or the person who actually lit the fire, which ended up causing death, versus the person who was acting as a scout at that place, making sure nobody comes, or a sentry, or the person who actually brought the kerosene from the car and gave it to this person. There was a difference in the punishment that the courts were awarding. Because, you know, they were talking about degree of involvement, etc., etc. And this gives us good clarity in that they are all liable for a murder. And when it comes to murder, the punishment is imprisonment with life or death. That is very clear. So that is the importance, the significance of this section being included in the penal code. So what I'll do is, now we are coming to the sections that we have to talk about, the major changes: organized crime, petty organized crime, and terrorist act. So before that, I'll cover snatching and suicide, and then we'll take a 5-minute break, and then I can cover terrorist act and organized crime. So now we come to suicide. As I told you that suicide is completely decriminalized, right? But there is this section 226 that has been invoked, and the scenario that you have to recollect would be probably the grievance day at the collectorate. Like in my state, it used to be Monday, and there would be at least 4 or 5 cases of people trying to self-immolate or throwing kerosene on themselves for various reasons. And some would be legitimate reasons, but some would not be legitimate reasons. So I would like to read this section out for you. Whoever attempts to commit suicide with the intent to compel or restrain any public servant from discharging his official duty shall be punished with simple imprisonment for a term which may extend to 1 year, or with fine, or with both, or with community service. Again, yes, punishment is not high, but then again, think of the people who are actually doing this. They are not, you know, really hardened criminals or anybody, but they need to be told that this is an offense under the new law, where an FIR will be filed against them, the case will be investigated, charge sheet will be filed, and they will be awarded some kind of punishment or the other. So I repeat, this section will be very useful, and what I foresee is these kind of cases. Eviction drives, it happens, or any kind of road widening, it happens, and you would be able to invoke this particular section. So this is the only form of suicide that is criminalized, not suicide, only form of attempt to suicide that is criminalized under the new act. Everything else is decriminalized. Of course, previously you always had these sections which are also existing under 225 and 224, which is threat of injury to induce person from to refrain from applying protection of a public servant. That still exists, but this particular 226 is a new section that is there for us. Then I'll go to snatching. And this is something that, this section is something that will bring about a lot of debate among a lot of people. I don't know if Jain sir covered this as part of the philosophy behind changes, but we can definitely talk about it a little bit. So I will read out this section for you. There's a separate section called snatching. And it's section 304. And it says theft is snatching if, in order to commit theft, the offender suddenly or quickly or forcibly seizes or secures or grabs or takes away from any person or his possession any movable property. Whoever commits snatching shall be punished with imprisonment of either description for a term which may extend to 3 years and shall also be liable to fine. So the punishment is only up to 3 years. Now, in different states, of course, different sections were invoked, but more often than not, in most of the states, robbery used to be invoked for offenses of chain snatching specifically, and it carried a punishment of 10 years. Similarly, certain states, I think they used to invoke 382 as well, which was causing hurt or grievous hurt in order to commit an offense, etc., etc. That also used to have punishment for 10 years. Now, suddenly you might be thinking, how can 10 years punishment and offense now be reduced to 3 years? You have to realize that this section does not prohibit you from invoking snatching, robbery or 382, provided the ingredients of robbery and 382 are fulfilled. Right? It does not prohibit you from invoking 379, the erstwhile 379 as well, provided the ingredients of that particular section are fulfilled. This section is more for petty snatching that most of the time the police fail to register or bring into account. It may be mobile snatching, it may be bag snatching at bus stations, at railway stations, etc. It should be looked at from that point of view. So the punishment is only up to 3 years, but the ingredients are also very less. There is no requirement of any death or grievous hurt or attempt to cause death or hurt anything. It only says suddenly or quickly or forcibly seizes or secures or grabs or takes away. So it is very, very easy to invoke this section and to comply with the requirement of ingredients of this section during our investigation for simple things such as bag snatching, cell phone snatching, or any other item of this nature. So please try to distinguish from that. If we suddenly start invoking this section for all chain snatching, then it has only a thing up to 3 years. Remand may not be given by the magistrate, because then they will again start bringing out a Renish Kumar judgment and it's not punishable up to 7 years, etc. So it may cause a little bit of an issue. So please keep that in mind, especially when you instruct your subordinates or when you guide your subordinates regarding invoking of 304 or invoking of the robbery sections. So with that, I'll take a break of 5 minutes. I'll go through the questions that have been sent by WhatsApp and in the chat window. I'll try to address that. When we come back, we look at Terrorist Act. Section 113 Terrorist Act, its comparison with UAPA. What are the similarities? What are the differences? And post that, we will look at organized crime and petty organized crime, how that can be invoked. Like one question is regarding unnatural sex. Yes, it has been removed as an offense. So it does not exist as an offense, and that is why I told you that victim and accused are now defined. We will have to wait for some clarity with respect to any court judgments that will, kind of elaborate that for us. Previously, since gender was just male and female, most of the times we would bring. I hope it's audible. सुनाई दे रहा है क्या आपको? Yes, okay, thank you so much, thank you. Yes, so that's why I told you that previously we would kind of include any transgender victim or anyone as a woman, and we would include that. Now unnatural sex has been removed as an offense. It is no more treated as an offense, and the section of rape can only be applied to a man, right? Of course, if it is a child that is below 18, we will still apply POCSO. There's no issue regarding that. But yes, above 18, unnatural sex at the moment, clear cut, there is no offense for that intercourse. You can still invoke sections like hurt, criminal force, assault, grievous hurt. You can still invoke those sections, but as such, for that particular act, there is no offense. We'll have to wait for some court judgments to kind of explain or elaborate these things, right? Next thing, two questions regarding snatching. One is if snatching is done with an arm in hand, that I am assuming arm means weapon in hand, how would you treat it? And the second is mobile is snatched and during snatching, person is seriously injured, then which section will that act? So see, there is no bar on you to invoke robbery, dacoity sections when the ingredients of those sections are fulfilled. You do not need to resort to this particular section. Right? Though the word mentions the heading of the section, title of the section is snatching, but title is not important at all for us in criminal law. Title can be anything, right? So it does not mean that every type of snatching, only this offense has to be, only this section has to be invoked. When there is no hurt, when there is no weapon used, when there is no threat, when there is no injury, when there is no threat of injury, and yet some kind of snatching takes place. Let's say that two people are walking with a bag in hand, a plastic cover in hand, and somebody comes beside them, snatches away that cover, and then runs away. There's no injury that is caused on that person also. Then we can invoke this section 304. So even if mobile is snatched, there's no relation to the value of the property. So even if mobile is snatched, and during snatching, if the person is seriously injured, then obviously we would invoke sections related to robbery, and if the number is more, sections related to dacoity. There's no problem at all. So we should not have any confusion in that. But simple offenses of snatching, where usually the police were not inclined to bringing that on record by registering an FIR, I think we should now force and insist that FIR under this section be invoked, so that all offenses are brought on. Thank you. So the provisions of rape do not extend to a man. So there was one question regarding that. It's not unclear whether protections against rape are there for male. Protections against rape are not there for male. That is very clear. There should be no doubt in that. Yes, against transgender, yes, there is an issue because the rape law clearly says that the victim has to be a woman. Who is a transgender is defined under section 2K of the Transgender Protection of Rights Act. So there's a Transgender Protection of Rights Act, and section 2K defines who a transgender is. Basically, it's a person who does not associate himself or does not is not the gender that is assigned at birth. Is different from the gender that is assigned at birth. Apart from that, there is another extra qualification that is required, and वो ये है कि the district magistrate should give a certificate in this regard. So basically, the person who wants to be regarded as a transgender has to apply, and the district magistrate should give a certificate. And actually, many of the NGOs and groups were against this particular provision, कि you have to apply and get the certificate. But as the law stands as on date, this is how it is. Yes. Okay. Talking about zero FIR, but victims still have to run to post. So actually, if you ask me honestly, there was never an issue with respect to registration. There should never have been a technical or legal issue with respect to registration of FIR. If I take example of Tamil Nadu, we don't have the concept of called zero FIR. Every FIR has a number. Even if it is an offence happening in some other jurisdiction, we would register a regular FIR and then transfer that FIR as per normal procedure. So the new provision in BNSS has been brought about just to remove ambiguity and bring about a common practice throughout the country. That is, you have to register an FIR irrespective of the jurisdiction. But honestly, in many states, it was still in vogue. Maybe they would not use the term zero FIR, or they would not have this concept of zero FIR. They would invoke a regular FIR and invoke. Something has to be done in this regard. It has to be done only by supervisory officers. The law is very clear. The courts are very clear. Nobody is going to prohibit you from doing that. So it is the supervisory officers who have to step up and ensure that cases are registered promptly. So now we'll go to the section on Terrorist Act 113, and I'm sure that for participants from Jammu and Kashmir, this is going to be very important, interesting, and I think all of you would also have to. Right. So we'll talk about section 113 now. I'm not going to go over the definition for this cohort because you very well know what is the definition of Terrorist Act. It is the same as what is given under the UAPA. So I don't think we need to go threadbare into what is the thing. It is intent to threaten or likely to threaten the unity, integrity, sovereignty, security, or economic security of India with intent to strike terror or likely to strike terror in the people or any section of people in India or in any foreign country, right? That is the basic ingredient of Terrorist Act. And of course, you have whether by using bombs or dynamite or lethal weapon or poisonous gases. It may cause death, it may cause injury, it may cause damage to property, it may cause loss of property, it may cause disruption of essential services, it may cause damage to monetary stability, it may cause damage or destruction to any property in India or abroad, which was what was invoked when NIA registered a case to investigate destruction of or damage to property of our embassies abroad. It also includes detains or kidnaps or abducts any person threatening to kill or injure such person in order to compel government of India or any state government to do or not do something, right? So it is the same, very, very same to the definition under UAPA Act. And therefore, I don't think we need to go into it. But where it kind of, where the similarities and so if you look at this, and of course I'll be sharing all of this with you. So apart from the regular person who commits a terrorist act, there are certain other acts as part of this terrorist act which are also punishable, similar to UAP. So the first one under 113 would be conspiring, attempting to commit, advocating, abetting, advises or incites directly or knowingly facilitates the commission of a terrorist act or any act preparatory to the commission of terrorist act shall be punishable with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life and shall also be liable to fine. Now, this was also there under Section 18 of UAPA Act. It's the same thing that is there. By having it under the General Penal Code, if you remember from your training days, that there was under the stages of offences, preparation was never an offence except for certain very specified things. Like criminal conspiracy के लिए preparation is an offence. Erstwhile sedition के लिए or waging war के लिए preparation used to be an offence. But for other things, there was never preparation to commit murder. Could never be an offence. That preparation had to evolve into attempt. But now in general penal law, abhi under terrorist act mein preparation is also included as an offence. You don't need to go to UAPA, it can be done under BNS as well. Next, 1134. Whoever organizes or causes to organize any camp or camps for imparting training in terrorist act or recruits or causes to be recruited any person or persons for commission of a terrorist act shall be punished with imprisonment which shall not be less than 5 years, but which may extend to imprisonment for life. So 2 sections of UAPA Act have been brought under 1 section of BNS. That is, 18A said organizing terrorist camp and 18B said recruiting of person to commit a terrorist offence. Now both have been brought under 113. 1135, and this is very interesting. Any person who is a member of an organization which is involved in terrorist act shall be punished with imprisonment for a term which may extend to imprisonment for life and shall also be liable to fine. When you look at the corollary, its parallel in the UAPA Act, for gang or organization, the word terrorist is used. Here, there is no such word used. That means it can be any organization as long as you are able to establish that that organization is, as a whole, is involved in the terrorist act. Then any person who is a member of it is also liable for an offence under 1135. When it came to Section 20 of UAPA Act, and with certain NIA officers also we had this discussion, 1135 actually makes it easier to establish, because that whole aspect of it being a terrorist organization or a terror organization or an organization declared, that requirement is not there under 1135. 1136, whoever voluntarily harbors or conceals, right? This is similar to Section 19 of UAPA Act. And again, I'm assuming that you're all well versed with UAPA Act, and therefore I'm not going into too much detail. You can please correct me if I'm wrong, and I can go into a little more detail, right? Then comes 1137. Whoever knowingly possesses any property derived or obtained from commission of terrorist act shall be punished. The difference between this section and section 21, which you'll have to keep in mind, because that is also what we'll talk about when it comes to whether to register under BNS or UAPA. 21 may, apart from terrorist act, there is another phrase which is or acquired. I'll see if I can annotate here. Or acquired through the terrorist fund shall be punished. So यहाँ fund का कोई बात नहीं है. Funding के बारे में 113 में कुछ है नहीं. तो ये आपको याद रखना होगा. I'm sorry I did my whole thing in English. I just saw one of the comments which said that if you could do in Hindi as well. So I'll try to mix Hindi from now onwards. Now we look at differences. And now I've changed it. The right side column is BNS and left side column is UAPA. Punishment for raising funds is an offense under UAPA, but terror financing or funding is not dealt with under BNS. Right? Anything related to financing is not dealt with under BNS. Offenses by societies or trusts is not, this particular section does not find a parallel under BNS. But if you remember, under section 1135, it said of an organization, right? So it need not be a terror organization or anything. It can be any organization. So I think we can overcome that by using that particular. Section 24A, 33 and 51A talked about forfeiture of property, right, of people related to organizations or gangs involved in this terrorism or terrorist act. It talked about attaching resources, attaching assets, attaching financial assets by person empowered by central government. So 51A empowered DG, NIA, if I'm not wrong, to attach or seize or freeze financial assets. Under BNS, you will have to resort to section 107, where the attachment officer will be the court, and the investigating officer should send a request through the superintendent of police or the commissioner of police. So I'm sure this would have been covered, this section 107 would have been covered when the session on BNSS was taken for you, or if it is not, I think it will be covered later in the day. So I'm again repeating, if you invoke 113, then you will have to resort to section 107 of BNSS to seize, freeze or forfeit any property. And that the authority will be a court, right? Usually a special court or a magistrate or a sessions court, whoever, depending on how your state criminal justice system is designed. When it comes to UAPA, DG NIA used to be the authority. Yes, I will talk about difference between both and challenges in a minute. Probably the next slide or one after that, I will be talking about that. When you had certain criminal procedures that were specifically mentioned under the UAPA Act. They talked about procedure for granting bail, when bail, how bail can be granted and when bail cannot be granted. They also talked about police custody, remand, etc., beyond the limits that were provided in CRPs. So whenever there is a special law that talks about procedure, it obviously takes precedence over the general criminal procedure code. When you invoke the offense of terrorist act under 113, then you cannot take recourse to the special provisions under the UAPA. You will be guided by the provisions under CRPC only, which means the regular provisions of bail will apply, which means that if you want to investigate beyond the mandatory period of 90 days, then the regular procedure will apply, which is basically applying to the court and obtaining a permission. So that is one of the important differences between invoking 113 and UAPA. There was a special witness protection scheme, etc., and you could redact the names of witnesses or any portion of the case diary which would involve the disclosure of the name of the protected witness under 44. And by virtue of 398 of BNSS, this witness protection scheme has been formalized, but it still has to be notified by each state government. This is a very, very important aspect, difference. If you invoke section 113, there is no requirement of any prosecution sanction from anybody to file the charge sheet in the court and for the court to take cognizance of it. Under UAPA, as you all must be understanding, that there is a requirement of sanction to be obtained from the competent authority. Right? This is another important difference. Before this, I would like to talk about one important thing that has been mentioned in the BNS as an explanation to section 113. You all must be already aware of this, but I'll remove this. I'll repeat this. For the removal of doubts, it is hereby declared that the officer not below the rank of superintendent of police shall decide whether to register the case under this section or under the Unlawful Activities Prevention Act 1967. You'll have to understand two things in this. First, it means that you cannot invoke both of them at the same time. You cannot invoke both of them at the same time. But it also does not prohibit you to invoke the sections of UAPA at a later date. Right? Again, there will be judgments of courts clarifying this or giving us a procedure regarding this. But as on date, how it stands is the superintendent of police of that district will decide whether to register the case, the FIR, under section 113 or under UAPA Act. And you know the implications of registering under 113 versus the implications of registering under UAPA. First thing, 113 is not a scheduled offense under the NIA Act as of date. If you register a case under the UAPA Act, it is a scheduled offense, which means NIA can take over the investigation of that particular case. And under the NIA Act, they are very much empowered to do so. There is no requirement of a request from the state government or there's no requirement of the state government to concur or the state police to concur, etc., etc. But since 113 is not a scheduled offense as on date, then the NIA it's not part of that. That is one implication. Second implication, as I've told you, the special procedures under UAPA Act will not be applicable for a case registered under 113. CRPC will apply, right? Third thing, as we have seen, tackling terror financing is not possible under section 113. I repeat, terror financing or offenses involving financing of terrorism or financing of any terrorist act or any organization which is organizing this financing, we do not have provisions under 113 to tackle that. So whenever those kind of ingredients or those kind of issues are there, it would definitely be better to invoke UAPA because UAPA has sufficient provisions to deal with terror financing and persons or organizations involved in terror financing. Yes, guidelines as of now, under the BNS, they are not there. But I am sure that state governments, either through the police standing orders or DGs through memos or circulars or state home department through a government order, will kind of clarify this position. Another important thing, I don't know if you've observed or not, is the rank of the investigating officer is not mentioned under BNS. So you all know that there is a minimum rank of investigating officer who will investigate the case under UAPA Act. But under BNS, under 113, that is not mentioned. I am sure that every state has a police standing order or a police manual or some collection of DG circulars or something which say that murder should be investigated. For example, in my state, murder will be investigated by an inspector of police rank at least. Similarly, 304A, erstwhile 304A would be by minimum inspector of police rank. So there used to be certain divisions based on our police standing orders. Now those have to be redefined or they have to be changed so that acts such as 113 will be included where it is mandated, who is the minimum level of a police officer who will be the investigating officer. Yes. So the basis on which the SP should decide are the points that I have just established. The point is that what kind of offense are you actually registering for? If you feel that it is so heinous that the special protections under UAP Act, the special provisions that help the prosecutors or help the investigating agency under UAP Act are required, then you better well register under UAP Act. If you feel that there is a lot of financing angle involved in this, or this offense, or the reason why I'm charging them, I am making them criminally liable, there's a lot of financing angle involved, then I would rather invoke UAP Act, right? Now, if suppose, I think I would have caused some confusion by my first statement. If the offense is not mentioned under BNS and the offense is there under UAPA, you are at liberty to invoke both in the same affair. My only point was you could not invoke the regular terrorist act under BNS and UAPA. But you invoke regular terrorist act under BNS, and under UAPA you want to invoke the terror financing offenses. You are well within your right to do that. Please don't mistake me when I said that you cannot invoke both to mean that you can never invoke 113 BNS read with UAP Act. You still can invoke things like that. Okay? But the offense should not be repetitive. For example, if you are invoking 1134, which says organizing or causes to organize any terrorist camp, you cannot invoke the corresponding section under UAP. That's all. But if there is no financing mentioned here, there is financing as an offense in UAPA, you can invoke that separate. Okay, there's no issue in that. I'll just open the chat box. On what basis should SP decide whether offense is to be? So this is the basic thing. These are the basic basis. BNS lacks clear guidelines on how this decision has to be done. Absolutely, it lacks, and hopefully it will be clarified by our state headquarters. And if not, I think senior officers of Jammu and Kashmir Police are there. That needs to be definitely looked into, and it will help guiding the young officers. Yes, absolutely. It's not yet mentioned as a scheduled offense. If central government brings about amendment and includes 113 as a scheduled offense, then NIA can take over. Yes, absolutely. So the last thing in the chat box, yes, it is true. Yes, very true, the last thing. So if there's no other point in this, we can go over to organized crime. If anybody has any questions regarding terrorist act, you can please write it. Again, I'll upload the differences and all of that online. That should not be an issue. So no difference between 113 and 50. Yeah, I think enforcing simultaneously I have already covered. The same offense you cannot simultaneously invoke. That has to be kept in mind. So I think there's no other question, so I can go over to organized. Yes. So when we were initially when the bills were introduced, NPA was given the task to go through the bill and the IPC threadbare and find out what kind of advantages will be there, what kind of issues will be there, etc., etc. So when we were going over these new offences, we were looking at how they would be useful for us as a law and order police officer, either in the subdivision or in the district or in the ranges. So one of the most important points that we picked out from there was this section on organized crime. As you know that NPA conducts a lot of seminars and conferences, etc., where senior police officers are called, discussions are made, and then recommendations are submitted to MHA as well, the outcomes of the seminar, conferences, etc. And invariably, anything that had to do with law, there would be a talk that, you know, we are not able to combat organized crime, we are not able to, you know, go after these rackets, etc., etc. And only a few states have special laws, like Maharashtra has Makoka, I think Gujarat also has an organized crime law. If I'm not sure, if I'm not wrong, Delhi also has an organized crime law, but very few states have it. I don't know if Jammu and Kashmir has a special law to deal with, special act to deal with organized crime. So when we look at organized crime, don't just think about it from the organized crime where it talks about some huge network underground from Dubai or from some other place running it. You should even think about the small level rackets and mafias that happen in districts and subdivisions. There would be a robbery gang, there would be a gang that's involved in housebreaking, there would be a gang that's involved in maybe cheating, gangs involved in cyber offenses, cyber cheating, cyber bullying. There may be a gang involved in begging. There may be a mafia or a gang involved in smuggling or adulterating petrol, diesel, etc., etc. Yes, illegal sand mining, absolutely. Selling of illegal bootlegging, okay, liquor, adulterating liquor. There's so many things. And as local police officers, sometimes we are not able to go beyond that initial raid or that initial catch that happens. There may be a gambling ring as well. Organized in many states, gambling is illegal and it's punishable more than 3 years also. So now we always complain that the only tools that we had to catch the big guys, the guys who are running these rackets, was criminal conspiracy or abetment. There's nothing beyond that. So now this particular section, when we read through it, when we go through it, you will realize that if used properly, it's really, really powerful. And you can really make a change, and the people on the ground will feel the change that can be made by invoking these sections properly. And on the flip side, since this law has been enforced for almost 2 months now, I have also heard stories where this law has been completely used in a way it was not supposed to be used also. Right? So we'll talk about both those examples. And first I will read this law for you and I will explain to you what are the important ingredients of this. And I'll also explain to you, more importantly, when can we invoke this section and when you cannot invoke this section. And in fact, Mr. Rahul Kasliwal, who was supposed to join us, made it very clear. We here at NPA were also a little bit confused initially. But since he had done a lot of cases under Mokoka, and the sections are very, very similar to the sections under Mokoka, he could clarify to us and give us court judgments to establish how you can exactly use this law and how you cannot use this law. So I'm starting reading, and any doubts, please type in the chat box and I will deal with it in real time. Organized crime section 111. Any continuing unlawful activity, including kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offense, cyber crime, trafficking of persons, drugs, weapons, illicit goods or services, human trafficking for prostitution or ransom by any person or group of persons acting in concert. singly or jointly, either as a member of an organized crime syndicate or on behalf of such syndicate, by use of violence, threat of violence, intimidation, coercion, or by any other unlawful means, to obtain direct or indirect material benefit, including a financial benefit, shall constitute organized crime. Right? This is the basic definition. And if we are able to understand this definition well, we can use it well and we will never use it in the wrong way. I will repeat the important points of this. As a policeman, we will first focus on, अरे अच्छा robbery भी है, dacoity भी है, extortion भी है. Don't focus on that. Because it only says it includes. This list is not exhaustive. Does not mean that only if it is this kind of offense you can include or you can invoke organized crime. It just says includes. So don't focus on that. My point is you don't focus on that at all. You will only confuse yourself. First important ingredient is continuing unlawful activity. The definition starts with any continuing unlawful activity, including names of offenses. So, including names of offenses, bhul jao. We need to know what is the meaning of continuing unlawful activity. That is the first thing you keep in mind. That is the first important ingredient. The second important ingredient is by any person or group of persons, either singly or jointly. Okay, so it does not matter that instant offense कितने लोग कर रहे हैं. ऐसा नहीं है कि 3 लोग होना चाहिए, 5 लोग होना चाहिए, 2 लोग होना चाहिए या 10 लोग होना चाहिए. ठीक है, वो instant offense. Keep this in mind. But the important point is that person or persons should be doing this offense, should be committing this offense as a member of an organized crime syndicate or on behalf of an organized crime syndicate. So the important second ingredient is organized crime syndicate. तो पहला ingredient हो गया unlawful, continuing unlawful activity. दूसरा ingredient हो गया organized crime syndicate. I'll explain to you what is organized crime syndicate, what is continuing unlawful activity. Third important ingredient. Now, yes, it says use of violence, threat of violence, etc., etc. But it in the end says any other unlawful means. So you don't have to worry about what means he is using to commit that particular offense, because it says any other unlawful means. So you don't have to think only if he brings a pistol, only if he brings a knife, he is committing this. Only if he throws a bomb, he is committing organized crime. So don't consider that as an ingredient also. The ingredient, third ingredient is to obtain direct or indirect material benefit. Okay? Somebody's written in the chat box. No, it is not important. I'll repeat. By use of violence, threat of violence, intimidation, coercion, or by any other unlawful means. So the threat of violence, violence is not important here. Please keep that in mind, right? So I am repeating there are 3 important ingredients and we will be explaining each ingredient now. First important ingredient is continuing unlawful activity. So we need to know what is continuing unlawful activity. Second important ingredient is organized crime syndicate. We need to know what is an organized crime syndicate. Third important ingredient is जो ये काम कर रहे ये लोग, जो ऑफेंस कर रहे ये लोग, जो ये सिंडिकेट कर रहा है या जो ये लोग ऑन बिहाफ ऑफ सिंडिकेट कर रहे हैं, that should be for a material benefit. It may be direct benefit, indirect benefit, it may be financial benefit or other benefit, but it should be some material benefit. So the third important ingredient is material benefit. I hope I am clear with regard to these 3 ingredients. If not, please type in the chat box. I am willing to go over it again and again. Now I'll come to each of this ingredient. What does continuing unlawful activity mean? Continuing unlawful activity, it is given under explanation 2 of this section 111, and I'm going to read it now. Continuing unlawful activity means an activity prohibited by law, which is a cognizable offense, punishable with imprisonment of 3 years or more. Okay, any offense. So इसलिए मैंने बोला कि kidnapping वो सब important नहीं है, because any offense which is punishable by any law for a term of 3 years or more, right? It should be cognizable and it should be an offense punishable for 3 years or more. That is what is required for us. That is what is important for us. So, for example, in my state, smuggling of liquor from other states is punishable for 3 years. So then it is part of an unlawful, continuing unlawful activity. Of course, there are more parts. I will talk about that. I will talk about how kidnapping and organized crime section will apply a little later on. कि organized crime section कैसे apply होता है, I will talk about later on. First, we'll cover the ingredients. Right, next, 3 years or more, undertaken by a person, either singly or jointly, as a member of an organized crime syndicate or on behalf of such syndicate, in respect of which more than one charge sheets have been filed before a competent court within the preceding period of 10 years, and that court has taken cognizance of such offense, and this includes economic offense. Okay, so I'm going to repeat this ingredient. Continuing unlawful activity के लिए पहले चीज चाहिए हमें कि that unlawful activity, that offense should be cognizable and punishable more than 3 years. Okay, second thing is वो जो लोग whom you claim are part of the organized crime syndicate, which we'll talk about now. What is an organized crime syndicate? The people whom you claim are part of the organized crime syndicate. Suppose you claim that 10 people are part of the syndicate. Against anybody of those 10, there should be at least 2 charge sheets that have been filed and court has taken cognizance, which means court has numbered the case. I am repeating. अगर आप लोग बोलते हैं 10 लोग इस syndicate के part है, तो against anybody, maybe against one person you might have 2 charge sheets, maybe against one person you might have 1 charge sheet, and other person you might have 1 more charge sheet, no problem. कुल मिला के cumulatively against that organized crime syndicate, there must be at least 2 charge sheets already filed in court, and the court should have taken cognizance, which means the court should have numbered that particular case. Right? If that is there, then it is a continuing unlawful activity. Now we come to organized crime syndicate. Organized crime syndicate is very simple. Whenever the law is simple, it becomes tough for the investigating officers. So organized crime syndicate, the explanation says, means a group of 2 or more persons who, acting either singly or jointly as a syndicate or gang, indulge in continuing unlawful activity. And we have talked about what is continuing unlawful activity already. Right? So the 3 ingredients हमने discuss कर लिया. पहला है continuing unlawful activity क्या है, we have established. Second है organized crime syndicate क्या है, we have established. And third is very simple, which says the end result, the motive, final motive should be direct or indirect material benefit. If these 3 ingredients are there, it falls under the ambit of organized crime. Now I'll give you an example of how these ingredients are not used, are not fulfilled, and yet some states have invoked 111. There is a cyber offense, cyber crime racket. You investigate, you find out bank accounts, you find out the financial trail, and you catch 3 people who are involved in that cheating. Okay? And you invoke 111 against them. Right? Without even checking, without even establishing that whether against any of those 3 people or cumulatively, there are at least 2 charge sheets already filed and the court has taken cognizance of it. That is very, very important to invoke organized crime. So there have been some state police forces who have invoked it without this. They said organized crime क्या है? General understanding. Organized crime मतलब एक group है, 3-4 लोग हैं, वो लोग बहुत दिन से ये काम कर रहे हैं, साथ मिलके कर रहे हैं, तो हम 111 invoke करें. Please do not do that. It is very clear what the ingredients are. Right? Now we come to how do we invoke? Let's say there's a kidnapping racket. Okay, before that, You can ask a doubt, and many of our course participants here ask a doubt. Sir, you are saying organized crime syndicate means two or more people. फिर organized crime बोल रहे हो singly or jointly? ये कैसे हो सकता है? The meaning of this is the organized crime syndicate needs to have a minimum of two people. But every act of that organized crime syndicate, every act in that continuing unlawful activity need not be done by two or more people. It can be done by one person. So I will give an example. There may be a chain snatching racket. There may be 4 people who are involved in chain snatching, right? But each act may be done by only one of those persons. Does not matter. That is what this act says. When you have to establish there an organized crime syndicate, you need at least 2 people. And when you have to establish that it is a part of an organized crime, you don't need 2 or more people. That is what you have to keep in mind. Yes, I will come to that question as well. So now I'll give you an example. We will talk about 4 people, A, B, C and D. Okay? A ने जनवरी 2024 में एक रॉबरी किया, एक चेन स्नैचिंग किया. ओके, अर्स्टवाइल जो 392 सेक्शन है वो इन्वोक किया हम लोग. A ने जनवरी में he has committed that offense. We have registered FIR, we have investigated, we have found out that A has done it. We have recovered the property, arrested him, sent him for remand. We have filed the charge sheet in court. Court has taken cognizance. ठीक है, ये जनवरी 2024 में हुआ. मार्च 2024 में पर्सन बी ने एक रॉबरी किया, चेन स्नैचिंग. We have registered an FIR. We have investigated. We have found out that B has done it. Okay, and we have क्या बोलते हैं, arrested him, recovered the property, remanded him, filed the charge sheet. Court has numbered it. Trial is going to begin. ठीक है. अभी A के इन्वेस्टिगेशन में, A के केस के इन्वेस्टिगेशन में, B के केस के इन्वेस्टिगेशन में हम लोग को कुछ लिंक पता नहीं चला. स्टैंड अलोन ऑफेंसेस के तहत ही हम लोग चार्जशीट फाइल किए. ओके, अभी क्या हुआ, अगस्त में एक चेन स्नैचिंग ऑफेंस हुआ, एक रॉबरी ऑफेंस. वी रजिस्टर्ड द एफआईआर, ओके, अंडर द रॉबरी सेक्शन ऑफ बीएनएस. So I am saying it is 392 of IPC. Just assume it so that it's easier for you to understand. 392 में FIR किया, इन्वेस्टिगेट किए. अब ये पता चला कि C has committed this offense. तो C को अरेस्ट किए, C को इंट्रोगेट किए. तो तब हमें पता चला कि नहीं, रिकवर किए ज्वेल्स, इंट्रोगेट किए. तो हमें पता चला कि नहीं, एक्चुअली जो जनवरी में ऑफेंस हुआ, जो फरवरी में ऑफेंस हुआ और जब ही ये अगस्त में हुआ, ये तीनों एक पार्ट ऑफ ए गैंग है या ग्रुप है. ठीक है. हम लोग ने एफआईआर ऑर्गेनाइज क्राइम में नहीं किया, हम लोगों ने रॉबरी सेक्शन में एफआईआर किया था. बट ड्यूरिंग इन्वेस्टिगेशन वी हैव फाउंड आउट दैट दे आर ऑल पार्ट ऑफ दैट सेम ऑर्गेनाइज क्राइम. ठीक है, नो प्रॉब्लम. अभी हम लोग मेंशन करेंगे ये थर्ड वाले एफआईआर में, सी के एफआईआर में, नॉट एफआईआर में, सी के इन्वेस्टिगेशन में हम लोग ये सब फैक्ट्स लेके आएंगे कि ए बी के ऑफेंस में भी ये ऑर्गेनाइज्ड गैंग ही इन्वॉल्व था. दे आर डूइंग इट पार्ट ऑफ एन ऑर्गेनाइज्ड क्राइम. वी हैव आल्सो फाउंड आउट वन मोर थिंग फ्रॉम सी's केस. वी हैव फाउंड आउट दैट देयर इज वन डी, देयर इज वन पर्सन डी, who is the guy who is directing these guys. Acha, today you do it in this place, today you do it in that place. Okay, we have also found out that there is one person E, who is the guy who collects all the money and who distributes it, right? He is the guy who takes care of, let's say, some corrupt police officials. He is the guy who, let's say, engages the lawyer. He pays the money. He pays the money for them to stay in a hotel, whatever. So now in C's case, we have established A का रोल क्या है ऑर्गेनाइज्ड क्राइम सिंडिकेट में, B का रोल क्या है, C का रोल क्या है, D का रोल क्या है, E का रोल क्या है. Okay, and we have also established how they are part of an organized crime syndicate. Okay, and we should also establish material benefit. वो तो है हमें, no problem. ये चेंज कर रहे हैं तो material benefit कैरी कर रहे हैं, no issues, right? So I hope everybody is in the same page. Again, C के offense में it is not that A has come and helped C commit the offense. वो requirement है नहीं है. It is not that B has helped C in committing the offense. I have never talked about A, B's involvement in that C offense. I have not talked about C's involvement in A and B's offense. इसलिए ये सेक्शन में मेंशन किया है सिंगली और जॉइंटली. तो A ने सिंगली जॉइंट कमिट किया है वो स्नैचिंग, B ने भी singly किया है. C also has done it singly. I hope you're understanding. Okay? Now when we file the charge sheet in C's case, we will invoke the section of robbery. We will also invoke 1112. We will invoke 1113. I'll talk about what 1112 and 3 talk about. We will invoke 1114 for D and E. Okay, and we'll talk about it. So now in the charge sheet for C's case, A is an accused. A will not be an accused for robbery, but A will be an accused for the organized crime sections that we'll talk about. B will also be an accused, so there'll be a charges framed against B. Again, charges framed against B will not include robbery, but will include the other cases. Charges will be framed against C. For C, it will be robbery plus the organized crime sections. Charges will be framed against D, will not be framed for robbery, but for the other sections, similarly for. Right. So when the charge sheet is filed for C, these sections will be invoked. So please keep in mind, there is no requirement of invoking 111 at the stage of FIR. Because there are certain ingredients of 111 that can only be established when we do some basic investigation. Right? You will never receive a complaint from a victim saying that this fellow came on a bike and he snatched my chain, or he threatened me with a knife and snatched my chain, and he has 2 charge sheets against him. ऐसा कभी कंप्लेंट मिलेगा कि विक्टिम बोल रहा है इसके अगेंस्ट 2 चार्ज शीट है, इसके अगेंस्ट 3 चार्ज शीट है? नहीं मिलेगा. Right? So keep that in mind when you're doing it. Yes, when police is a complainant, suo motu complaint, there may be chances that police has knowledge of existence of charge sheets. So this cannot be treated as an independent offense is what I'm trying to tell you. That sees, okay, now this is one thing. Chat box दिखाइए. Okay, yeah. Yes, UAPA can definitely be clubbed together, but I'll come on that later. Now the second thing what I'm talking about. Before that, let me go over the offenses. So 1112 is basically whoever commits organized crime, unke liye punishment. So if the offense resulted in death, then punishment will be, death or imprisonment of life or and fine. In any other case, punishment is imprisonment for a term which shall not be less than 5 years, but may extend to imprisonment of life. So organized crime, irrespective of what the offense is, if you remember offenses, 3 years punishment minimum चाहिए हमें, continuing unlawful activity के लिए. Irrespective of that, अगर आप 111 invoke किए, तो उसका minimum punishment होगा 5 years and maximum होगा imprisonment up to. Okay. Third होगा whoever abets, attempts, conspires, knowingly facilitates the commission of organized crime or otherwise engages in any act preparatory to organized crime shall be punished with imprisonment for a term which shall not be less than 5 years but may extend to imprisonment of life. Again, like terrorist act, preparation to commit organized crime is also an offense. I repeat, preparation to commit organized crime is also an offense. You don't have to wait for the offense to happen. Okay, but you will have to establish that they are preparing to commit an offense. Facilitation of commission of an organized crime is also an offense. So anybody facilitating, you can also invoke this section. Any person who is member of an organized crime syndicate shall be punished with imprisonment for a term which shall not be less than 5 years. Abhi wo ABC ke offense mein, let's say you come across some person X, whom you know is a part of this organized, who you are able to establish as part of this organized crime syndicate. But he has nothing to do with the offense. He will still be charged under 1114. Right? 5. Whoever intentionally harbors or conceals any person who has committed offense of organized crime shall be punished with imprisonment for a term which shall not be less than 3 years, but which may extend up to imprisonment to life. But this section will not apply to spouses of the offender. You cannot claim that a spouse is harboring or shielding or concealing any other person. Next, these are two important, the next two sections which talk about how we can financially target these organized crime syndicates. Whoever possesses any property derived or obtained from the commission of an organized crime or proceeds of any organized crime or which has been acquired through organized crime shall be punished with imprisonment for a term which shall not be less than 3 years or which may extend to life. So any property that a person is possessing and he has derived that possession from this organized crime, either he has paid by using money that he has derived from organized crime, or by virtue of his organized crime he has gained possession of it, he is again punishable. Seventh, which is very important. If any person on behalf of a member of organized crime syndicate, that means he is not a member of the organized crime syndicate, on behalf of a member of organized crime syndicate is or at any time has been in possession of movable property or immovable property which he cannot satisfactorily account for, shall be punishable with imprisonment for 3 years up to 10 years. That means बेनामी property. जो ये लोग कमा के पेट्रोल बंक खरीद लेते हैं, they run a petrol bunk. Some benami is in possession of that petrol bunk, right? Or they buy a complex, or they build a complex. Some other guy is managing it. He is not part of the syndicate at all. His only job is to manage that complex, manage the shops, manage the gyms, right? Manage the hotels. Now, the onus is on that person to account for the property. कि भाई आपको कैसे मिला इस प्रॉपर्टी का पोजेशन, इतना बड़ा कॉम्प्लेक्स आप कैसे बनाए, ये पेट्रोल बंक आपका पोजेशन कैसे मिला आपको. The onus is now on that person to satisfactorily establish how he has obtained that property. So now you can realize what are the advantages that we have in tackling, especially the guys who are kingpins, remote, do not engage in direct activity, but they are the ones who are organizing or enjoying the fruits of organized crime. Now I will come to how we invoke the FIR. Suppose जनवरी में A ने ऑफेंस कमिट किया, हमने चार्जशीट फाइल कर दिया. B ने ऑफेंस कमिट किया, हमने चार्जशीट फाइल कर दिया. ठीक है. और at that time we did not know that they are part of an organized crime syndicate at all, right? Now suddenly in the month of May we get some intelligence, some special branch constable or somebody passes information that actually they are part of an organized crime syndicate, right? You cannot suddenly now invoke section 1112 and file an FIR against them. Okay, I am repeating. You cannot now suddenly invoke section 1112 and file an FIR against them. There should be an offense that you are investigating in which you are able to establish these facts, right? So now there are two options. You can get permission, further investigate the case and establish it and file it. Okay, file a supplementary charge sheet, no problem. Keeping in mind the ingredients are fulfilled, that is 2 charge sheets are already filed, etc., etc. Okay, I'm repeating. You cannot suddenly file an FIR independently 1112 कि they are committing organized crime, because you cannot show what crime has been committed at all. Yes, if you show that somebody is preparing for an organized crime and you are able to establish that, then you can invoke 1113. That is possible. So the ideal method would be like how C has committed an offense, a third offense, and there you have now in that investigation you are establishing that they are part of an organized crime, you are linking them, and then you file a charge sheet in that particular case, having different charges for different accused. So like I told you, one person was simply a member of organized crime syndicate, so the charges against him will be 1114. That will be fine. Somebody was facilitating the commission of an offense, the charges against him will be 1113. Okay, somebody you find out that he is nowhere connected with this offense or anything, but he is member of an organized crime syndicate, charges against him can be 1114. Right? That is how you will have to establish these charges. Do not be in a hurry to invoke this section right at the FIR stage itself. Reason is, just by invoking this stage at the FIR stage, you are not getting any benefit. Right? But rather you are on a weak wicket because you are not establishing many of the ingredients that are required for this section. So rather my advice would be, after the first investigation, the first case diary हम करते हैं, observation, measure, rough sketch, ये सब करके initial statements of the 161 statement of the complainant, उसके बाद statements of the nearby witnesses, वो सब करते हैं. उसके बाद आप establish करके ये charges को invoke कीजिए. That will help us in what do you say, stabilizing our case. Because the FIR hote you invoke the section, they'll go to High Court for bail, etc., quash, etc. You will have unnecessary questions that you'll have to answer. But instead, you invoke this in the right way, and this is how they do it in Makoka as well. Then it will help us. Yes. Yes, ideally, though Mr. Raj has said it means only in the third offense or preparation of offense, FIR under section organized crime can be registered. Absolutely right. This is absolutely right. Okay. Because now if you say, see, A offense may you have not talked anything about organized crime syndicate, कुछ भी नहीं बात किया. B offense may you have not talked about organized crime syndicate. अब suddenly आप एक FIR register कर रहे हो कि एक organized crime syndicate और A, B, C, D उसके part है. It is completely illogical, right? So either you have to reopen, further investigate the case and get some. You will tell the court that I've obtained some additional evidence, so I want to further investigate the case and establish some thing. Or there is a new offense, or you have come about new preparation of an offense, or a new conspiracy for an offense that you have come about, and you register an FIR, and then you invoke these particular sections. That is very important. What I'm trying to say is the base offense is very important. You have to show that what is the continuing unlawful activity that these guys are engaged in. You cannot say कि वो पहले किए थे इसलिए हम लोग invoke कर रहे हैं. Okay, that is the first point. Second point is the offense punishable greater than 3 years need not be under BNS. The only requirement is पिछले 10 साल में. उसका मतलब है कि आप 4 साल पहले कोई रॉबरी केस रजिस्टर किए होंगे, 4 साल पहले कुछ आर्म्स एक्ट केस रजिस्टर किए होंगे, उसमें चार्जशीट फाइल किए होंगे. That can also be used in this organized crime syndicate to fulfill that requirement of 2 charge sheets in continuing unlawful activity. It does not mean that offense has to be only under BNS. The offense can be previously as well. The only limit is 10 years. No, absolutely, you do not need to include. You do not know the previous offenses have been conducted. When C has committed the offense, you do not know that it is linked to A and B. So there is no requirement of mentioning the previous offenses. In your investigation, you are coming about that, and it is, for example, it is something like, how can I say? Let's say that initially you registered robbery. You thought कि 2 लोग ही आके ये कांड किए थे, तो आपने robbery register किया. जब आप investigate कर रहे हो, तब आपको पता चला कि actually 6-7 लोग involved. तो आप alter करोगे dacoity में. Similarly, आप जब register कर रहे थे, आपको नहीं पता था कि C is linked with A and B, they are part of an organized crime syndicate. आप regular robbery invoke करोगे. During your investigation, you have established, you have found out that they are part of an organized crime syndicate. Then you will, in your case diary, in your investigation, you will start including all these previous case details, etc., etc. Explain in English. ठीक है. तो जैसे मान लो कि एक आपने रॉबरी का FIR रजिस्टर किया, तब आपको इंफॉर्मेशन था कि 2 लोग ही इस कांड में इन्वॉल्व थे, तो आप रॉबरी. आपको इन्वेस्टिगेशन में यह पता चला कि एक्चुअली 6 लोग इन्वॉल्व थे, तो तब आप क्या करोगे? ऑल्टर करोगे डेकॉइटी में. ठीक है, बिकॉज यू डिडंट नो एट द टाइम ऑफ रजिस्ट्रेशन. तो इसके लिए सिमिलरली जब सी ने वो कांड किया, मैंने आपको एक्सप्लेन किया था, जनवरी में इन्हें किया, फरवरी में बी ने किया और अगस्त में सी ने किया. जब सी ने किया था, आपको ये पता नहीं था कि सी ए बी लिंक्ड है, एक ऑर्गेनाइज्ड क्राइम सिंडिकेट के पार्ट है, तो आप रेगुलर रॉबरी का FIR ही इन्वोक करोगे. ड्यूरिंग इन्वेस्टिगेशन आपको ये पता चला कि एक्चुअली सी ए बी लिंक्ड है, तब आप in your investigation, in your CD file, in your witness statements, in your investigating officer's case diary, in your charge sheet, आप इंक्लूड करोगे प्रीवियस ऑफेंसेस क्या थे, कैसे ये सी का ऑफेंस ए एंड बी से लिंक्ड है, कैसे ये लोग पार्ट ऑफ ऑर्गेनाइज्ड क्राइम सिंडिकेट है. एंड फिर आप जब आप चार्जशीट फाइल करोगे, उसमें चार्जेस विल बी डिफरेंट फॉर डिफरेंट पीपल. जैसे मैंने बताया था, सी के लिए रॉबरी रेड विथ 111 होगा, ए के लिए सिर्फ 111 होगा, बी के लिए सिर्फ 111 होगा. ठीक है, और जो प्रीवियस चार्जशीट है वो एज इट इज रहेंगे. ए के अगेंस्ट रॉबरी का चार्जशीट वो मुकदमा जारी रहेगा, बी के अगेंस्ट रॉबरी का चार्जशीट वो मुकदमा जारी रहेगा. तो 3 मुकदमे रहेंगे. ओके, ए और बी के अगेंस्ट 3, सी के अगेंस्ट 1, जो ये लेटेस्ट ऑफेंस हुआ है. दैट इज व्हाट आई एम ट्राइंग टू से. क्लियर है? Oh, you wanted me to explain in English. I'm sorry, I read it as you wanted me to explain in Hindi, so repeated in Hindi. Is it clear, Mr. Tamil? Ilta Tamil is olta. Yeah, okay. So I hope this is clear. Again, I'm repeating, it is not necessary that the predicate offenses have to be under BNS. They can be under IPC as well, right? Now it comes to what kind of offenses can be treated as viable for those two charge sheets. So there is no specific thing mentioned, but what is logical is they have to be somewhat related to the activities of the organized crime syndicate. मान लो A के against, person A के against 498 A के charge sheet. No, you cannot, I mean, you would see how absurd it will be to use that charge sheet to tell that this is an organized crime syndicate that is involved in illegal sand mining. Right? So you're using a 498 A charge sheet to fulfill the requirement of two charge sheets. So it will be a little illogical. But it is never mentioned that it has to be the same thing. An organized crime syndicate may be involved in many things. Different people might be involved in different things. Right? So there might be a IT act and a cheating FIR against one person and a charge sheet against one person. There may be a robbery FIR against another person. Right? But their activities are all part of the organized crime syndicate. So the charges never have to be same. At the same time, they have to be somewhat logical and corresponding to the unlawful activity that is being undertaken by the organized crime syndicate. That is very, very important. If there are any more questions, or is it clear? So like I told you, there was this one case where they had arrested a person who was involved in some crypto or Bitcoin fraud. ठीक है, रेड किया, अरेस्ट किया वो बंदे को. They recovered a lot of SIM cards, lot of bank account details, lot of crypto wallets and all that. ठीक है, और उसके साथ दो तीन लोग भी थे जो involved थे. अब वो तीनों को arrest किया और but they did not know what was the exact offense that they were doing. वो तो सिर्फ cryptocurrency क्या बोलते सो he was buying it from the marketplace, from a platform, and he was selling it through Telegram at a premium. So the charge of the police was कि all unlawful activity का पैसा है वो लोग से ये क्रिप्टो खरीद रहे थे और उसको रिटर्न भेज रहे थे. That was the only charge. But they could not establish exactly किसको cheat किया था, क्या किया था. Simply they invoked 111, saying that तीन लोग हैं organized crime में continuing unlawful act. They could not even find out कि at least there is a one charge sheet against one fellow. That also could not be established. More than that, what is the exact offense that they are accused of? Just because 3-4 people are organized and doing something together doesn't make it an organized crime. What is the base offense that they have committed? And in that offense, how is that offense part of the organized crime syndicate? That is very, very important. So don't be in a hurry to invoke this section initially itself. Please establish these three ingredients and then invoke it. Yes. Any other doubts? What's up? Mr. Rohit has said, will it not delay the FIR registration to find out number of cases and charge sheeted in case of organized crime? So the whole point is that there has to be an offense for which you are filing an FIR. That is very important for us. If he is conspiring to commit, let's say, murder, if it's an organized crime group, the crime syndicate that is involved in committing murder for money, right? They are a group that can be hired killers. Then you have to register 120B read with 302 or 307. That is the FIR. So there is no delay in that. You don't have to register an FIR under 111. That is my whole point. So it is not going to delay registering of FIR. Yes, FIR is registered on one IPC and now organized crime is in. Absolutely 111 can be added now. Again, remember the three ingredients. एक है कि दो चार्ज शीट होने चाहिए मिनिमम. सेकेंड थिंग मटेरियल बेनिफिट होना चाहिए. थर्ड थिंग ऑर्गेनाइज्ड क्राइम सिंडिकेट होना चाहिए. उसके लिए आपको एस्टैब्लिश करना चाहिए. एंड द ऑर्गेनाइज्ड, आई फॉरगॉट टू टेल दिस पॉइंट, ऑर्गेनाइज्ड क्राइम सिंडिकेट, द वे यू कैन एस्टैब्लिश इज much more than just conspiracy and abetment. See, if they are all conspiring together, if they are a group, a gang which conspires together, obviously they are part of an organized crime syndicate. You don't have to worry. If they are abetting each other's offense, they are organized crime syndicate, no problem about it. वो लोग खुद मिलके प्लान कर रहे हैं, वो सब कर रहे हैं, नो प्रॉब्लम, एग्जीक्यूट कर रहे हैं, नो प्रॉब्लम, ठीक है। वो लोग ऑफेंस में साथ में ऑफेंस कर रहे हैं, नो प्रॉब्लम, ऑर्गेनाइज क्राइम सिंडिकेट। उसके बियॉन्ड भी हम ऑर्गेनाइज क्राइम सिंडिकेट इन्वोक कर सकते हैं। मान लो कि एक बंदा है या 3 ग्रुप है, दे आर डिवाइडिंग द टेरिटरीज अमंग्स देमसेल्व्स। वो लोग बोल रहे हैं कि ये 3 लोकेलिटी में मैं गांजा बेचूं। दूसरा ग्रुप, ठीक है, आप वो 3 लोकेलिटी में भेजिए, मैं ये ग्रुप ये लोकेलिटी में भेजूं, आप यहां नहीं आना चाहिए, मैं वहां नहीं आऊं। They are also now part of an organized crime syndicate. Because you can take this phrase, there is some kind of formal or informal regulation of the unlawful, continuing unlawful activity that is happening. You should establish that. To establish they are part of an organized crime syndicate. It may be as simple as one person is collecting money for protection. He is telling कि हाँ मैं देख लूंगा पुलिस को, हाँ मैं ये गांव वालों को देख लूंगा, ये देख लूंगा. That is enough. That link is enough to establish that they are part of an organized crime syndicate, because there is some formal or informal regulation. Regulation does not mean control. Regulation of their continuing unlawful activity. That is enough to establish that they are part of an organized crime syndicate. So I am completed with my thing. If anybody has any doubts, you can type it. I hope it was reasonably good. It is difficult for me to take the class on VC because I don't see your faces or your reactions. So that is difficult. In the chat box, if you can quickly, anybody can type, was it okay? Or do you want something extra? What is the chain of organized crime ends in very foreign country? Very good. Okay. So there are 2 things that you please remember. एक है जो हम section 48 देखे थे, जो abetment of an offence by a person outside India, and that is punishable greater than 3 years. So automatically वो भी offence आ जाता है continuing unlawful activity में. Second चीज है BNSS, जो नया CRPC है, उसमें ट्रायल कैन गो ऑन इन एब्सेंशिया. मतलब बंदा नहीं है फिर भी ट्रायल स्टार्ट होके कंटिन्यू हो सकता है. एग्जिस्टिंग सीआरपीसी में कैसा था? इफ द अक्यूज्ड इज नॉट प्रेजेंट इन कोर्ट, ट्रायल कैन नॉट गो ऑन एट ऑल. All the accused have to be present in court, or you will have to split the case into 2. Abhi under the new law and BNSS we don't have to do it. Only the sentencing cannot be done. That person cannot be sentenced only after unless he is present. So even if the perpetrator is outside India, organized crime can be invoked against that person. There is no issue at all. And I will repeat something. A, B, C, D, E 5 लोग है, organized crime syndicate है. D and E के खिलाफ एक भी FIR नहीं है. No issues. If you are able to establish that D and E are part of organized crime syndicate, you can file charges against them. It is not necessary that हर एक के खिलाफ मिनिमम 1 या 2 FIR होना चाहिए. वैसा कुछ रिक्वायरमेंट नहीं है. तो मान लो कोई बंदा बाहर बैठा है, उसके अगेंस्ट FIR है ही नहीं, नो प्रॉब्लम. जब अब नया ऑफेंस हुआ है, FIR हुआ है, इन्वेस्टिगेट कर रहे हो, ये एस्टैब्लिश कर रहे हो, बाहर वाला बंदा भी इन्वॉल्व है, इंक्लूड कर दो उसको 111 में. सिंपल, राइट? ट्रायल भी कंटिन्यू होगा, बस सेंटेंसिंग नहीं होगी, बस इतना ही. वो BNSS का प्रोविजन. आई होप दैट इज that answers your question regarding foreign involvement, right? So any other questions, please you can put it in the feedback, please you can tell us. I think there's another question that is coming. Yes. So the service provider, there's a question which says, we have seen that there are many electronic communication means being used to commit financial frauds in a syndicate manner, with the service provider having facilitated vicariously the commission of crime to be made part of organized crime syndicate. That is exactly what France did to the Telegram app founder, the founder of Telegram app. See, technically, yes, they can be included under organized crime, but Indian criminal law always has given high importance to intention. Always has high importance to intention. So now you can take this to say that वो उसने मेरे अकाउंट से इस अकाउंट को ट्रांसफर करवाया पैसे चीटिंग करके, ऑनलाइन फ्रॉड, ठीक है? वो अकाउंट जिस अकाउंट को ट्रांसफर कर रहे हैं वो एसबीआई में है. So can we include SBI guys as part of the organized crime? So for Indian criminal law, the intention aspect is very, very important. If you are able to establish that, then yes. A service provider, a guy who is selling SIM cards for 5,000 rupees without doing the KYC properly, knowingly putting somebody else's Aadhaar card and selling the SIM cards, absolutely you can include them under one. Because उनका intention आप establish कर सकते हो कि वो एक unlawful activity के लिए he is helping, he is facilitating. 1113 says knowingly facilitates. Knowingly is very important. Knowingly facilitates. So knowingly he is giving the SIM card without fulfilling KYC norms. Knowingly he is using somebody else, his Aadhaar card, and giving the SIM card to this guy. So he is knowingly facilitating. Therefore you can invoke. But मैंने एक ऐप बना दिया, आप वो ऐप को कोई मिसयूज कर रहे हैं तो knowingly establish करना थोड़ा difficult होगा. That is my personal opinion. Again, it's not a legal opinion. It is finally up to you. It's purely my personal opinion that I'm telling. I think that's about it. So thank you so much. I thought I'll finish at 11 o'clock, but good that I've gone to 11:30. So we'll have a tea break. The next session, 20 minutes. So we'll have a tea break and 15 minutes. So 11:45, we will reassemble for the next session. Thank you all the participants. Yes, Mr. Kitchlu, intention is not always required, you're saying. In death due to rash and negligent act, driver does not have intention of killing. The intention here is rash and negligence is the mens rea aspect of that. So if there is no rashness or there is no negligence, it is not an offense only. It in fact is covered under general exceptions of IPC, where it is treated as an accident, where that person is not liable. Because there is no intention of killing, he is not charged with murder. But the intention aspect is fulfilled by his rashness and negligence. Right? So there always has to be mens rea and actus reus. The level of mens rea, what type of mens rea depends on the offense. So when it comes to 304A, it is rashness and negligence.
Good morning, Parmesh ji. Am I audible?
Yes, yes. Good morning,
Uh,
ma'am.
Good morning. आप एक बार शेयर करके देख लेंगे अपनी स्क्रीन so that हम
Sure.
टेस्ट ट्रायल कर लें.
Screen दिख रहा है, ma'am?
हाँ, दिख रहा है. Thank you.
Yes. Stop कर दो, ma'am.
हाँ जी, स्टॉप कर लीजिए. Very good morning, all officers. I think we can start now. Before I formally start it, I had shared one link in the group, which was basically for all the any areas to identify in which training can be given for regarding new criminal laws. So since we are just around 2 months old into the new criminal laws, we are basically doing a very generalistic training in which we are training on all aspects of new criminal law. But we have floated this Google Drive or Google link for Google form for you to basically you can just suggest us certain areas in which you want an exclusive training or which areas you want the focus of our training should be. So with that, I'll be sharing that in the chat also after this session. And so I think we had a break and we'll formally start the session right now. So yesterday we already had a very exhaustive session on BNSS by DC Jain sir. I've uploaded the PPT also now on the Google Drive. Apart from that, today we are going to be focusing on areas which are about the implementation aspects. And regarding the implementation aspects, there are certain specific issues like recording, audio-video recording of the scene of the crime or for the search and seizure proceedings, with which today with me is joined another faculty from the NDCRTC. He is Mr. Parmesh Naik. He is a computer engineer who holds a post-graduation degree in information security. He has been with us as a faculty member of our specialized wing, which is NDCRTC, since last 8 years. And he is very active in the field of cybersecurity, web application, and pen testing. So he has been closely associated with the investigation of approximately 150 plus cases. So he will be there co-joining me in this session when I'm explaining the technicalities of the search and seizure part. So as if now, I'll initiate the first part of my presentation now. Uh, Now we already had this kind of an understanding of what we are doing about it. I'll directly come to the point and how I have basically culled out the other important aspects of it. So as you know that all of our states have now formulated our own respective SOPs of how to implement it. We have by and large a broader understanding of what will be the implementation or what will be the changes, broadly categorized into two very specific parts, which is one is investigation and one is court proceedings. When it comes to investigations, approximately all police agencies have documented and started documenting the SOPs. कि इसको करना कैसे है finally. As senior officers, what is something that we need to keep a watch on? What are the checks and balances that we are going to be finally implementing it on the ground? So today I'm discussing only the implementation phase. We had a discussion yesterday also, so it will be a revision about it. This slide is showing a reference from BPRND. So BPRND has created a list of all compendiums that have been issued till date by respective states and also by themselves also what the documentations have come in the for what they have arrived and what the SOPs are. Now if I'm going to go through all these SOPs and all these discussions also when I'm discussing with you. Finally it will be the state calls of what they are going to be taking from what, but we have to in generally understand what we are doing about it. First point as expected is FIR. FIR is the starting point of our investigation with the fulcrum of everything that is there about us. So we are basically first looking at the much more broader aspects. सबसे बड़ी बात कि हमें अब जीरो एफआईआर करनी है, जीरो एफआईआर करनी है तो उसको करना कैसे है, इलेक्ट्रॉनिक एफआईआर भी करनी है, इलेक्ट्रॉनिक एफआईआर भी करना है तो कैसे करना है. तो when we come to this broad aspect कि अभी हमें जीरो एफआईआर जो हम पहले से भी करते आ रहे हैं उसको अब हमें implement करना है, तो जीरो एफआईआर को implementation करने के लिए we have some options of exactly are we giving them the crime number or are we maintaining a separate register for that. So what CCTNS is proposing and what I understand has been done in majority of the states is we maintain a separate categorization of the zero FIRs. Zero FIRs list is maintained separately by us. It is not merged with the original FIR list that we are basically looking into. वो FIR अलग चल रहा है, हमारा एक zero FIR बन रहा है. CCTNS में उसका एक अलग प्रावधान दिया गया है. There is a separate provision itself per se which has been given for the implementation of that. If you can see that, it shows very clearly that there is something known as a registration of zero FIRs. उसको एक अलग कॉलम दे दिया गया है, उसमें जाकर वहां रजिस्टर करना है. यानी कि जीरो FIRs की अपनी एक अलग लिस्ट बनेगी जिसका एक अलग सीरियल नंबर होगा. ये लॉजिक सिर्फ इसका इतना है कि ये हमारे जुरिस्डिक्शन में ऑफेंस नहीं हुआ है, but since we have already the implementation is also there and the person has agreed, person has approached us, it is our responsibility now to register the FIR. So once we are registering the FIR, now how we are doing it is through this particular mechanism. And if you observe here also, they have created that entire what you call documentation कि उसको कहाँ भेजना है, उसकी एंट्री भी हम इनिशियली जीरो एफआईआर वाले स्टेज पे ही कर रहे हैं. वही हम उसकी एंट्री भी कर रहे हैं कि हमें उसको कौन से पुलिस स्टेशन में भेजना है और जिस पुलिस स्टेशन में भेजना है वहां उसके एसएचओ को का भी एक डैशबोर्ड है जिसके पास भी एक अलर्ट जाएगा. यानी कि whichever the police officer is, whoever that police officer is, where that information has to be sent, from there also this documentation is done that information will automatically go to that person कि this FIR has come for us and this is a FIR which now should be registered as a full-fledged FIR with that appropriate numbers also. जिसको ये इनके हमारे CCTNS पार्लर्स में बोला जा रहा है re-registration of zero FIR. So it is nothing but हमने एक FIR है, same exact column है, वो यहाँ से यहाँ जा रहा है. The entire challenges about this is the logic also is very clear cut. FIR करते हुए हमें complainant का sign चाहिए होता है. ये complainant का sign हमारे पास है zero FIR में because that is what the format is. Once this format is getting transferred there to that particular police stations, the form remains the same. So since the form is remaining the same, there how are we finally documenting it and signing is something that I am now asking you to answer that question, that who basically signs that FIR when the person is registering it there. For example, today I have registered a zero FIR here in Hyderabad regarding something that has happened to me in Srinagar. And I have registered that zero FIR in Hyderabad. So that means under CCTNS, a zero FIR register will be initiated. यहाँ तो मैं खुद present हूँ, इसलिए मैं उसको sign भी कर रही हूँ. हमारा format भी है, हम format में उसको sign भी कर रहे हैं. And once now I have signed that format here, it has to automatically be reflected to Srinagar police SHO. वो श्रीनगर SHO जब उसको accept कर रहा है, तो वहां साइन क्या होगा कंप्लेनेंट का? वहां कंप्लेनेंट का कौन सा सिग्नेचर आ रहा है? एग्जैक्टली हु इज साइनिंग देयर एज ऑन बिहाफ ऑफ द कंप्लेनेंट देयर? So there are two options to it. How I understand it, I'm opening the question here because so that I can also get a much better clarity of it, that who is signing on it. Because at the form that we are using for FIR, now this can happen other way around also. For example, यहाँ हैदराबाद में रहते हुए हमारे पास एक आता है, एक aggrieved person has come to us, and that aggrieved person is based, not aggrieved person, information has come to us that so and so person is admitted in the hospital. So once that person is admitted in the hospital, what do we typically do? We basically send our police constable. That police constable takes his statement and basically comes back, and it is our police constable who's signing on as the complainant. So this is happening with us already everywhere. My understanding of it is that this SHO, the receiving SHO, Srinagar SHO, will receive it directly and will register it immediately on receipt of this information which has been sent to him through the CCTNS. Now, this is my understanding of whatever I have understood out of this entire thing of CCTNS and what it looks like about zero FIR. चाहे हम CCTNS accept ना भी कर रहे हो, maybe our states are not implementing CCTNS, but finally the fulcrum of what CRPC amendment says is, or what the new BNSS says is, I can no longer refuse registration of FIR just based on the pretext that this is not my jurisdiction. But please try to understand that cognizance, when it is taken, once cognizance is taken, when the judicial process starts, the judges, the judiciary, the trial is still based on jurisdiction, where the offense has happened. So for that, anyhow, the cognizance is going to be taken by that trial court only even if I'm completing my investigation and filing a police report under 173 CRPC/193 BNSS. So the fact is, we have to, and we will naturally be going across that entire way of how we are documenting FIR, how we are handling FIR. We have been doing it traditionally, but the fact remains, चाहे हम उसको zero FIR का नाम दें, चाहे हम उसको full-fledged FIR का करें, हम अब किसी भी complainant को refuse नहीं कर सकते हैं that we will not be registering an FIR. We have to register an FIR and do our level best of transferring it to the place where jurisdiction is there. Jurisdiction will always be important for trial. Cognizance trials is dependent on jurisdiction, and that will always be there. Next point, another very categorical point, but which is about EFIR. Now, EFIR is something that we have been discussing for yesterday. Also, we had a huge elaborate discussion on this entire very small one line, which is that now information can also be relayed to us by electronic communication. Now, this के बहुत सारे इश्यूज हैं, उसमें दो इश्यूज है, ज्यादा नहीं है, सिर्फ बेसिक दो इश्यूज हैं कि इलेक्ट्रॉनिक कम्युनिकेशन का मतलब क्या है. तो कल भी आप लोगों ने, yesterday also one of the participants had asked the question that what will the electronic communication mean, and what sir also's response was, electronic communication will automatically mean that what electronic communication has been defined is, means कोई किसी भी तरीके का communication हमें through electronic mean अगर receive हुआ हो तो हमारी definition के हिसाब से वो electronic communication है. इसका मतलब WhatsApp call भी electronic communication है, हमें Instagram हमारे official pages में जो tag किया जाता है वो भी हम electronic communication है, Facebook में tag किया जाता है official pages में वो भी electronic communication है. So this is going to always be an issue, पर हम इसमें किस चीज को ऐड करेंगे. Now, why am I discussing this point is, this is linked to the practicality of it, which every state will now have to formulate its SOP. I am briefing you about 2 points. First point that I am briefing you is about, this is the Rajya Sabha's discussion about this point. See, BNSS, when it was tabled in the honorable parliament, it will be, obviously there will be a lot of discussions about it, ki should we implement it this way, should we implement it that way. If you observe it, this is the extract of the Rajya Sabha discussion about it, in which the way forward and what is our right now the doubt that we have it. They also had the similar kind of a doubt that how exactly are you going to be accepting it, and that will lead to a plethora of a lot of things happening. So if a plethora of lot of things is happening, how will you basically accept this electronic communication? And they very categorically said that let us, you should basically authorize or basically declare certain means for accepting this sorts of electronic communication. Like for their particular say that you should create a portal, and only through the portal, if that information is being received, you should take it in the form of an EFIR, so as to remove this entire doubt whether WhatsApp messages or whether all other things are also amounting to the information that is there in electronic communication. What does our MHA SOP says about this? Because the second thing that I have highlighted in front of you is the MHA has issued SOP about how we are supposed to do EFIR. If you also observe the first thing that I have highlighted, it also very categorically says that either you can do it through the portal, or you can basically do it through the way in which any other communication which will be accepted. So my dear friends, any other communication matlab hai that it is going to open up a lot of things for us. I agree with that entire idea also, that yes, we should open up other things, but how are we going to document it will become extremely important. Who is keeping a watch on it and how we are documenting it will automatically become important. ये तो हो गया इलेक्ट्रॉनिक कम्युनिकेशन क्या है. अब सेकंड पॉइंट आता है करना क्या है उसके बाद. What am I supposed to do? And this was also something which has already been lot of times been discussed. Yesterday sir has also expressed a very clear cut opinion on this, that should I wait for 3 days for receiving his signature and then basically start doing the documentation, or then basically do this entire thing, or basically I just do it immediately. Now if you plainly read it, it actually means that you should wait for 3 days. It just a plain reading is means कि आप उसका इंतजार कीजिए 3 दिन का, 3 दिन के बाद आ जाए तो उसके बाद उसको एक्सेप्ट कीजिए और आगे चलिए. अब इसमें हमारे, because for us nothing is exactly same, nothing exactly works like same. So for us, what exactly am I supposed to do in the 3 days becomes the next important question. How am I documenting it for those 3 days becomes the second important question. So the fact remains that we understand broadly the law that has come in is one aspect. How are we now progressing towards implementation of this becomes the second major challenge that we all have. And for that, we need to understand what all we require to formulate. And I'm also going to be showing you what some states have already done. So this is once again the MHA's SOP about EFIR, and which very categorically says what we all agree कि भाई 3 दिन तक हमें वेट करना है. 3 दिन तक वेट करने के बाद जब उसका साइन हो जाएगा तब हम उसके बाद हम FIR करेंगे. अब उसमें लेकिन सबसे बड़ा इशू आता है कि 3 दिन तक क्या करें. हमारे पास एक क्लियर कट इन्फॉर्मेशन है कि किसी ने हमें फोन करके बताया कि उसके घर में चोरी हुई है. उसको कैसे पता चला उसके घर में चोरी हुई है? उसको किसी और ने बताया कि उसके घर में चोरी हुई है. वो हमारे पास आ जाकर यहाँ कंप्लेंट दे रहा है. कंप्लेंट देने के बाद उसने हमें ईमेल कर दिया है. Email theoretically is electronic communication. So now does that mean I wait for that person to come to me after 3 days and then basically do the action, or should I go there and verify? If I go there and verify, what will I do for 3 days if I find that there is actually a theft happening? So the fact remains for us, every situation is new. Logic says कि अगर आप वहां गए, आपको लगा कि there is a commission of a cognizable offense, you will do a suo motu FIR, irrespective of waiting for that person to come for us in 3 days. We will have to formulate SOPs. Sooner or later हमें एक SOP बनानी ही पड़ेगी कि 3 दिन तक हमें क्या करना है. उस वेरिफिकेशन का कुछ करना है या फिर छोड़ देना है. क्या किस टाइप ऑफ केसेस पे एक्ट करना है, किस टाइप ऑफ केसेस लाइक चीटिंग केसेस है जिसमें हो सकता है हमें उसको ध्यान देने की भी जरूरत नहीं है, पर किस टाइप ऑफ केसेस के बारे में हमें इमीडिएट एक्शन चाहिए, किस टाइप ऑफ केसेस के बारे में हमें इमीडिएट एक्शंस नहीं चाहिए. So all those documentations we will have to basically understand and basically document it. And if we are doing any sort of action on the field, please try to understand that all actions should ideally be protected by BNSS, and the entire focus of what we are doing there starts with FIR. So we should not just be very headlong or very strong in our saying कि नहीं जब 3 दिन के बाद ही करने वाले हैं हम FIR. Logic also says that if information is there, if you yourself come to know that there is a cognizable offense that have happened, you should initiate action, and that action means FIR. So that is something about the two broad aspects of it. This is just understanding. It's not about, it's what I have gathered from a lot of things कि कहाँ entry करने चाहिए. आपके पास EFIR आए तो आप उसको entry करेंगे कहाँ, information आई तो entry कहाँ करेंगे, उसके लिए क्या करेंगे, उसकी report कैसे बनेगी, suo motu FIR करेंगे कि नहीं करेंगे. So all sorts of these questions need to be answered by your particular SOPs, whichever you are going to be now formulating. third issue, which is about preliminary inquiry. Now, preliminary inquiry is the most loved point. Sir has also very elaborately explained to you what exactly preliminary inquiry means. And if you read it also, you can make a sense of it. But this is something that, like arrest 41A को हम अभी तक अलग-अलग connotation से समझते आए हैं, उसी तरह से preliminary inquiry को भी हम अलग-अलग connotation से समझते हैं. Basic understanding about preliminary inquiry is that preliminary inquiry does not mean checking the veracity of the complaint. वो सही है या गलत है चेक करना is not the focus of preliminary inquiry. Preliminary inquiry means you have to establish whether there exists a prima facie case or not. What does that mean? That means the information that has been told to you, does it disclose cognizable offense? And the answer is always going to be a yes or a no. It can never be pata nahi. If it is a yes, if it discloses a cognizable offense, if it discloses a prima facie case, there is no question of preliminary inquiry whatsoever. The issue कि वो 3 साल का है, 7 साल का है, किसका परमिशन चाहिए, वो आता ही नहीं है. सिंपल लॉजिक है, अगर वो डिस्क्लोज करता है एक प्राइमा फेसिया केस है, अगर हमें एक लड़की आके बोलती है कि यहाँ फलाना फलाना जगह मेरे साथ छेड़खानी की गई है इस पर्टिकुलर टाइम में इस पर्टिकुलर लोकेशन पे, this is a clear cut information that is given to you which discloses molestation. Now whether molestation is in 3 to 7 years, whether I should do preliminary inquiry or not is not a question here at all. You basically have to go ahead, register an FIR. If you find she is saying false, close it and then prosecute her. But the fact remains that this is a clarity that majority of our lower rung staff doesn't has. ये एक unnecessary नहीं है, हमें धीरे धीरे वो maturity आएगी हमारे अंदर समझने की कि क्या मतलब है इस चीज का. हम इसको बहुत जल्दी और बहुत बार कंफ्यूज करते हैं ललिता कुमारी के साथ. ललिता कुमारी ने भी एग्जैक्टली यही बोला था. ललिता कुमारी ये नहीं बोलती है कि हर मैट्रिमोनियल केस में आप जाकर प्रिलिमिनरी इंक्वायरी कीजिए. उसने बोला प्रिलिमिनरी इंक्वायरी कर सकते हैं, मे बी डन. एग्जैक्टली अभी भी यही बोला गया है कि यू मे बी डूइंग इट. So the fact is, you do not exactly go about dropping it or basically breaking it down into very, very small things which cannot be understood. अभी अंडरस्टैंडिंग इज फाइनल. अगर आपके पास इंफॉर्मेशन है विच डिस्क्लोजेस कॉग्निसेबल ऑफेंस, हम एफआईआर करते हैं. अगर हमारे पास जो भी इंफॉर्मेशन आई जिस डज नॉट डिस्क्लोजेस कॉग्निसेबल ऑफेंस, यानी कि उसमें हमें समझ में नहीं आ रहा है कि प्राइमा फेसी केस है कि नहीं है, उसके इंग्रेडिएंट्स जो है वो हमारे, अब इंग्रेडिएंट्स आते कहां से, इंग्रेडिएंट्स आर कमिंग फ्रॉम आईपीसी एंड स्पेशल लॉज. उसका इंग्रेडिएंट होगा तभी हो सकता है. हमारे पास फॉर एग्जांपल मैं आपको एक एग्जांपल देती हूँ कि एक पर्सन आता है और वो बोलता है कि मेरा लैपटॉप नहीं मिल रहा है सुबह से. अब इसमें दो ऑप्शन हो सकते हैं, या तो उसने लैपटॉप खो दिया या उसका लैपटॉप चोरी हो गया. खोना इज नॉट एन ऑफेंस, चोरी होना इज एन ऑफेंस. हम तभी पिक्चर में आते हैं जब चोरी हुआ है. हम आईपीसी का जो भी प्रावधान है जो भी लगाना है तभी पिक्चर में आते हैं when there is something which is an offense which is described under IPC. So first thing is, whether does it discloses an offense, does it discloses an information about a prima facie case, and that is the understanding of preliminary inquiry. Now we come to the second subset of this preliminary inquiry, which is what exactly BNSS talks about preliminary inquiry. BNSS ने ये कहा है कि अगर आपके पास preliminary inquiry, आपको preliminary inquiry करनी है, then you have to fulfill 3 obligations. The first obligations is वो 3 से 7 साल की punishment वाला होना चाहिए. उसमें आपको अपने DSP की permission चाहिए और आपको 14 दिन का time दिया गया है. It is different from Lalita Kumari. Lalita Kumari talks about 7 days. Lalita Kumari talks about different types of cases. उसमें एक अलग categorization of cases है. यहाँ ऐसा कुछ भी नहीं है. यहाँ उन्होंने एक बड़ा सा basket बनाया, 3 से 7 साल वाला एक basket बनाया और उसमें बोला कि 3 से 7 साल है आप कर दीजिए, पर आपको उसमें prior permission of DSP चाहिए और 14 दिन के अंदर आपको एक conclusion चाहिए कि what do we want to do about it. So basically the fact is we have to understand that you will have to make a judgment call when you are doing entirely and going into this idea of preliminary inquiry. First, does it warrant preliminary inquiry? Is it fitting into prima facie cases or not? Second, if you decide to go into it, is it fulfilling these criterias or not? And in this also, how are you implementing these criteria? What is your checks and balances? How have you taken the permission of the DSP? Is there a separate register for taking it? If there is a separate register for taking it, have you documented it? What are the reasons regarding the doing a preliminary inquiry? How many time frame has been allocated to the person who is doing that preliminary inquiry? So these are the checks and balances which every state will now have to sit down and formulate its own SOPs about how do you do the documentation part of this preliminary inquiry. Conceptually, we understand it. We have to make our juniors understand it. But broadly, as senior officers, you have to also implement it and understand that it should not be misused. Once again, everybody's concept, our constabulary's concept, our man on the ground's concept is preliminary inquiry का मतलब है veracity verify करना, चेक करना कि सच बोल रहा है कि झूठ बोल रहा है. ऐसे फालतू में हम केसेस नहीं करेंगे, हम फॉल्स केसेस बिल्कुल भी नहीं करेंगे. तो प्लीज ट्राई टू अंडरस्टैंड, अगर वो फॉल्स केस नहीं करना था तो इसके यहाँ वर्डिंग्स चेंज होनी चाहिए थी, या वर्डिंग्स प्राइमा फेसे केस नहीं हो सकता, यहाँ डायरेक्टली हमें डालना चाहिए था टू एग्जिस्ट द वेरासिटी ऑफ द केस. अब जब यहाँ आ गया है वर्डिंग्स एज प्राइमा फेसे केस, तो प्राइमा फेसे केस का यही मतलब है दैट यू नीड टू बेसिकली वेरीफाई वेदर देयर इज द इंफॉर्मेशन डिस्क्लोजेस अ कॉग्निसेबल ऑफेंस और नॉट. ये सारा कलेक्शन ऑफ इंफॉर्मेशन आप बाद में करेंगे. एक बड़ा इशू इन सब चीजों के अंदर है कि प्रिलिमिनरी इंक्वायरी करते हुए आपके पास क्या पावर्स है. क्या आप किसी को पुलिस स्टेशन बुला सकते हैं? क्या आप उसको किस तरह से डॉक्यूमेंट कर सकते हैं? क्या आप उसकी स्टेटमेंट लेंगे? नाउ ऑल दीज आर नो वे डॉक्यूमेंटेड एनीवेयर, बिकॉज इफ यू ऑब्जर्व ऑल दीज आर अराइजिंग फ्रॉम सीआरपीसी, एंड व्हेन इट अराइजेस फ्रॉम सीआरपीसी ऑब्लिक बीएनएसएस, इट अराइजेस पोस्ट इन्वेस्टिगेशन, पोस्ट इनिशिएशन ऑफ इन्वेस्टिगेशन, दैट इज एफआईआर. अभी एफआईआर हुई नहीं है, ये सारा प्रोसेस हमारा पहले का है. अब जो सारा प्रोसेस पहले का है वो हमें ही डॉक्यूमेंट करना पड़ेगा. वी विल ओनली बी ऑब्लाइज्ड to document of how exactly are we going to develop this SOPs, of what exactly is the power of your personnel on the field who is conducting a preliminary inquiry. Can he basically summon a person? Can he basically ask them to produce documentation? What exactly is his rights? Because tomorrow, sooner or later, this also will eventually be challenged, and then we do need to understand that how are we documenting that entire process. There is another angle to it, which is as if now a very legally debatable angle. Now that legally debatable angle is about what does this 3 to 7 years means. Why am I reflecting and giving you this point is, this is just an interpretation of one facet of Supreme Court, because Supreme Court in one case in 2020 came up with this idea that if you blindly say that it is 3 to 7 years, what do you mean by 3 to 7 years? Is the minimum punishment 3 to 7 years? Is the minimum punishment 3 years? Is the minimum punishment 7 years? और इसका मिनिमम पनिशमेंट कुछ भी नहीं हो सकता है, या फिर 3 साल का मतलब मैक्सिमम पनिशमेंट है? एग्जैक्टली इसका मतलब क्या है इस पूरे 3 से 7 साल का जो अभी हमारे सामने दिख रहा है? व्हाट डज इट एग्जैक्टली मीन्स? So in this particular case, what had happened was, if you observe and if you remember the JJ Act also basically defines and breaks down the cases depending upon the offenses. It is petty offense, serious offense, heinous offense, और उसने उसको criteria define कर रखा है. 3 साल maximum minimum punishment है, less than 7 years minimum punishment है. तो उस particular प्रावधान के लिए इन्होंने ये declare किया था कि आप ये जो 3 साल मान के चलते हैं, 3 साल का ये मतलब नहीं होता है कि वो मैक्सिमम पनिशमेंट और मिनिमम पनिशमेंट इज नॉट प्रिस्क्राइब्ड. इट आइडियली वुड अमाउंट टू बी सेइंग दैट यू आर सेइंग दैट 3 years will be the minimum punishment as per what this particular judgment says. And because of this particular judgment, the amendment also came in JJ Act in 2021 post this judgment, which clarified the entire thing that it doesn't mean and we should not be restricted by the minimum punishment. So this is still matter in sub judice. अभी ब्रॉडली हमारे समझने के लिए जो एक आम आदमी को समझ में आता है, जो ब्रॉड ज्यूरिस्प्रूडेंस ये है कि मैक्सिमम पनिशमेंट 3 से 7 साल की होती है, क्योंकि आईपीसी में है ही नहीं प्रावधान जिसमें हर जगह मिनिमम पनिशमेंट दिया हो. पूरी आईपीसी में कुल मिलाकर 3 ही प्रावधान है जिसमें मिनिमम पनिशमेंट दिया हुआ है और मैक्सिमम पनिशमेंट 7 years के बीच में. क्या सिर्फ इसी में हम प्रिलिमिनरी इंक्वायरी कर सकते हैं? The answer is obviously no. That is not what the the people behind the law also meant. So sooner or later, this is going to get clarified in the Supreme Court. That does it mean that 3 years is the baseline or minimum punishment prescribed? The answer most probably is going to be no, because that is not what the intentions of the lawmaker was. And the intention of them lawmakers was to make their implementation, but this is also going to become a matter which will sooner or later be coming into our discussions. नेक्स्ट वी कम टू दिस इंटायर एस्पेक्ट ऑफ प्राइवेट कंप्लेन. प्राइवेट कंप्लेन को हमारा वर्ड है प्राइवेट कंप्लेन. बेसिकली आप सबको पता है कि अगर हमने किसी की कंप्लेंट नहीं ली तो क्या उसके पास एक रिलीफ है? कैन ही डायरेक्टली अप्रोच द कोर्ट? So the answer to all this was actually yes, he can directly file. Anybody can file a complaint. Complaint is what? It is an allegation made orally or in writing in front of the magistrate. Now this is the original definition of complaint as per the law. So in this case that means कि अगर एक cognizable offense का कोई complaint है जो मेरे पास आई है, जो मुझे ideally FIR दर्ज करना चाहिए, पर मैंने FIR दर्ज नहीं की, तो क्या मैं उसको डायरेक्टली जाकर कोर्ट में दे सकती हूँ? आंसर इज यस, मैं उसको डायरेक्टली जाकर कोर्ट में भी दे सकती हूँ. एंड सिंस मैं उसको जाकर डायरेक्टली कोर्ट में देती हूँ, कोर्ट भी उसका अपना कोर्ट कैन डायरेक्टली टेक कॉग्निजेंस और कैन रिफर इट फॉर इन्वेस्टिगेशन टू द पुलिस. What change has come now in here in BNSS? The only very simplistic change that has come is now they have made a small changes of only, failing which, दो तीन वर्ड इधर उधर हुए. पर इसका मतलब ये है कि अगर कॉग्निसेबल ऑफेंस है तो सबसे पहले किसी भी कंप्लेनेंट को पुलिस स्टेशन आना पड़ेगा. अगर पुलिस स्टेशन में एक्शन नहीं लिया गया तो उसको एसपी के पास जाना पड़ेगा, और जब एसपी ने भी उस पर एक्शन नहीं लिया तब वो जाकर डायरेक्टली मैजिस्ट्रेट को दे सकता है. That is what the change that has come. So what is going to be its implication to us, all of us? What is the change that is going to be happening to us? The change what is happening to us is they will have to produce the evidence that they have approached police. And the typical evidence, like we maintain visitor receipt, visitor registers, some sort of a things where they will take a receipt of out of which, and where the demand also will now come that you please give us a receipt of visit. एसपी साहब से मिलने गए लेकिन वो मिले नहीं या जो भी हुआ, पर उसके बाद कार्रवाई नहीं हुई. And since there was no action after meeting SP also, now they can definitely go and basically submit themselves or basically present their grievance to the magistrate, and that is what all has been brought in. Broadly, that are the basic changes about how the changes have been brought in, what will be the implementation aspects of finally doing it. Non-cognizable offenses, you also know that there is nothing major change that has happened. Only thing is now they need to basically also have a list, or basically we need to submit a GD fortnightly report of the entries of such cases in the to them also. So that is something where GD का extract निकालकर हमें उनको भेजना है. कैसे भेजना है, कहाँ भेजना है, वो थोड़ा सा भी हमारे लिए difficulties होंगी initially, but I think very simple introductions into CCTNS will improve and will lead to the benefit of that also. It can very easily be done technologically, but how will it eventually happen has to be done individually by all the states. Now we come to the part of other aspects of investigation. अब तो हो गया, FIR भी हो गई है, अब हमें सीन पे भी पहुंच गए. सीन पे पहुंचने के बाद यहाँ दो ही चेंजेस हुए हैं मेजरली, जो आपको सर ने कल भी बताया. I'm just for the sake of repeating only telling you. More than 7 years, we do have now an obligation of inviting a forensic expert. So forensic expert will have to be there on the ground regarding any offense which is more than 7 years. Now this forensic expert, and do we have some time limit and time gap? Yes, actually the law itself is giving us 5 years to implement it. The law ही हमें खुद 5 साल दे रहा है कि आप 5 साल के अंदर अपनी capabilities बना लीजिए. क्योंकि अब हमें capabilities क्यों चाहिए? ये इसीलिए चाहिए कि सबसे पहले अभी हमें क्लैरिटी चाहिए कि फोरेंसिक एक्सपर्ट है कौन. Who is this expert? Is this the expert which is defined under 45 of Indian Evidence Act or 39 of new BSA? Who is this person and what is his credibility? What is his criteria? Is he the member of our forensic cadre, or is he a private person whom we have hired? So a lot of hiring has happened in all FSLs across the country. But if you observe the way the hiring is happening, they're majorly taking it on contract basis. So once they're taking it on contract basis, who is this forensic expert who is basically going there? And there are certain logistic things, there are certain conceptual things that we have to understand when we are doing and incorporating this forensic expert. आज के प्रेजेंट प्रावधान में, पुराना CRPC में जाकर सीन से जो भी कुछ उठाना होता, कौन उठाता है? Who basically picks up the evidence from the crime scene? The answer is categorically IO. It is IO who is going to be picking it up, because IO की बाद में सील लगती है, उसी की सील के साथ आगे उसका प्रोसेस होता है. अभी हमने एक प्रोविजन डाला है जिसमें forensic expert is going to be visiting and collecting the samples. Now we have basically added on the collection of samples to the forensic expert. So now once he is collecting it, he will be the person who will be sealing it. And if he is not sealing it, what is his vis-a-vis role to the IO? उसकी क्लैरिटी हम सबको अब चाहिए कि इस आयोग का क्या काम रहेगा और इसका क्या काम रहेगा, उठाएगा कौन, सील कौन करेगा, डॉक्यूमेंट कैसे करेंगे, और जब डॉक्यूमेंट करेंगे will he be cited as a witness? What has happened and already happened in southern states is they have started doing this already. They were already doing it, and in some of the states they were also cited as a proper witness. So he is the person who is doing it, taking it, but in certain states he is only assisting the IO. He's there to do it, but he is on the name of it basically assisting the IO. So that clarity will eventually have to come to us कि हमें उसका status क्या है, Panchanama या whatever name you call it about the documentation of the scene of the crime, how does that exactly happens is something that we will have to now understand, write it and document it. What are the vis-a-vis role of these people in the entire way of our documentation. इसके अलावा जब हम लेडी, वहाँ कोई लेडी है या फिर कोई रेप विक्टिम है और रेप विक्टिम का भी हम अगर स्टेटमेंट ले रहे हैं, तो अगर आपने पहले सर ने भी बताया पॉक्सो का जो भी था, पॉक्सो के जनरली जो भी हम बच्चों के लिए करते थे वो सेम पार्ट हमने उसको एक्सेप्ट कर लिया है into the entire aspect of sexual assault also, ideally done by a woman, done on the places of her choice or her residence preferably, and in the presence of people whom she is comfortable with, ideally should be recorded. No, it is may be recorded by audio video means. Please remember, in BNSS every statement is may be recorded, every search and seizure is shall be recorded. जो भी हमने कुछ उठाया है उसको पक्का ऑडियो वीडियो रिकॉर्ड करना है, जो भी हमें बता रहे हैं, हमसे बता रहे, हमें उसको रिकॉर्डिंग कर रहे हैं, हम उसको नोट डाउन कर रहे हैं, स्टेटमेंट हो रहा है कहीं भी, सब जगह में लिखा हुआ है. Obviously we have dedicated a major part of that today also to understand कि how are we going to be documenting that also. इसके अलावा मेडिकल एग्जामिनेशन बहुत सिंपल है कि अब हमें उसको मेडिकल एग्जामिनेशन की रिपोर्ट हमारे पास आ जानी चाहिए 7 दिन के अंदर. पहले था एज सून एज पॉसिबल, अब हमारे पास है जल्द से जल्द आना चाहिए, एज सून एज पॉसिबल जल्द से जल्द की जगह पे आ गया 7 दिन. ऑब्वियसली जल्द से जल्द का मतलब था बहुत जल्दी भी आ जाए हमारे पास, लेकिन वो आता नहीं है हमारे पास एक टाइम. देयर वाज ऑलवेज दिस एंटायर फोकस ऑन अस दैट वी वर नॉट गेटिंग दिस इंफॉर्मेशन वेल इन टाइम. Since we are not getting well in time, there was this entire thing that we should basically be adopting, we should basically be putting a timeline. If you observe, BNSS is full of timeline. Now we need to come down to SOPs of how to implement the timeline and what will be the administrative responsibilities of implementing the timeline. So that will obviously become the focus of it now. लड़की की स्टेटमेंट ले ली हमने, हम उसके घर गए, एक वुमेन ऑफिसर ने उसकी स्टेटमेंट ले ली, हमने मेडिकल कराया, मेडिकल कराने के बाद 7 दिन के अंदर हमारी रिपोर्ट आ गई, और लास्ट पार्ट होता है हमारे पास मजिस्ट्रेट के पास जाकर उसकी स्टेटमेंट लेना. सो इन तीनों प्रावधानों में चेंज हुआ है. हमें उसकी स्टेटमेंट कैसे लेनी है, लड़की रेप विक्टिम की स्टेटमेंट कैसे लेनी है, किसने लेनी है, कहाँ लेनी है, में चेंज है. हमने जाकर उसका मेडिकल कराया, हमें रिपोर्ट कब मिलेगी, में भी चेंज है. और लास्ट चेंज है बेसिकली अबाउट हाउ द मैजिस्ट्रेट इज रिकॉर्डिंग, या क्या एक महिला मैजिस्ट्रेट ही होनी चाहिए जब उनकी स्टेटमेंट रिकॉर्ड की जा रही है 164 में. ये पहले एक जजमेंट भी थी, इफ यू ऑब्जर्व देयर वाज अ जजमेंट शिवना वर्सेस स्टेट ऑफ कर्नाटका, एंड बेस्ड ऑन इट दैट क्लैरिटी सुप्रीम कोर्ट हैड ऑलरेडी गिवन टू अस. नाउ सुप्रीम कोर्ट रादर देन जस्ट टेकिंग अ क्लैरिटी हैज फाइनली एक्सेप्टेड इट इन टोटो. And once it is accepted in toto, it basically means कि अब हमारे पास, obviously there is the onus of responsibility on the court कि जहाँ तक possible है lady magistrate होनी चाहिए for recording 164. I'll just repeat it briefly. Regarding cases of rape, the idea is that we have some small modifications have happened. Where do we record the statement of the victim? Where she wishes to. Who records the statement of the victim? Preferably a woman officer. How the statement is recorded and who should be presented in her whenever she is basically recording the statement. There also changes have happened that it should be ideally, but may be recorded with audio video means, and the person whom she has trust with should be present when the statement is getting recorded. After that, we are typically sending her for medical examination. There also one change has come in which now the doctor has to give us report within 7 days. After that, the next step is always recording of her statement in front of the magistrate, and that also basically the change has been incorporated, that should also be done preferably by a woman magistrate. If the woman magistrate is not present, then obviously it can be done by other male magistrate in the presence of female also. So both provisions have been incorporated. Now that was about what women and related to rape cases were there. Now if you observe, the other part of the thing is also something that is very unique for us, very important for us, and that part was about the fact that we sometimes want 164 statement to be recorded of people, of witnesses whom we think tomorrow may turn hostile, where we send a request to the magistrate for recording of their statements. Theoretically, is it permissible or was permissible under 164? The categorical answer is yes, it was permissible. Although the title was confession of the accused, it actually permitted us or permitted them to basically accept a request, accept written or make written statements also. Here also now one change has happened, that the word shall has been incorporated in the erstwhile 164/183. इसका मतलब क्या है? If police presents a witness in an offense which is punishable with more than 10 years, यानी कि cases of rape, cases of murder, any other such serious cases, then the magistrate shall record the statement. So now there is a clear-cut obligation on the magistrate to record the statement of the witnesses if the police presents the witness in front of the magistrate. So this is going to ease a lot of our thing, in which there was always a conflict of interest or a conflict of understanding between us and the magistracy. So that is one thing that has been changed or added. Apart from that, there is one simple change that has happened. I'll also be covering this victim-oriented things a little later. But one basic significant change that has come in is that we basically are now or incorporating changes in which we are informing the victim at every point of time. Now this template, what you see is the template of CCTNS. CCTNS proposes to basically incorporate the numbers and information of complainants at all stages. If you observe, in all forms, IFF1, that is FIR, crime detail, arrest, अपना property seizure, final form. तो वो ये logic को क्यों अप्ला रहे हैं? Because now basically, if you observe, either we give the charge sheet, that change has come in the section of the charge sheet, in which either I should at the end, that was always there, चार्जशीट होते वक्त हमें इंटीमेट करना था कंप्लेनेंट को, ये पहले से था हमारे सीआरपीसी प्रावधान में, पहले से था कि हमें उसको इन्फॉर्मेशन देनी है। अब टिपिकली आप चार्जशीट कब करते हैं? हमारे पास डिफॉल्ट बेल के हिसाब से हम 90 दिन के अंदर चार्जशीट करते हैं। अगर हमने 90 दिन के अंदर तक चार्जशीट नहीं किए तो इसका ऑटोमेटिक मतलब क्या है? अब हमारे पास एक ऑब्लिगेशन है कि या तो आप चार्जशीट कर दीजिए, अगर आप चार्जशीट नहीं कर रहे हैं तो आपको इन्फॉर्मेशन देनी पड़ेगी विक्टिम को अबाउट द प्रोग्रेस ऑफ द इन्वेस्टिगेशन। They have created that entire information template. CCTNS creates that template, which we can also be utilizing it about how we are intimating it to the victim. Second and the most important part of today's presentation was about the conceptual idea, or a typical very small mock drill which we wanted to show you about was search proceedings, and how do we basically do a recording of search. Why should we do a recording of search? Once again, the same point, new things have been cropped on our 105 and 185 CRPC, which basically says that we should and shall be doing an audio video recording of the searches and seizures that we are doing in either of the provisions. Yes, that also says, and one of the provisions that is in 185 also says that we need to be intimating it within certain period of time. Either way, we are supposed to intimate it now to the, not just intimate, send a copy of it also to the magistrate. तो पहला point, रिकॉर्ड करना है, ऑडियो वीडियो रिकॉर्ड करना है, कुछ भी उठाते वक्त, कुछ भी सीज कर रहे हैं, उसको कहीं भी डॉक्यूमेंटेशन पे ला रहे हैं, उस समय हमें इसको ऑडियो वीडियो रिकॉर्ड करना है। क्या उसका रिकॉर्ड की कॉपी देनी है ऊपर मैजिस्ट्रेट को? द आंसर इज अ कैटेगोरिकल यस। हमें उसके आंसर से भी उस ऊपर हमें उसका इंफॉर्मेशन देनी है। उसको करते वक्त हमारे पास बाय एंड लार्ज ये दो तरीके के ऑप्शंस होते हैं। हमारे पास एक वीडियो कैमरा होता है, हमारे पास एक मोबाइल कैमरा भी होता है, हम दोनों तरीके से उसको कर सकते हैं, जिसमें हर जगह आपने अगर ऑब्जर्व किया हो लिखा हुआ है प्रेफरेबली बाय अ मोबाइल फोन। So अब जब हम उसको कर रहे हैं और हम मोबाइल फोन वाला भी एक्सपेक्ट आपको एक्सप्लेन करेंगे, as my information also goes that e-Saksha app has been implemented by Jammu Kashmir Police also. So apart from the e-Saksha app, what we have tried to develop and try to focus initially is on the typical aspect of audio video recording using a video camera. And that is where we are now going to be explaining you the process. Some of you have already had attended our previous sessions also, where we had briefly taken you on. This time we have made a presentation in which we are taking you through the exact steps, and with which I will actually now formally invite Parmesh to join us and take over, so that you can basically show them your screen of how basically we are also doing that entire process.
Sure, ma'am. Ma'am, are you able to see my screen?
Yes, it's visible, Parmesh.
Yes, ma'am. So good afternoon, everyone. So now I'll be discussing about the audio video recording part, where I'll be covering the technical parts that are involved here. So to begin with, I'll be first discussing the kind of evidences which we'll be carrying. So majorly, whenever we record any kind of crime scene using camera, we have two storage devices which we will be carrying with us. One, as you see in the screen, we have SD card. SD card can be a micro SD card if you're using mobile phone kind of devices, or if you use a standard camera kind of devices, you use a normal SD card. So SD cards will be one of the places where we store the audio video recording. And another storage media. So for the memory card, we will be using a card reader for reading this memory card also. So every forensic kit should have this card reader and will have a card reader. So it should not be an issue reading any of the memory card which we have. And the second kind of storage media which we will be using while this whole exercise is evidence container. Okay, so these are the two storage media. One is the memory card which we'll be using in camera, which stores the audio video recording, and the second storage media is what you're trying to see, what you're seeing in the screen, which is a pen drive. So why we are using a pen drive is after we record the video, we are supposed to make a copy. So to store that copy or to store the image which we create out of that uh, memory card, to store that we will be using a separate pen drive. So we refer this device as an evidence container. So there are overall two storage media which we will be using here in case of audio video recording process. So before I proceed further, roughly these are the two storage media we'll be using. So before I proceed further, I would like to discuss about quickly about this concept called as write blocker. So I hope most of you know about write blocker, but I will quickly give a rough. I'll quickly give an introduction to what write blocker is and what it does. So basically, let us take an example. I have a pen drive. Let us say this is a pen drive I have seized at the crime scene. So if in order to connect, if I want to connect this pen drive to any computer, I should use a write blocker, a device called as write blocker. So what does a write blocker does basically is, if this is the storage media which I have seized from the crime scene. So this write blocker which you are seeing in the screen will prevent my evidence, my storage media which I've seized from the crime scene from getting tampered. So it will prevent any kind of files to getting copied into this pen drive. Okay. So overall, if you technically talk, write blocker basically what it does is it blocks all kind of write operations. So what do I mean by write operations is, let us say, if I want to copy any file in this pen drive, or if I want to create any file in this pen drive, or simply if I want to open this pen drive, some kind of write operations will happen. So this write blocker device will prevent all such kind of write operations. So basically, it will this write blocker will block the storage media from any kind of tampering. So that is the reason we will be using this. So write blockers come in different formats. The one which you're seeing on the screen, it supports memory card as well as write blockers. For hard disk, you also have slightly bigger kind of write blockers, which is not a part of this class, but for our agenda, this is how write blocker generally looks like. So when do we use write blocker is a question. Basically, just to answer this question, why and when do we use? So why we use, just to prevent tampering on the storage media, we use write blocker. When do we use write blocker is, let us say this is a pen drive which I have collected from the crime scene, or if this pen drive or this storage media has any kind of evidence. So if I want to make a copy of this pen drive, that is, if I want to make a forensic copy, I have to use a write blocker. If I want to take a hash value, in that case also I have to use a write blocker. Or in case if I simply want to check what is there inside this pen drive, okay, in that case also I have to use the write blocker. Yeah, about the hash value part, I'll be covering. Just give a minute. Let me first cover about the write blocker. So whenever you connect any storage media which has a potential evidence, okay, even though if you want to check whether what is there inside that pen drive, we will be using write blocker. Okay. After we record audio video inside the memory card, we have to write block our memory card because it has evidence there. Now, before we proceed, now I hope this should give a clear understanding about what is write blocker. It basically helps our storage media from getting tampered. How our storage media can get tampered is by any kind of write operations. If you copy something, if you create something into the pen drive which is there, so all these write operations if you block, then that means we are not tampering our evidence. Okay. Even if you directly connect this pen drive without write blocker, even open the file and close it, that will also make changes inside the pen drive that we will be seeing with a small example case scenario we'll be discussing in the coming slides. So with this, we will proceed to the next concept, which is nothing but wiping. Okay. Now, the two storage media which I have discussed previously, these are the two storage media. One is the memory card, which we will be using in the camera while we record. And the second storage media which we are discussing is the pen drive, where we are trying to copy the image of the memory card. So this basically this pen drive we are using to make a copy, and this is the pen drive we are supposed to give it to the magistrate, judicial magistrate. So what is wiping? So basically every storage media which we will be using where we copy our evidence. So the camera in the memory card which we are using, that is the place where evidence is getting stored, and the pen drive which we have discussed is another place where we are making a copy. So we are making a copy of the evidence, so that is also considered as one of the storage media. So every storage media which we will be using where we will be copying our evidence, it should be made sterile. Okay. In computer world, how we make sterile is by the process called as wiping. Now, why we are performing wiping is, let us say this is a pen drive in which I want to copy any kind of evidence. I have to make sure that this pen drive does not contain any kind of data within this pen drive. There should be no kind of data. Suppose I have this pen drive, I have used it previously, I have added some videos, photographs, my Aadhaar card, or any such things, any such files. If I use the same pen drive, I quickly format this pen drive and use it directly. Tomorrow, if someone tries to perform any forensic activity on this pen drive, those files which I had previously will also be recovered while doing the forensic activity. So just to be safer from those kind of things, it is recommended that we have to perform the process called as wiping. Now, simply we can also delete the active files which are there. Instead of performing the process of wiping, let us say I have few files, I can simply delete those files and format it, and then I can use it. But still, even if you delete or format, we can able to recover those files. Okay. In computer world, we need to remember one thing: we don't have any concept called as deletion. Okay, there is no concept called as deletion. When you delete a file, it is only the index page. In the index page, it is marked as deleted, but the file will be still present in the location when we in the location where we have saved. And forensically, if we try to retrieve it, we can retrieve the same file. So both deletion and formatting will not work on the new pen drive where we are trying to store evidence. We have to perform the concept called as wiping. So just to explain what is wiping in a simple word, let us say I have this pen drive of 4 GB. Now, if I copy a 4 GB pen file inside this pen drive, let us say I have my Aadhaar card, my PAN card, and some video files which are my personal video files. And this is a pen drive of capacity 4 GB. So tomorrow I take a 4 GB file, and if I try to copy the entire 4 GB file in this pen drive, what this will do is this will overwrite my previous data, which are my photographs or Aadhaar card or some video files which are there. So because the data is overwritten with a new file, I cannot retrieve that older data. So in computer world, what we do is if you want to make sure that previous data should not be recovered, I will be just overwriting that data with another data. Okay. So that process is nothing but that process is called as wiping. Okay. But when we forensically wipe, when we forensically perform a wiping process, we override every single character, every single bit in this pen drive with 0 character. Okay. So when we overwrite every single bit, we are performing basically the wiping process. When we overwrite with zeros, it becomes a sterile media. So there is no active bit. So there is no one which is there inside this pen drive. There is no bit one which is there in this pen drive. So when we overwrite with complete zeros, we consider this pen drive as a sterile media. And whenever we try to use this any pen drive or any storage media, we need to first perform this process of wiping by overwriting with zeros and make it sterile, and then we have to use this pen drive for collection of evidence. Now there is also another part where, let us say I have performed the process of wiping, and this is the pen drive which where I'm trying to collect, and tomorrow I say this is perfectly wiped. So how do we prove? We also have a mechanism where we try to take the checksum value of this pen drive, and when the checksum value becomes 0, when we take the checksum value of this pen drive, if the checksum value comes as 0, that means that refers to that this pen drive is completely sterile. So now I will explain you both the process of performing wiping, which is forensical wiping, as well as how do we take the checksum of this pen drive now in the demo. So I hope my screen is visible now. Yes, sir. So what we will do is basically I have a pen drive. I have connected a pen drive to my local system. So to perform the process of wiping, I am using a tool called as WinHex. So to perform the process of wiping, I am using a tool called as WinHex. So once I load the WinHex, so this part which I am doing, this part should be done in the IO system. So this is not supposed to be done at the crime scene or using the accused or suspect system. Now, after I load WinHex, I come to this option called as Tools, and I click on option called as Open Disk. So in WinHex, I click on Tools and I click on Open Disk. So first of all, what I'll do is I will open the disk and I have to select the media which I want to sterilize. So here I want to sterilize this pen drive. Now there are two categories here which you need to remember. You can always remember the meaning of these two things. Whenever we perform ahead, the way ahead when we also see the same things, which is logical drive and physical drive. So what does these two means? Let us say you have a hard disk of 500 GB capacity, and you have C drive, E drive, and F drive. So if I want to work on any particular partition, then I have to select under logical media or logical drive. Let us say I have a pen drive of 16 GB capacity. Then if I want to perform any operation on the entire 16 GB, then I will be selecting under physical media. All right. So whenever I want to perform anything under physical media, that means I'm accessing the entire pen drive. So under physical media, I will select the pen drive and I'll click on OK. So this will load because I've already loaded my pen drive. It is saying it is already loaded. So this will load the pen drive in WinHex. So on the left side of the screen, if you see, we get to know the name of the pen drive, the make, model, and the capacity. Now you have to, whenever you try to perform wiping, you have to make sure that you check these details, or else a lot of times you might make a mistake and accidentally, instead of selecting your pen drive, if you select your local hard disk and you perform the process of wiping, then you might lose your data, and it will not even, you will not even forensically retrieve that data. So you have to make sure that whatever the drive which you are selecting, it is the drive it is the pen drive which you are trying to wipe. So once we load the pen drive in WinHex, so basically this is how it looks. The next step is we will try to override or perform the process of wiping. So to perform process of wiping, we come to this option called as edit, and we come to this option called as fill disk sectors. Okay. Once we load the pen drive in WinHex, we come to process called as edit, and we click on fill disk sectors. Okay. So click on edit, and we will click on fill disk sectors, and this will give a pop-up. And here we say with which values I have to override, which values I want to override. As I said, when we override with complete zeros, we consider that as a sterile media. So here we are giving the character 0 with which we are trying to override. And what is this pass is, it is a number of iterations. So I want to override the entire pen drive with zeros for one single time. So I will click on OK, and it will ask a few details. I will click OK, and I will click OK the next time. And this will start the process of wiping. Okay, this basically starts the process of wiping, and it based on the amount of storage you have, 16 GB or 32 GB or 64 GB memory card which we are using, it will take 15 to 20 minutes, or if it is slightly higher capacity storage device, then it will take some more time. So basically this process, once this process completes, so I'll stop this because I have previously wiped this pen drive already. So I'll close this process. So after the completion, this is how our pen drive looks. So every single bit, if you see, I am just scrolling down and trying to see the content of the pen drive. So this is basically nothing but the content of the pen drive. So when I scroll, you can see all the characters in this pen drive are overwritten with zeros. Okay, so that means there is no single data which is there. There is no single information that is there in this pen drive. So even if I use this pen drive now, tomorrow someone whimsically tries to retrieve any deleted data, they'll not be able to get any of the deleted data from this pen drive. Okay, so this is how we do the process of wiping. It's very simple. Use WinHex, connect the pen drive to your system, go to tools, click on open disk, select the pen drive, and load the pen drive into the WinHex application. Then once it is loaded, go to the option called as edit and click on fill disk sectors. And while you select this, you get a pop-up which says what are the characters with which you overwrite. There we select the character 0, click OK, and we proceed to the next steps, and that will continue the process of wiping. After it gets finished, all the characters in the pen drive will be overwritten with zeros. So this is the simple uh, process of wiping. There is no, I don't think there is no much complexity involved here in the process of performing wiping. Now, let us say this wiping process you can do anytime, you can do beforehand before you visit any crime scene. But the next step, which is how do you prove that whether a given pen drive is perfectly wiped or whether a given pen drive is perfectly sterile. So we use the process called as checksum. So if this pen drive, I have performed wiping on this pen drive, so uh, I have to check the checksum of this pen drive. So if the checksum value comes as 0, then that means this pen drive is perfectly sterile. Okay, if the checksum value comes as some non-zero value, then that means there is some sort of data here. So we should show this checksum value to the panchas who are there at the crime scene, just to tell them that this is a perfectly wiped pen drive and there is no data present in this pen drive. So how do we take the checksum? Again, let me just rewind the process again from the first. So again, we will use a tool called as WinHex to take the checksum. Click on Tools, click on Open Disk, and we will select the pen drive under Physical Media. This is the same process we have done for wiping also. And for taking the checksum also, it is same. So first, we will load the pen drive within the application of WinHex. So once the pen drive is loaded in WinHex, we will go to this option called as Edit, and we'll go to the option called as Tools, and we'll click on the option called as Compute Hash. Okay, so to take the checksum, we'll go to Tools, and we'll click on the option called as Compute Hash, and we will select under this drop down. You can select either checksum 8-bit or 16-bit, and we click OK. It is very simple. You can see I clicked on Tools, I clicked on Compute Hash, I selected a checksum, and this will give me this value. So now the checksum has come as 0. So this means this pen drive which I have used is completely sterile media. Okay. So the pen drive which I have used completely sterile because the output of the checksum is 0. There is no active bit or there is no data in this pen drive. So this part you have to, you can mention in your statement, and you can show the same thing to your panchas. So these are the two things which we do before we capture any evidence in our storage media. So now this wiping process we are doing for both memory card as well as the pen drive. Okay, the memory card where we are recording the audio video and storing it, and the pen drive where we are storing the evidence, that is an image copy. So we'll wipe both the storage media and take the checksum value of the pen drive or the memory card. Now once this is completed, when we have the pen drive or the memory card, let us talk about memory card first. You are supposed to, so these are the tools which we use to wipe. For wiping, we use WinHex. There is a free software called as Eraser, and we also have a free application called as HXT. So these are the three applications which we use to take the wiping, and also to take the checksum value. So these are the three applications which are available. Now, once we wipe the memory card, we are supposed to, this is a process of wiping. We are supposed to format the pen drive. Just to tell you, this is the storage media which looks before wiping. If you see on the screen, this is how the data within the pen drive looks like, and after wiping, this is how the data looks like. There is no data within this application within this pen drive. Okay. Before we have data, after wiping, we don't have any data. So this is how the output looks like. Now we also have to take checksum. As I said, these are the steps for checksum which I have included in the PPT. We take checksum and the checksum value will come as 0. Now after we perform the process of wiping, let's say I have a memory card, I connect in pen drive, I connect it to the camera, or I have a pen drive. After wiping, I connect it to the computer. Computer will directly not read this pen drive. Okay, we have to first format it before we use a pen drive which is wiped. I have to format this. Okay, how do we format? We format we right click on any the device, the normal formatting which we do, and here, yeah, we will share the PPT after this session. Here you have to understand one thing, that when you try to format any pen drive, you need to remember one thing. Generally, we right click on some pen drive, we format it with a quick format, but we have to understand one thing here, which will not create you problem ahead. Is if you select at 32 file system in the file system part which we are seeing here, the file system part here, we also have a part called as here. We also have a file system which is FAT32. So the disadvantage of FAT32 file system is it supports a maximum file size of 4 GB. So if you create a file which is more than 4 GB, then FAT32 file system will not support. So that is the reason you have to select either NTFS file system, which is we are seeing on the screen, or you can select exFAT file system. So exFAT file system is supported in cameras, as also it is supported within computers also. So it is recommended you go with the exFAT formatting. So that is the reason I have included here, just to tell you, you don't make a mistake of selecting FAT32 whenever you use a memory card or a pen drive after performing wiping. Try to format it either with NTFS or exFAT. If it is a memory card, make sure you format it in exFAT format. Okay. Now we insert the pen drive. We insert the memory card within the camera. Okay. After formatting, we then record the crime scene, whatever the activity which is there. We do the recording using our camera. And once the recording is completed, now we have performed wiping, we have took the checksum, we have performed formatting, and now what we are doing is we recorded the video at the crime scene. After we record, we perform the process called as hashing. So to perform hashing, as I said, let us say once you take the memory card from the camera, you should not connect that memory card to any computer directly. Okay, we have to use a device called as write blocker. So we have to use write blocker because now this memory card has evidence. So when we have evidence, we do not connect these storage media directly to any computer device. So we have to use write blockers before we connect it to any computer. Even if you try to open the memory card and you want to see the content of the pen drive, you should not connect it directly. Even to see the content also, you have to use write blocker and connect it to your computer. Okay. So now we have to connect it with the write blocker. And let us see how we take a hash value. Now here, I will show an example with a single file. How do we take the hash value of a file? So to take a hash value, here I will be discussing two ways. One is how to take the hash value of a file. Suppose we have a video file, how do we take the hash value of that single file? And in the second step, we'll also see how do we take the hash value of the entire drive or the entire memory card. Okay. So first, to begin with, we will use the application named hash calculator. So this is the application which we are using. Hash calculator or hash calc. This is the application which we will be using. Let us say I have a file let us say I have this file, I want to take the hash value of this file. Or let us say you have a video file. The process is very, very simple. Just drag the file of which you want to take the hash value and drop it in the uh, hash calculator application. It is very simple. You just take the file, drag and drop. Here you should see the hash values of this file. So we have to take these two hash values into consideration. Always note down two hash values, which is MD5 and SHA-1. So we are taking the hash value here of the video which we have recorded in the camera. Okay, so that memory card which is there in the camera, we have connected to our computer system using a write blocker. Okay, and after we connect it with the write blocker, we are taking the hash value of that video file using this application called as hash calculator, and we are noting these two hash values of that video file. Okay, this is how simple it is to take the hash value of a file. Now we'll also see how do we take the hash value of the entire drive. So to take the hash value of the entire drive, again, the memory card which we have connected, it will be connected with the write blocker. Okay. Now we will be using an application named FTK Imager to take the hash value of the entire memory card. I'll open this application. Okay, this is FTK Imager. So FTK Imager and hash calculator are free applications which we can use to take hash values. Again, the hash value part we are doing in our computer, or we are doing in IO's computer. Now, once we open FTK Imager, click on File, click on Add Evidence Item. Okay, click on File, click on Add Evidence Item, and as we have discussed earlier, we are trying to take the hash value of the entire memory card or the entire pen drive. So we have to select under physical media. If you are selecting under anything under logical media, that means we are selecting anything which is a partition of the entire hard disk. So we'll select the physical drive, click next, and here in the drop down, we should always make sure that we select the right storage media. By default, here we see that it is selected as physical drive 0, which is nothing but the local hard disk which is present in my laptop. So I have to select, and I have to click on the drop down and select the pen drive of which I want to take the hash value. In this case, I am having a pen drive, but we are supposed to take the hash value of the memory card. And I'll click on finish. So this will load my pen drive. This will load the memory card in FTK Imager. Now, once the memory card is loaded in FTK Imager, I simply will see a physical drive number mentioned here. If it is physical drive 0, then we are doing wrong. If we see physical drive 0, that means we are doing anything on my local hard disk. So you should get either physical drive 1 or 2 if we are trying to access on memory card. So I will simply right click on this physical drive part, and I simply click on verify drive image. So this is how simple again is to take the hash value of a drive. You connect the pen drive memory card to the computer using a write blocker, open FTK Imager, click on add evidence item, select the memory card. Once it is selected, you load it. Once the memory card is loaded, you right click on the physical drive 1 and you click on verify drive image. So this will start taking the hash value of the entire memory card. Okay. So if you, we are supposed to take the hash value of both video files separately, and it is recommended to take the hash value of the entire pen drive also. Okay, this will help you while cross questioning, even if there is slight mistake in handling this this memory card. Also, these two hash values will help you. If there is slight tampering, if there is slight tampering accidentally which happened on memory card, still you will have the hash value of a file which is we have taken with the hash calculator. So it is recommended or it is advisable to you to take the hash value of both file as well as the entire drive. Okay, so let this process get complete. So we'll come back to the presentation. So we have taken the hash value of the file using the hashcalc application, hashcalc application. So how do we take? We open hash calculator. This is how it looks. We simply drag the file or load the file in the hash calculator, and this will give you the hash values of the file. So we will note both MD5 and SHA-1. Again, I'm repeating, we have to take both MD5 and SHA-1 hash values. Then how do we take the hash value of the entire pen drive or the entire memory card? Yes, we use the application called as FTK Imager. Once we load the FTK Imager, we click on Add Evidence Item by clicking on File. When we click Add Evidence Item, and we have to select physical drive here. Once it is loaded, once we select the right storage media, physical drive 1 is loaded. We right click there and click on Verify Drive Image. So after the process gets completed, we should see a hash value like this. So this is the hash value of the entire pen drive. Okay, this is the hash value of the entire pen drive. Now, till now we have seen the process of wiping, process of taking checksum, formatting. How do we take a hash value of a single file? How do we take the hash value of the entire drive? So now once we take the hash value, we will try to make a copy of the memory card which we are trying to access. Okay, we will try to take the hash. We try to take the image, the forensic copy of the memory card. So to take the forensic copy, we will see whether this process is completed. Yes, now as you can see, I have taken the hash value of my entire memory card. So this is how you get the hash values. We need to record this. We need to note down these two hash values, which is MD5 and SHA-1. So this is how we take the hash value of the disk. Now I will remove this media. Now to take image copy of memory card also, we will be using the same application, which is FTK Imager. Okay, now we are trying to make a forensic copy of the memory card, which we are taking out from the camera. Again, to take the image or to make a forensic copy of the memory card also, you need to connect that memory card using a write blocker to any system. So once we connect that memory card using the write blocker to any system, how do we take? Now here the pen drive which we earlier used will come into picture. Now the memory card we will be using as a source, and the destination where we will store this image copy will be the pen drive which we earlier wiped. As we discussed earlier, we are using two storage media. One is a memory card where we are recording and storing the video, and the second one is the pen drive where we are copying this entire video of the memory card and storing it in the pen drive. So this is where the pen drive will come into picture. So we will connect both the devices. Memory card is connected with the write blocker, and the pen drive is connected without write blocker. You have to remember this. Memory card is connected with the write blocker, and the pen drive is connected without write blocker. Now, for my demo, I will try to take the forensic copy in my local system, but you are supposed to store that in the pen drive. So I click on File to make a forensic copy, which is to make a image. I click on Create Disk Image, File, Disk Image. Okay, I have to select the source. What is the source? The source is the memory card. I'll select the physical drive. I click Next. So let us say I select the memory card here. I click Finish. So source will be the memory card. So that we have selected now. Now will be the destination. So destination, I am selecting my local computer. So I click on Add, and here you add FTK Imager will ask you to select the kind of format which you want to store. Simply I'll explain. If you select RAW /DD, this means that you don't want any kind of compression on your image. That means if you have 100 GB storage as source, the output will be a 100 GB file. If you have selecting the rest of the three, if you have a 100 GB source file, the output will be around 60 to 70 GB of image file. So these three will help you in these three will allow you to create the image file with the facility of compression, whereas DD will not allow you to compress. But we recommend you to perform the imaging using DD because this will help you. This will help you in analysis, where all the forensic tools will try to analyze this raw or DD format. So we'll click next. We enter the case details. This is memory card. Examiner name Parmesh Nayak. So I'll enter these things. These are the things which you will be seeing in the final report after we perform imaging. FTK imager will generate report. Sorry, FTK imager will generate a report. These details will be reflected there. We click next and we select the destination. For now, I am selecting desktop as the place where I am storing this. But when you actually select, you are supposed to select this destination as the pen drive which we have wiped. Okay.
Network issue. I think we have lost Parmesh for some time. But I'll just basically
Hello?
we'll finish the question.
Yeah.
Parmesh, you're back.
Is it fine now?
Yeah. Your voice is heard. You're just
So,
not visible.
Okay.
Yeah, it's there. It's
Is it
there.
fine now, ma'am?
Yes, it's fine. Please continue.
Yeah. So once we select the destination, source I can just by clicking here. So once I click start, the process of imaging will continue. So again, it will take some time. So I'll continue with my presentation, what we do basically in case of imaging. So while we perform imaging, we are using FTK imager. So we load FTK imager, we connect both source, which is memory card, destination is our pen drive, we connect both the things. The memory card we are connecting using a write blocker. The pen drive which we will connect directly to our system. We click on create disk image in FTK imager. Select physical drive. Select the source, which is nothing but our pen drive. Then these are the formats I've explained you. Click on add and give the destination. Give the details. And here, after entering the output where this is supposed to store, give your file name and click on finish. And you click on start. This is how the imaging process will start. After it gets completed, you see the output like this, what you're seeing on the screen. Okay, again, taking the image is very, very simple. Now here, I quickly will explain the difference between what is imaging and what is cloning. So when both imaging and cloning, both are forensic way of copying. Okay, both are bit by bit copy, imaging and cloning. Now the major difference comes is when we perform something called as imaging, we call it as disk to file. That means if I have a 500 GB hard disk and I perform a process of imaging on this hard disk of 500 GB, the output will be a 500 GB file. Okay, output will be a file which will be similar to your entire hard disk. Okay, this is what happens in case of imaging. So when I clone any media, what happens is, if I have a 500 GB hard disk, the output will be also another 500 GB hard disk. So the cloning part, we call it as disk to disk, and that is a reason if you use any hardware based disk duplicators or disk imaging devices, hardware based disk duplicators, you don't see the concept called as imaging or cloning. You see disk to file or disk to image. So these two nothing but this refers to imaging and cloning. Okay, in this part we have seen how do we image. So taking image is a better option because this will not tamper the content of the image file even though you do not use the right. Okay, so if you quickly see the entire process, we have the memory card and the pen drive where we are trying to store evidence. We wipe it with zeros and we make it sterile. To check whether a given memory card is sterile, we check the checksum. If the checksum is zero, that means we call it as a sterile media, which indicates that there is no active data that is there in memory card. Now, after we sterile it, we format it and we insert it in the memory card. We record the video. After we record, we take the hash value of a file using hash calculator, and we take the hash value of the entire memory card using FTK imager. And next, we do an image copy to give a copy to a judicial magistrate. To do that, we use FTK imager to perform imaging. So to perform imaging, what we do is we connect the source and destination. Again, using FTK imager, we try to image, and finally we get an image copy within the pen drive which we are using. So, so that's it from my side. Should I take questions?
Yes, Parmeshi, there are just 2-3 questions regarding the same our steps. I'll just read it out to you and then we can just answer them one by one. First question was that if we record video through an eSaksha app, then there is no need for using a pen drive. You are right in that point of view that if you either have to use the eSaksha app, and I'm going to be describing the eSaksha app also now subsequently. So I'll further explain the eSaksha app point also to you. If it is either or, but you should always obviously know how to do an audio video recording from a video camera also, and that was the entire objective of telling this. One question is there that making an image of any storage media using FTK imager by IO cannot be produced in court of law, which is not admissible as the IO is not a forensic expert under BSA. So sir, for answering your question, basically if you read 185, if you read 106, it says that any copies of any record made during the search has to be communicated to the concerned magistrate. So that means copies of any record made. So we have already made an electronic record and the copies of that will have to be given. Now, whether that will be given and whether that will finally become admitted is not a question. हमारा जो copy हमारे पास original है वही बाद में जाकर admit होगा जब हम उसको charge sheet के time attach करेंगे. उसमें कोई doubt नहीं है. क्यों इसका यूज होगा? इसका टिपिकल यूज हमें डिस्क्रेडिट करने के लिए होगा कि जो हमने सबमिट किया उसका हैश कुछ और है और जो वहां कोर्ट में सबमिट हुआ उसका हैश कुछ और है. सिंस उन दोनों का हैश कुछ और है, इसका मतलब है कि हमने चेंज कर दिया है इमेज. हम जो रिकॉर्डिंग कर रहे थे वो कुछ और है और जो गया है वो कुछ और है. इसीलिए हम हैशिंग का प्रोसेस कर रहे हैं, इसीलिए हम वो हैश रिकॉर्ड कर रहे हैं और इसीलिए जब हम कॉपी कर रहे हैं हम इमेज करने की कोशिश कर रहे हैं, एक फॉरेंसिक कॉपी बनाने की कोशिश कर रहे हैं, यानी कि सिंपल कंट्रोल सी कंट्रोल भी करने की कोशिश नहीं कर रहे हैं. सो दैट इज द आंसर टू योर क्वेश्चन दैट वी हैव टू सबमिट अ कॉपी टू द मैजिस्ट्रेट. That copy will be used to discredit us only in the later or in the future when we are submitting a final charge sheet, because the question will come, what exactly have you recorded and is this the same copy of it? That is why, to tell you a standard operating procedure of it, we have explained you the process of imaging and cloning. Both of them appear to be the same, but they are different. And what has been explained to you in detail is the process of imaging. क्लोनिंग करेंगे तो एक और मेमोरी कार्ड ही हो जाएगा उसके साथ. हम लोग उसको एक छोटे पेन ड्राइव में करेंगे और उसको बाद में सबमिट करेंगे. हाँ, ये बहुत चैलेंजिंग है प्रैक्टिकली ये सुनने में इजी लगता है, करने में बहुत मुश्किल है. ऐसे तो बहुत सारे पेन ड्राइव्स ही हो जाएंगी, बहुत सारे नए चीजें हमें उसको इम्प्लीमेंट करना पड़ेगा. सो yes, there are challenges in the implementation of it, but this is what it exactly means. And there is one question only. After recording write blocking, do we need to generate hash value and include 53 subclause 4 certificate before sending it to magistrate? So your question basically is, you are saying that we are recording it, we are recording the hash value of it, and when we are recording the hash value of it, when we are transmitting it to the magistrate, do you require to submit a 65B/63 BSA a certificate? I will advise you, yes, we should do it. And why we will advise you, it is a subsequent part of my presentation when I am also coming and touching that aspect also. I'll answer your question there also, ma'am. As per the new laws, all IOs have to record the crime scene through eSaksha app, but at the same time, FSL expert have also been made mandatory for recording of the scene of the crime. Then what is the need of recording by eSaksha app? So, sir, if you read that entire section, it basically says that it is a responsibility of the SHO to record it, and it is a responsibility of the SHO to get a forensic expert. Now, it is our onus of responsibility is now being rested onto us to basically record it. That is what the plain reading of it means. If we are we using eSaksha for this? Yes. Can we use a simple video camera? Yes. We have explained to you the video camera part. We'll also explain you now the eSaksha part of it. But broadly, with Parvesh ji being here, broadly this is the broad idea of what we were trying to explain to you is like this. Whenever we are doing any sort of a video recording, whenever we are doing any sort of a idea is कि उसको सबसे पहले साफ करना है, उसके लिए हम वाइपिंग करते हैं. वाइपिंग करने क्या हम वाइपिंग सीन पे करेंगे? Answer is no need. You can actually wipe it at the back end and then basically bring a clean thing. But you will have to show the checksum in front of the in front of the panchas, and it need to be recorded in the panchnama. Checksum 0 था, क्यों ये हमारा दिखाने के लिए जरूरी है? ये दिखाने के लिए इसलिए जरूरी है क्योंकि हमारे ऊपर एक ऑब्जर्वेशन आएगा कि हमने इसको टैम्पर किया है, इसके अंदर ऑलरेडी कोई मैलवेयर था, हमें कैसे पता है कि इसके अंदर ऑलरेडी आपने रिकॉर्ड नहीं किया था. So all these sort of defense questions comes. To prevent these defense questions, we have to categorically clean whatever you are trying to record on it. For that, you have to do wiping. To prove you have done wiping, you are doing a checksum verification. Can immediately after that, and will you be using write blocker for that? The answer is no, because if you are doing write blocker, then how can you write and how can you wipe it? So that is not going to be used there. Don't confuse write blockers here. पहले तो हम उसको साफ करेंगे, साफ करने के बाद चेक करेंगे कि हाँ ये बिल्कुल साफ हो चुका है, उनको पंचास को दिखा देंगे कि हमने इसको चेक किया है, और चेक करने के बाद जब हम अब इसको अभी इम्प्लीमेंट करेंगे, जब हम उसको दोबारा से नेक्स्ट स्टेप करेंगे, वो एक और स्टेप है फॉर्मेटिंग, जो अभी परमेश जी ने भी बताया कि अब हमें इसको फॉर्मेट करना पड़ेगा. फॉर्मेट करने के बाद हम इसको अब यूज करेंगे, सब रिकॉर्ड करेंगे. रिकॉर्ड करने के बाद फर्स्ट स्टेप इज हैशिंग, which is very simple, what Parvesh ji has just showed us. Usme there is this entire typical idea that who exactly are you hashing? Are you hashing the file or are you hashing the drive? The idea remains, you will always try to first hash the file, because वो hash होता क्या है? वो आपका signature है. आपका signature है या आपका as a family एक identity है, जो family identity है वो आपकी drive हो जाती है. जो सिग्नेचर है आपका ओरिजिनल यूनिक सिग्नेचर है, वो आपका खुद का सिग्नेचर है, वो उस फाइल का सिग्नेचर है. तो हम पहले उसका हैश लेते हैं. हम उस ड्राइव का हैश क्यों लेना चाहते हैं? क्योंकि ड्राइव में कुछ और भी समथिंग होता है, which he has very clearly explained, which is the metadata. So once metadata is also getting stored, every time you are opening and closing, the metadata is changing. So once the metadata keeps on changing at all point of time, you have to understand hashing of the single file is different, hashing of the drive is different. यानी कि जो भी आपके पास है वो अगर आपके पास पेन ड्राइव है उस पूरे को हैश करना है क्या? पूरे को भी हैश कर सकते हैं, करना चाहिए आइडियली, लेकिन that is just for your own precaution. Most important is hashing of that file, यानी कि हमें पता लग गया कि इसको किसी ने टैम्पर नहीं किया है. वंस इसको किसी ने टैम्पर नहीं किया, क्या हम उसको अब यूज कर सकते हैं? हाँ, डेफिनेटली अब हम उसको यूज कर सकते हैं टू अंडरस्टैंड कि अब नेक्स्ट स्टेप पे जा सकते हैं कि हमने ले लिया, वीडियो रिकॉर्डिंग भी कर ली, इसकी हैशिंग भी कर ली. अब हैशिंग के बाद जो नेक्स्ट स्टेप क्या होगा? लॉजिकली व्हाट विल बी द नेक्स्ट स्टेप? हमें उसको एक कॉपी बना के रखना है. क्यों कॉपी बनाने की जरूरत है? हमें मैजिस्ट्रेट को भेजनी है, इसलिए हमें उसकी कॉपी बनानी है. और वो कॉपी क्या सिंपल कंट्रोल भी होता है? आंसर इज नो. वो सिंपल कंट्रोल भी नहीं है, वो इमेजिंग का प्रोसेस है. वो इमेजिंग का प्रोसेस भी हमने आपको अभी एक्सप्लेन करने की कोशिश की. We have actually tried to explain you all the tidbits of it. They may appear technologically very advanced, they may appear to be very theoretical ideas, but they are very simplistic in logic. And the logic is also derived from the fact that whatever we are recording, we want to use it tomorrow as evidence. And since we want to use it tomorrow as evidence, we are trying to maintain its its strength, we are trying to maintain its veracity ki theek hai kisi ne tamper nahi kiya hai. There should not be any allegations of tamper coming in. So that is why we are doing that entire 4-5 steps. We have also created this documentation, and I'm sharing that documentation in the group also, and I'll later on, I've also uploaded it in the drive also. You are free to use it. E-Sakshi app, I will briefly explain to you right now about what the E-Sakshi app is. It's not just about the state of Jammu Kashmir, because I think you're already using it and you're quite advanced in its use, but it is about generically about in general ideas also, that what exactly is E-Sakshi app and how we are utilizing it is what we are going to be touching. Is there any other question regarding the process? Sir has asked, are our judges technically literate to know what hash is? We are expecting them to become literate, sir, like we are becoming literate. So hopefully they'll also become literate. So with that, I think we will move to my remaining presentation, where I'll just finish off the other salient features of the implementation of BNSS. Thank you, Parmesh ji, for joining and for taking that session. Like Parmesh ji has very clearly told us, हम वीडियो कैमरा का यूज भी कर सकते हैं, और वीडियो कैमरा के यूज में ये बहुत ही सिंप्लीफाइड स्टेप्स है जो हम उसको यूज कर सकते हैं. क्या हम मोबाइल फोन को यूज कर सकते हैं? बिल्कुल करना है, बिकॉज हमारे हर जगह जहां जहां आपने इसको देखा है वहां वर्ड यूज हो गया प्रेफरेबली यूज अ मोबाइल फोन. Now we have to understand, when we are preferably using a mobile phone, what exactly is happening, what exactly is getting recorded, how it is getting recorded. Try to understand that BSA has come, and yesterday we had a very elaborate discussions on BSA कि कहाँ जाकर वो सेव हो रहा है. तो मोस्ट इंपॉर्टेंट यही रहता है कि इज इट एन ओरिजिनल कॉपी, इज इट अ साइमल्टेनियस कॉपी, इज इट अ सीक्वेंशियल कॉपी. क्या जब वो बन रहा है वो उधर ही जाकर रुका हुआ है, या फिर उसके अलावा वो कहीं और जाकर भी रुका हुआ है. तो दिस ये हम जहां भी वो जाकर रहता है, यानी कि द ओरिजिनल पार्ट ऑफ इट इज कॉल्ड प्राइमरी एविडेंस. उसके साथ उसका जितना भी कॉपी बनेगी, दैट विल ऑटोमेटिकली बिकम सेकेंडरी एविडेंस फॉर अस. So that is where we always have to remember that just really taking your phone and recording something will not exactly become the fulfilling the entire responsibilities of BSA, because उस समय आपके फोन की मेमोरी के अंदर गया है ओरिजिनल कॉपी. यानी कि जब आपके फोन के मेमोरी के अंदर गया है ओरिजिनल कॉपी, तो अर्जुन पंडित राव के हिसाब से प्राइमरी एविडेंस इज योर फोन. If primary evidence is your phone, that means primary evidence is the best evidence rule says that the primary evidence only has to be produced. That automatically means आपका phone आपको produce करना पड़ेगा. So the implementation of this doesn't mean that we should just take up our phone and started recording on it. Obviously phone के अंदर भी हम अलग से memory card डाल सकते हैं, या फिर हम ऐप जो आया है हमारे पास ई-साक्ष्य ऐप है उसका यूज कर सकते हैं. ई-साक्ष्य ऐप के बारे में आप सबको ऑलरेडी बाय एंड लार्ज पता है, जिस स्पेसिफिकली जम्मू कश्मीर पुलिस को, बट फॉर द इंफॉर्मेशन ऑफ एवरीबडी, ई-साक्ष्य ऐप इज बीइंग डेवलप्ड बाय एनआईसी. And once e-Sakshi app has been developed by NIC, they have created a format of how they are onboarding the people who can deposit and can basically put that evidence into the e-Sakshi app. तो e-Sakshi app में आप रिकॉर्ड करते हैं एविडेंस, और वो एविडेंस स्टोर भी होता है. Going back to the original idea of primary evidence and secondary evidence, अगर कोई भी चीज क्लाउड में स्टोर हुई तो उसका प्राइमरी एविडेंस क्या हुआ? क्लाउड. क्या क्लाउड को मैं प्रोड्यूस कर सकती हूँ कल को कोर्ट में? द आंसर इज नो. सो उसमें कैटेगोरिकली आई एम सेफ दैट आई नीड नॉट प्रोड्यूस द प्राइमरी एविडेंस एवरी टाइम. आई एम ऑलवेज गोइंग टू गिव अ कॉपी, एंड दैट इज द एग्जैक्ट एडवांटेज ऑफ एनी ऐप, और स्पेसिफिकली द ई-साक्ष्य ऐप दैट हैज बीन डेवलप्ड टू यूज दैट थिंग. सो इन ई-साक्ष्य ऐप there is a process of onboarding it. If you see, there is a user creation module. After the user creation module, that there is a writer module, there is a viewer module. उसके बाद there is this very elaborate, you can download it, आप सेवा से download कर सकते हैं. I'll just briefly take you through it. It has its own level of authentication. Authentication होना चाहिए, उसका एक MPIN generate होना चाहिए, यानी कि पहले तो वो आपको authenticate करेंगे, उसके बाद आपके device को authenticate करेंगे. Both of them do require authentication, because that is where you have to understand that there are these checks and balances that have been inbuilt. Have you tried to tamper it? See, the biggest importance of using information technology is information technology keeps on moving here and there. So at every point of transmission, there is a possibility of interception. So that is where this entire thing goes, that can everything be hacked? The answer typically is yes, everything can be hacked, because information is going from one point to another. And whenever it is going from one point to another, we need to authenticate where the information is flowing, which has been inbuilt in this app. अपार्ट फ्रॉम दैट थिंग, ये आपका ये आपको ऑथेंटिकेट करने के बाद आपकी ऑथेंटिकेशन भी वेरीफाई करता है. And when it is, yes, you're right, sir, it is not available on iOS. It is only available. The Android version is only has been launched, and then it also has to be basically authenticated. And this, it's not there, so we can't do anything much about it. NIC only will have to do it. उसको करने के बाद जब हम उसमें जाते हैं अंदर, the very simple functionalities है उसकी functionalities में एक नया साक्ष्य का ऑप्शन आता है. नए साक्ष्य के ऑप्शन में आपको जाना है, खोलना है, वो आपको ऑप्शन देगा आपको क्या रिकॉर्ड करना है. वंस आप उसको जब रिकॉर्ड करने जाएंगे तो आपके पास ऑटोमेटिकली ऑप्शन आ जाएगा कि आप उसमें क्या करेंगे. आप वीडियो कैप्चर करेंगे क्या, तो आप वीडियो कैप्चर करने का बटन ऑन करेंगे. वीडियो कैप्चर करने के बाद आप जब वीडियो हो जाएगी, उसके खत्म हो जाएगी आपकी वीडियो, इसमें देयर इज अ 4 minute टाइम फ्रेम दैट हैज बीन गिवन, दैट ओनली 4 minutes is being possible in one particular video. Why also the logic raised? Because the information has to go, it depends on its load, and since the load is as if now being fractured to 4 minutes only, obviously they are working towards increasing that also, but as if now it's 4 minutes. ठीक है, वीडियो बना लिया हमने जगह का सीजर का वीडियो बनाना था. वीडियो बनाने के बाद हमने सीजर में किया क्या, हमने सीज किया. Since we have seized something, we have to basically document the seizure process also, and finally take a final picture of that seizure. क्या क्या उठाया मैंने, ये बुक उठाई, ये पेन उठाया, वो सब का जो हमने फाइनल सीजर लिया उसकी एक सीजर फोटो खींचनी है. सीजर फोटो खींचने के बाद हमें सबसे ज्यादा इंपॉर्टेंट किसकी फोटो रहेगी, हमारे पंजा की, क्योंकि हमेशा वही हॉस्टाइल हो जाते हैं कि हम तो गए ही नहीं थे सीजर करते हुए. तो उसमें एक इनकॉर्पोरेशन करना है कि हमें विटनेस की फोटो लेनी है, और फाइनली हमें आपकी फोटो लेनी है, द पर्सन हु इज बेसिकली डूइंग दैट एंटायर वीडियोग्राफी, द पुलिसमैन हु इज देयर. And here then comes the point of syncing it to the database. And once you're syncing it to the database, the entire this Sakshi goes and sits in that locker that has been created by the NGED, where the entire server system is being created to basically save your video. क्या ये automatically ICGS में जाएगी? That is the objective of this entire process, कि हमें अब कॉपी भी ना देना पड़े. हमने इतना elaborate process अभी सीखा, imaging करना पड़ेगा, कॉपी देना पड़ेगा. Things, technology should make our lives easy. So to make our life more easy is the entire idea of trying to develop this entire app. It is still, and the new versions are coming. I believe you're already using the 3rd version of it. So very soon all these functionalities will eventually come to the entire documentation portion, where we will try to ease it out for us. देखिए, रिकॉर्डिंग करनी है मैंडेटरी है, हाँ करनी है. उसकी कॉपी देनी है मैंडेटरी है, हाँ देनी है. जब हम उसको कॉपी करते हैं, क्या हमें उसका इंटेग्रिटी को प्रिजर्व करना है, हाँ करना है. जैसे अभी हमने क्या बात की थी, हैश का क्या, हैशिंग यहाँ हो रही है क्या, यहाँ इनबिल्ट हैशिंग हो रही है. इनबिल्ट हैशिंग होकर उसी समय हर एक छोटा 4 मिनट का जो आपका वीडियो बना उसका एक SID क्रिएट हो रहा है और उसकी एक हैशिंग भी हो रही है. सो इट इज ऑलरेडी गेटिंग डन एज अ मेजॉरिटी ऑफ द लेवल इन e-Saksha app. What will be the challenges and how the challenges are going to be factored now is the second question. BSA comes into the picture, where one of the questions also was asked कि हमें 63 सर्टिफिकेट देना है कि नहीं देना है. कल ये बहुत elaborately सर ने बहुत अच्छे से explain किया है. I'll once again explain to you very simply. These two are the crux of it. These two are basically trying to incorporate that any kind of a digital record which is created simultaneously or sequentially will be accepted as primary evidence. How does e-Saksha app creates? e-Saksha app is sequentially creating it. There is an inbuilt mechanism, कहीं जाता नहीं है, directly sequentially वो बाद में जा रहा है हमारे server में. Will that now be considered as primary evidence? That is the entire idea of it. That should be considered now as primary evidence, and that is what we are looking at in explanation 4. Anything which is done sequentially or simultaneously will be considered as an evidence for all of us. That will be considered evidence as primary evidence. हमें अब उसको produce करने की जरूरत ही नहीं है. These all are also explanations that have been added. पर by and large 63 क्या बोलता है? Same बोलता है कि आप एक certificate बनाओ. जो 63 सब क्लास 4 का सर्टिफिकेट है वो हमें अभी भी बनाना पड़ेगा. वो सर्टिफिकेट जब हम बना रहे हैं उसका क्या मतलब है? सेम लॉजिक विच वाज देयर फॉर 65B. क्या मतलब है? कॉपी बना रहे हैं और कॉपी दे रहे हैं, इसीलिए आपको उसका एक सर्टिफिकेट की जरूरत है। क्या हमें वो सर्टिफिकेट की, क्या आप जब एक आप में से किसी का क्वेश्चन था कि जब हम एक कॉपी भेज रहे हैं मैजिस्ट्रेट को, तो क्या हम 65B का सर्टिफिकेट देंगे? The answer is yes, is what my understanding says, that since you are doing a copy of it, it automatically means you will eventually do it. Is the copy, क्या ये सर्टिफिकेट ई साक्ष्य ऐप में बन रहा है? हाँ, उसमें भी ऑटोमेटिकली बन रहा है हमारे लिए और ऑटोमेटिकली ट्रांसमिट भी हो रहा है. That is one step ahead, that or it is automatically transmitting also. But your question also is very clear and very right, sir, that are we experts in that? The answer here is also the biggest elephant in the room. The elephant in the room is there are two forms which have been given to us. Form number one is for the party, which is me and you, who's creating it right now. Form number B is basically for an expert. अब ये एक्सपर्ट को कहां से लाना है, ये एक्सपर्ट कौन है, इज द $1 billion क्वेश्चन हियर, दैट हु एग्जैक्टली इज दिस एक्सपर्ट हियर इन दिस. सो बेसिक आइडिया अबाउट BSA ऑब्लिक इंडियन एविडेंस एक्ट पे अगर हम जाते हैं तो हम वापस जा रहे हैं 45 की डेफिनेशन पे कि एनीबडी हु हैज सम नॉलेज और व्हिच द कोर्ट वांट्स टू बिलीव दैट ही हैज सफिशिएंट अंडरस्टैंडिंग इनटू द सब्जेक्ट मैटर कैन बिकम एन एक्सपर्ट. क्या आप और मैं भी एक्सपर्ट बन सकते हैं उसके हिसाब से? थ्योरेटिकली हाँ, पर क्या हम साइबर एक्सपर्ट बन सकते हैं? द आंसर विल बी नो. व्हाई इट इज नो? बिकॉज 39 also says, the new law, that it does not, is not applicable for electronic evidence. If it is not applicable for electronic evidence, what is applicable for electronic evidence? 79 is applicable. अब 79 में क्या है? हमारा वो ट्रिपल ई है, एग्जामिनर ऑफ इलेक्ट्रॉनिक एविडेंस. वो कौन है? वो तो सिर्फ सर्टिफाइड लेबोरेटरीज है. And if you also observe, these are not exactly people, they are laboratories who have been certified by MAITI in that considered sense. So like DC Jain sir also very pointed out very beautifully yesterday, that the solution may be that we use section 329 of BNSS oblique 293 CRPC. What is 293 CRPC? 293 CRPC talks about scientific expert. पहले जमाने में जब भी FSL बनती थी तो FSL को नॉमिनेट किया जाता था, उसको डिक्लेयर करना है उसके एक्सपर्ट को, जिसको हम एक्सपर्ट को डिक्लेयर करने के लिए वी आर बेसिकली यूजिंग द पावर्स व्हिच आर मेंशन्ड अंडर 293 CRPC. नाउ हियर व्हाट हैज हैपेंड इज द स्टेट, नाउ दिस one amendment has happened which allows the states to also notify experts. Is this expert the same expert? Maybe, may not be, because word here is used as scientific expert, but this is appears to be the only solution, that states should now notify, and this is what MHA guideline also says, that states should now be notifying the under provisions of this 329 that who this expert is. Is it a FSL guy? Is it you people? Is it me? Who basically are these experts, and should we basically be also giving that the padvi of expert to universities or others, is now something which MHA has already issued in its advisory, and also say that will now be the responsibility of the state government to basically be doing it. So 39A and all this, in the fulcrum of this, this is what has come out. This appears to be the logical thing, and that is what we will be doing. We would, the catch here is the 63 subclause 4 uses and, that is आप और मैं तो देंगे ही, that is part A आप और मुझे देना है, पर part B देना है. अगर इसका मतलब है कि पार्ट बी बाद में FSL से मिल जाएगा, बहुत अच्छी बात है, लेकिन अगर नहीं मिलेगा तो क्या करेंगे? So it's still something which is not very clear, that how we are going to be able to find this expert, who is this expert on ground. As if now this is the generalistic understanding, that we are hoping that states will take up the matter and bring out a notification declaring the experts also, so that we can understand of how we are documenting this entire process also. After that, we have, I'll finish the presentation very quickly and then we'll have the question answers. It's a very small thing. I'll just finish it off in a very few minutes now. We have this powers of seizures. That is, अभी हम seizure की बात कर रहे थे, search and seizure में हमें documentation करना था. हम एक और seizure के powers है हमारे पास, जो हमारे पास 52 और 102 में है. 52 में ऑफेंसिव वेपन सीज करने की, और 102 में हमें बेसिकली किसी और प्रॉपर्टी को सीज करने की. एक टिपिकल कंफ्यूजन हमारे दिमाग में आता है कि 102 में क्या हम इमूवेबल प्रॉपर्टी सीज कर सकते हैं? कैन वी सी basically can we seize an immovable property becomes the question of 1 or 2. क्या मैं किसी ने मेरे को चोरी करने के बाद एक जमीन खरीदी, क्या मैं जमीन को जाके सीज कर सकती हूँ? हम करते क्या है प्रैक्टिकली, हम जमीन को सीज नहीं करते, हम डॉक्यूमेंट को सीज कर लेते हैं उसकी, और हम नोटिफिकेशन भेज देते हैं पर्टिकुलर डिस्ट्रिक्ट मजिस्ट्रेट को कि देखिए देयर शुड नॉट बी एनी चेंज ऑफ टाइटल्स इन दिस पर्टिकुलर केस. So this is basically all about how we typically end up doing it. अब आता है हमारा इसका भाई यानी कि BNSS. What does BNSS talks about? So BNSS is also not very changing it anything about 102 or it. It is now basically trying to bring in one very good section which is 107. क्या ये 107 पहले था? हाँ, हमने पुराना अमेंडमेंट 1944 अमेंडमेंट में है, क्रिमिनल अमेंडमेंट में था, सीजर ऑफ प्रोसीड्स ऑफ क्राइम, यानी कि अब हम आते हैं मोर और लेस अबाउट दिस इंटायर कंसेप्ट कि हमें उसका प्रॉपर्टी भी सीज करना है, यानी कि प्रोसीड्स ऑफ द क्राइम सीज करना है. प्रोसीड्स ऑफ द क्राइम का मतलब क्या है? मतलब एनीथिंग व्हिच इज डिराइव्ड डायरेक्टली और इनडायरेक्टली एज अ रिजल्ट ऑफ अ क्रिमिनल एक्टिविटी. तो वेरी ब्रॉड डेफिनेशन. ये डेफिनेशन कहाँ से ली है? हमने पीएमएलए से कब ली है? ऑलरेडी स्पेशल लॉज में ये सब कुछ है. ऑलरेडी स्पेशल लॉज में ये सारी पॉइंट्स हैं इन विच वी हैव दीज प्रोविजंस ऑफ पीएमएलए हैज इट. एंड इफ यू नो बड्स एक्ट, Banning of Unregulated Deposits Act, it has exactly the same provision or same exact ditto copy what 107 has now proposed all of us to be. So what does 107 basically say? I'll just show it you in a pictorial form, very simplified pictorial form. आपको यानी कि आपको और मुझे as an IO, you will now have to prepare a report. And what does that report basically will have? That report will basically have the reasons of belief. Now I need to justify why do I believe that this is a proceeds of the crime, that this is a property that the person has directly or indirectly derived as a result of a criminal activity. एक हमारा एनडीपीएस का अक्यूज्ड है, एनडीपीएस के अक्यूज्ड के वाइफ के पास इतनी सारी प्रॉपर्टी है, क्या मैं प्रूव कर सकती हूँ इसमें? क्या एक किसी आदमी के नाम पे प्रूव है, क्या मैं इसको उसको भी प्रूव कर सकती हूँ? नाउ कम्स द ओनर्स ऑफ रिस्पॉन्सिबिलिटी ऑफ मी ट्राइंग टू प्रूव दिस. And here what will now be the next course of action? The next course of action will be the representation, or this application will have to be routed through the superintendents of police. And once it is routed to the superintendent of police, it goes to the court. Now who's this court? This court is the court which can take cognizance or which can basically run a trial. This court has to basically now do something that we have never exactly done punitively till date. आज तक हमें attachments, the word attachment were always used as a means to process, to compel the appearance. To get a person only, I was always using the entire phrase attachments. For the first time, I'm now using the word attachment to attach property. And what should I do after attaching the property? What will the court do after attaching a property? The end game here is that the court will then be able to pass an order of attachment and then will hand it over to the district magistrate to liquidate it and distribute it to the victims. Now, this is something that we all actually want to happen, and we are the entire end result of criminal justice system is that only, that if somebody has been derived of some property or has been caused a financial loss, he should be able to recoup it back. What is the process? What is the point of doing the criminal justice system? What is the point of prosecution if we cannot give back the property back to the person? Or what is the point of basically not being able to recoup the financial loss the person has? So for those objectives, 107, which is a new dimension, has been added. The one big rider will be when this entire implementation of it is going to start is how the implementation will start will be important. Is this being done parallelly to the trial and investigation, or will it be done subsequently to the trial? Because there is always going to be an opportunity or circumstances in which you have done a liquidation, you have done an attachment, and then the person obviously becomes acquitted also. Logically, the criminal jurisprudence says that both of them are different points. Here also the court is applying his mind and then only attaching after giving sufficient reasonable opportunities for him to defend. After, despite that, if he is not able to do it, then We are basically doing the entire attachment process and then liquidating the property. So this is what 107 basically says. And for getting an acquittal or a conviction, we do require a clear-cut, proper establishment of guilt, which has different parameters. We cannot equate both of them. But this is something which is there, which is very unique, that has been included in the sections recently, for which we obviously have to understand that it has to be done in that particular code under provisions of 107, and there should be reasonable grounds. It should have reasonable beliefs. It should have all those details which will enable the court to understand that this is linked to this. Notices now can be given online very nicely. As I said, it is very easy for us to now do it. And something which is very interesting for us is, as Abhinav also was explaining to you, as yesterday also sir has explained to you, कि document के definition में electronic records भी आ चुका है. तो अभी तक 91 जब भी हम use करते थे, हम document लेने के लिए use करते थे कि हमारे सामने document produce करो. You should produce that document in front of us. Here in 94, can we basically ask them to produce the electronic devices? Yes, this is also something that we can actually ask him to produce the electronic devices. Can we force him to produce the password? Is the same, very different question whatsoever, but can we ask him to produce, can we ask anybody to produce a electronic device? Can we ask them to produce, हाँ ठीक है वो tablet लाओ, देखते हैं किसमें किया था, कोई tab लेकर आओ, वो laptop लेकर आओ, हमें देखना है कि इसमें कुछ हुआ था कि नहीं हुआ था. Answer is yes. Now we do have a right now to send notices and get it done under 94. Disposals is very important for us. I'm just clubbing this now to seizure. हालांकि ये वो post court का काम है, लेकिन कोर्ट के काम में एक चेंज हुआ है. There is a small change that has been incorporated, and I wanted to basically explain, because this is something which has always been our eyesore for the police department. We just are not being able to get rid of this entire process. We need to understand how best we can be able to get rid of this. And for that, although we have those judgments also, but what does law basically says? Law basically has three provisions, which was CRPC 451, 452 and 457. 451 बोलता है कि temporarily, जब तक court is not deciding on the finality of it, whether it is an acquittal or a conviction, court may decide to give it temporarily to somebody. That is 451. उसका process was being basically further elaborated in 457. 452 was final disposal. तो अब हमारे लिए जानना इंपॉर्टेंट है कि इसमें क्या चेंज हुआ है, जो नया चेंज आया है बीएनएसएस में. बीएनएसएस एक सेक्शन लाता है जो उसका पैरेलल सेक्शन है 451 का, which is 497. इसमें वो लाता है exactly what 52 NDPS Act says. If you remember the special laws, 52 NDPS Act is a very unique provision. वो बोलता है कि आप अभी चार्जशीट भी मत कीजिए, कोई बात नहीं, लेकिन आप ड्रॉल ऑफ सैंपल कीजिए मजिस्ट्रेट के सामने. जब आप ड्रॉल ऑफ सैंपल बना रहे हैं, आप एक इन्वेंट्री बनाएंगे. दैट इन्वेंट्री विल बी सर्टिफाइड बाय द मजिस्ट्रेट, एंड आफ्टर द इन्वेंट्री इज डन एंड द ड्रॉल ऑफ सैंपल इज डन, यू डिस्पोज इट ऑफ. We don't require to produce it entire 2-3 tons of ganja at the time of trial. हमें नहीं चाहिए वो. We will take the inventory only, and we will verify the inventory, and we will accept the inventory only. Now, this has been tried to be incorporated here, in which the court has now been given responsibility to prepare a statement of the properties. And once the statement of the property, what is that statement of the properties? This is where the statement of the properties part also come, in the form and the manner in which the state government may say. उसको करते हुए क्या करना है, फोटोग्राफी भी करनी है, वीडियो रिकॉर्डिंग भी करनी है, ताकि हमारे पास एविडेंस हो जाए कि हाँ जी हमने तो इसको लिया था, हमने इसको प्रोड्यूस किया है. जब हमने उसको प्रोड्यूस कर लिया, अब क्या होता है, इसके बाद इसमें भी टाइमलाइन है, 14 दिन के अंदर उनको करना है. 14 दिन को करने के बाद, once this statement of record has been done, within 30 days the court has to order for its disposal. यानी कि the entire idea, हम सीसीटीवी लेने जाते थे, हम सीसीटीवी का डीवीआर ही सीज किए जा रहे हैं और हमें परमानेंटली कर अपने पास रखते हैं. The fact is, और क्यों नहीं वो अपने पास रखते, क्योंकि उसको वापस दे नहीं सकते. This is trying to ease it out, in which it says you draw something which is known as a statement of record. After drawing the statement of record, please try to do all these things so that you can give back the property. Now, this is something very revolutionary, but it is going to put a lot of onus of responsibility because on the magistrate, because then it becomes his job to do it. अब मैजिस्ट्रेट का काम है कि वो एक इन्वेंट्री बनाएगा, तो हमें मैजिस्ट्रेट का टाइम लेना पड़ेगा, मैजिस्ट्रेट के पास एक लिमिटेड टाइम फ्रेम होता है. तो these things are also going to become important for practical implementation of it. And how does this exactly practically gets implemented also? Arrest, you had a very elaborate discussion, very beautiful discussion with DC Jain sir. I'm not at all going to go back into it. I'll just show you some things that have been added in CCTNS modules for others specifically regarding this. Now CCTNS, there is this provision, you all know, that less than 3 years है, more than उस सब में हमें एक परमिशन लेना है less than 3 years punishment में. So उसको करने के लिए they have created these forms in which the permission also can be taken through the CCTNS. So this is something which is easy, good for us. It makes our lives easy in all those cases where the arrest has to be done in that provision. उसके अलावा जब हम उसको इंफॉर्मेशन भेज रहे हैं 50A में, तो उसके लिए भी हमारे पास एक डॉक्यूमेंटेशन है, मोड ऑफ इंटीमेशन है, ईमेल में भी भेज सकते हैं, और वो ईमेल भेजने के लिए उसका फोन नंबर ले सकता है, उसका ईमेल आईडी ले सकते हैं, और उसमें उसको भेज सकते हैं. वी कैन ऑल्सो सेंड देम, एंड उसके लिए भी उन्होंने एक सेपरेट फॉर्म बनाया है अबाउट इंटीमेशन, और उसके अंदर ईमेल आईडी एंड द मोबाइल फोन्स आर ऑल्सो एडेड. प्राइवेट पर्सन में ऑब्वियसली बात है, as soon as possible. Now they say no, within 6 hours you should produce it, because most probably as soon as possible was not happening. So that is what they believe, that they have added less than within 6 hours you have to bring him to the police. 41C tha basically, which initiated the control rooms in district, which should have the details of every person who's arrested. Now this has been, the nomenclature has been changed to called as designated police officer. Does that mean क्या control room नहीं है? नहीं, control room अभी भी है, अभी भी हर district में है, अभी भी state में है, लेकिन वहाँ एक designated officer भी रहेगा, जो कि ASI से नीचे नहीं हो सकता, जिसके पास सारी information होनी चाहिए कि कब कहाँ arrest हुआ. इसके तहत भी, under this also now all the states have to gear up and start notifying. This is an example of Assam that I have tried to bring it out to you. You must have already done it, or if you're not doing it, you will be in the process of doing it, in which you will have to notify who this designated police officer is at districts and at state level also. इसका एक और यूटिलिटी है डेजिग्नेटेड पर्सन का, कि कई बार क्या होता है जब हम अरेस्ट करते हैं, for example, a person from Jharkhand, I have arrested him in, I know he resides in Bangalore, and I take an arrest warrant and go to Bangalore and try to arrest him. I do also typically have to inform that the place where he usually resides. Now, usually resides का मतलब है जहाँ उसका typical residence है. Why we typically end up, why do we want to do it? There is a lot of habeas corpus things that keeps on happening, because sometimes we just inform the friends, we are informing somebody who he is telling us, but the parents don't know where the person is. So since the parents and the family members don't know where the person is, they are going to file a kidnapping case against the police, or they are going to file a habeas corpus against the police. So to overcome this idea is where the person originally resides, उसके उस particular district को भी हमें इंटीमेट करना है, वहां भी डेजिग्नेटेड पुलिस ऑफिसर या कि उसकी कंट्रोल रूम में दैट इंफॉर्मेशन हैज टू बी गिवन. Handcuff, very important part that has been added, but let us be very, very careful about it. Theoretically, it can only be used in 2 circumstances, which is while making an arrest or while producing. हम और भी बहुत सारी चीजों में लेकर करते हैं, उसको लेकर जाते हैं, एसओसी के टाइम लेकर गए, यहाँ गए, रिकवरी करते हुए गए. All those things are not as if now covered under handcuffs. You can try to make it show anything or like this or that, but the implementation of law basically has 2 provisions. So please be very careful of how you are documenting the use of handcuffs. And always remember that there has to be this checklist कि किसको handcuff कर सकते हैं. हर एक को हम handcuff नहीं कर सकते हैं, सिर्फ इनमें से किसी एक को कर सकते हैं. Habitual repeat offender का ये मतलब नहीं है कि हर बार दो बार उसने काम किया है, 2 बार theft कर लिया तो वो habitual offender हो गया है. नहीं, इसका ये मतलब बिल्कुल भी नहीं है. Habitual offender Act में जो habitual offender है वो उस आदमी को हम यूज कर सकते हैं, या फिर इन पर्टिकुलर केसेस में वो ऑफेंडर है उसको हम पर्टिकुलरली यूज कर सकते हैं. Remaining is something which is already there, like why I brought this, because these are some good things which have been done in CCTNS. You may incorporate it, you may not wish to incorporate it also. This is where the MLC register has been incorporated into the CCTNS, that is the link has been generated और एक MLC generate होता है. हम ये क्यों use करते हैं? हमें medical examination of accused करना होता है, इसीलिए we are typically end up using it and we try to use it, which is something, a good thing that can also be done. Remand, I think yesterday sir must have very elaborately explained to you. I'll just take 2 minutes. Simple rule of thumb, Police remand can only be of maximum 15 days. It can be taken anywhere between the first 40 days or first 60 days, depending upon which offense the person has been arrested in. There is a lot of contention about it कि maximum 15 days नहीं है. इसका मतलब है कि actually हम ले सकते हैं. There are a lot of views, counter views. I have actually gone through the Rajya Sabha discussion also. And in the Rajya Sabha discussion also, the categorical part means that their implied understanding was that it is 15 days. So this is what, as of now, the understanding is. Anupam Kulkarni is getting modified now. That judgment is getting modified. It will not be there because now we can take those things. अभी 2 दिन ले सकते हैं, बाद में 2 दिन ले सकते हैं, और बाद में 2 दिन ले सकते हैं. We can keep on doing it till 40 days or 60 days. इसके अंदर भी CCTNS ने कोशिश की है कि it can be incorporated into the ICGS module, and there is like आपने there's something going on in Jammu Kashmir, and all UTs have been very aggressively adopting Nice, Shruti, and all other small apps that NIC is developing. All of them have the initial teething problems, but once we are able to technologically adopt it, all these implementations will become very, very easy for us. Proclaimed offender, sir has very elaborately told you. A proclaimed offender पता होना हमारे लिए बहुत जरूरी है. Proclaimed person अलग होता है. See, there are different types of things. Proclamation is always going to be the same. First question, can proclamation be issued against witnesses? The answer is yes. Can proclamation be issued against accused? The answer is also yes. Can it be, when it is issued against accused, will he become proclaimed offender? Answer is no. Because proclaimed offender is defined, and proclaimed offender word, typical word, is used only for offenders under that particular subcategory of offenses. So what used to happen, and if you see that also, rape is not there. So can a rape accused never become a proclaimed offender? Yes, actually he becomes a proclaimed person. He's not a proclaimed offender. So, but now that alteration has also happened, and now it is a blanket. Everything which is more than 10 years, आप उसके against proclamation निकाल सकते हैं, और जब proclamation होगी, he will become a proclaimed offender. And why is proclaimed offender important? It is important for 356 BNSS, which sir has very elaborately told you yesterday, this section. कि इसमें कोर्ट के पास powers हैं in absentia trial करने के लिए. Please remember, in absentia trial can only be done against proclaimed offenders. And there was a lot of question yesterday also about it, and once again I like to re-emphasize it. Proclaimed, this in absentia trial doesn't mean that we're taking away the 100% rights of the accused. Yes, obviously this is going to be debated tomorrow, because a judgment is a final conclusion of his guilt is going to come without him being able to defend. But does that mean he'll not be given a legal counsel? No, he will get legal representation, but we will not keep on waiting. That is the fulcrum, and that is the crux of it. उसको करने से पहले हमें क्या प्रोसेस करना है? आप प्रोक्लेमेशन तो करेंगे ही करेंगे, और आप कल भी एक क्वेश्चन था कि उसको करने से पहले क्या हमें अप्लाई करना होता है या कोर्ट अपने आप करेगा? देखिए, ये पावर तो कोर्ट की है. This is the power of the court to basically do in absentia trial. Can we push it through PP? Obviously, we should be able to push it through PP because this is a new section which has come. Will it get hurt to whatever has already been implemented, or the trial that has already been initiated? We don't know. We still have that confusion. Like sir was very elaborately telling कि ये लगेगा कि वो लगेगा. उस सब चीज में अभी भी हमारे पास एक अच्छा खासा वो डाउट है कि क्या लगने वाला है और क्या नहीं लगेगा. But idea remains by and large clear that this is something which is very powerful, which can be done only against proclaimed offender. Once it is being done, then also there are checks and balances that have been incorporated in the act itself. Act itself is telling you कि आपको उसके इतनी बार नोटिस देना पड़ेगा, दोबारा करना पड़ेगा, अरेस्ट वारंट एग्जीक्यूशन, ये करना पड़ेगा, वो करना पड़ेगा. उसको करने के बाद now the court will decide that should I go ahead with the trial. Yes, court can go ahead with the trial. Once the court goes ahead with the trial, this section is so stringent that if the person doesn't comes back, he cannot even appeal. The appeal, for his appeal, his personal presence is mandatory. His personal presence will become mandatory. Other than that, he cannot appeal. And if he doesn't appeal for 3 years, then there cannot be any appeal. So it is absolutely, definitely very strong section. We may have our own observations about it. We may agree with it, we may disagree with it, but it is something which is very, very potent, very, very important for us. Specifically when we are handling people like Dawood Ibrahim, then we are not able to extradite him just because of the fact that we don't have conviction. Now coming to the very important aspect of charge sheet, एक बहुत ही छोटा सा change हुआ है, उस change को implement कैसे करना है is what we are trying to discuss here. उसमें एक वर्ड यूज किया गया है विच इज सीक्वेंस ऑफ कस्टडी ऑफ द इलेक्ट्रॉनिक डिवाइसेस, यानी कि अगर आपको जैसे इफ यू रिमेंबर देयर इज दिस फुल लिस्ट ऑफ सेक्शन जो आपको डालना होता है, विच शुड बी ट्रेडिशनली पार्ट ऑफ द चार्ज शीट, एंड देयर इज वन provision sub clause I that has been added, that is the sequence of custody of the sequence of custody that needs to be added. अब हमें एक chain of custody form लाना पड़ेगा, बनाना पड़ेगा. ये चेन ऑफ कस्टडी हमारे मालखाना से थोड़ा सा अलग है. क्यों अलग है? क्योंकि ये एक चार्ज शीट का पार्ट होगा. अब दिस हैज टू बिकम द पार्ट ऑफ द चार्ज शीट. इज देयर अ फॉर्मेट दैट हैज बीन गिवन? द आंसर इज नो. I am showing you something which I have myself borrowed from the West. Is I have taken that example, and something as simplistic as like this has to be done. Was it ever done previously? If you go back to NDPS Act, you do exactly this, because there you have a notification in which the go down in charge का एक list है, एक format है, हर चीज वहां दी गई है. ऑलमोस्ट सेम टाइप से यहाँ लॉजिक है, जिसमें है कि किसके पास कस्टडी थी. Theoretically, our Malkhana's custody is with the SHO, but is the key always with SHO? The answer is no. So who has the key, who has the safe, who is the safe custodian of this? Uske liye this entire provision has been added, which is the chain of the custody, which basically says kiske paas tha, kisne diya, jiske paas tha wo sign karega, jisko diya wo sign karega. ताकि और ये कॉपी आप चार्ज शीट में लगाएंगे. दिस कॉपी हैज टू बी अटेस्टेड टू अ चार्ज शीट, एंड दिस आल्सो विल हैव टू, ऑल ऑफ अस नीड टू बी वेरी वेरी केयरफुल अबाउट डूइंग दिस फ्रॉम नाउ ऑनवर्ड्स. Previously there is also this sub contention which comes same thing which is going on, और उसी में उसके आगे उसका सिग्नेचर है, दोनों पार्टीज का सिग्नेचर्स है. I'll be circulating it. This is a western idea, but we do require to do it. उसके बाद ऑब्वियसली जब हम इसको साइन कर रहे हैं, इसको सबमिट कर रहे हैं, कैन वी डू इट इन इलेक्ट्रॉनिक फॉर्म? यस, वी शुड बी एबल टू डू इट इन इलेक्ट्रॉनिक फॉर्म. नाउ ICGS is being adopting it, so we should be able to do it very much in an electronic form also. There is this one subcategory which is 173 subclause 8, which is 193 subclause 9 of BNSS, which is further investigation, which we typically keep on doing it because we are trying not to allow him to go on default bail. And we are also taking sufficient time for gathering all evidence. Typically, because we don't get FSL reports on time or something like that, is a typical idea in which we use 173 subclause 8. What was previously happening was that there was a Supreme Court judgment which says that you need not take permission of the court, of the trial court while doing, but you should intimate the trial court so that the trial court doesn't start the trial in isolation. But now what has come in, and one provision which has come in, is that you require to take permission of the court for the cases, and that permission obviously उसका एक time limit भी दिया गया है. अब ये वाला जो permission वाला part है, you have to understand that the wordings that is further investigation during trial. Please remember this. Trial starts with the framing of charges. The entire portion which is we call HBC, hearing before charge, cognizance, committal, is everything before trial. आपने चार्ज शीट सबमिट कर दी है, लेकिन अभी भी चार्जेस फ्रेम नहीं हुए हैं. So theoretically, as per this definition, you don't have to take permission. But obviously, for the benefit of us, everything, we do keep the courts informed that, sir, we are still in the process of getting it. And there has been a practice in a lot of states in which वहाँ चार्ज शीट के कॉलम में ही लिखा जाता है that we may be permitted to submit a further investigation, supplementary charge sheet because of pendency of certain things. Preventive action is something that has come in now, and वो पहले से था, ऐसा कुछ नया तो हुआ नहीं है. ये इससे ज्यादा जरूरी ये सेक्शन अब एक ऐड हुआ है, which is a small section जो कि प्रिवेंटिव सेक्शन वाले चैप्टर में ऐड हुआ है. प्रिवेंटिव सेक्शन वाले चैप्टर में, इफ यू रिमेंबर, यू हैव पावर्स. 151 में आपके पास पावर्स है टू अरेस्ट समबडी और टू बेसिकली डिटेन समबडी टू प्रिवेंट द कमिशन ऑफ अ कॉग्निजेबल ऑफेंस. देयर इज आल्सो पावर्स ऑफ प्रोटेक्टिंग डैमेज ऑफ पब्लिक प्रॉपर्टी आल्सो. So all these things, if you observe, they have created another subclause which is 172, which says that if a police officer gives an order under this particular section, then the order has to be followed, and if somebody who is resisting it, he can be detained by the police. And obviously the detain ka matlab hai that you need to either release him or produce him in front of the magistrate within 24 hours. ये सारा काम हम 151 में पहले भी करते थे. 151 में ये लिखा भी है कि आपको प्रिवेंट, अगर आपके अगेंस्ट आपको लग रहा है कि देयर कैन बी एन देयर कैन बी अ कॉग्निजेबल ऑफेंस हैपनिंग, इट इज योर रिस्पांसिबिलिटी टू प्रिवेंट इट। सिंस इट्स माय रिस्पांसिबिलिटी टू प्रिवेंट, मैं कैसे प्रिवेंट करूंगी? मैं डिटेन ही करूंगा। डिटेन करने के बाद मेरे पास क्या ऑप्शन है? मेरे पास ऑप्शन है या तो मैं उसको मजिस्ट्रेट के पास लेके जाऊंगा या मैं उसको छोड़ दूंगा। सेम चीज अभी भी है, पर अब उसको थोड़ा सा और बेहतर इम्प्रोवाइजेशन या उसको और बेहतर वर्डिंग्स दी है कि अभी भी आप उसको डिटेन कर सकते हैं एनी ऑर्डर्स दैट हैज बीन गिवन बाय द पुलिस ऑफिसर। वन वेरी इंपॉर्टेंट एस्पेक्ट दैट आई वांट टू हाईलाइट हियर इज, ऑर्डर का मतलब ये नहीं है कि आपने बाद में कभी ऑर्डर दिया, पहले कभी ऑर्डर दिया, कुछ और ऑर्डर दिया। दिस ऑर्डर और डायरेक्शन इज ओनली रिगार्डिंग दिस चैप्टर। What is this chapter? This chapter is for preventive action. Only this chapter के अंदर अगर आपने कोई ऑर्डर दिया है, that उसका अवेल ना होता है या फिर that order is not followed, then 172 comes into picture. This documentation, this understanding has to be taught to every one of us, including specifically our junior subordinate officers. इसमें भी obviously they are trying to incorporate CCTNS. They have added one subsection in which the preventive sections are also being added, जहाँ ये सारे sections के बारे में भी documentations can be done. Now I had already discussed small points about victim-centric approach, जहाँ victim को ये देना चाहिए, specifically rape victim के साथ क्या क्या होना चाहिए, victim को information मिलना चाहिए. Same चीज has been communicated to trial part also. उसमें क्या लिखा गया है कि if you remember we have the 207 की कार्रवाई 207 in which we are supposed to basically, it is magistrate's job to basically give it to the accused, but we are assisting the magistrate in making the amount of copies of charge sheets and all other things. So the dichotomy of Indian law previously was that we were obliged to give it to the accused, but we were just supposed to intimate to the victim. So here obviously the court, I mean to say, here that dichotomy has been removed. Now the court has to basically give the copy to the victim also and has to give a copy to the accused also. So that has a clarity. Committal proceedings में भी करना है. Committal proceedings में भी उसकी सुनवाई होनी चाहिए, चाहे discharge से पहले भी सुनवाई होगी, withdrawal से पहले भी सुनवाई होगी, and 90 days के अंदर आपने क्या investigation में progress किया वो आपको intimate भी करना पड़ेगा. So ये सब कुछ victim centric है, in which we are supposed to basically inform the victim. He has to become a part of the criminal justice system. He is not just a mute spectator sitting outside. He will be informed at every single point of time and about it. So that is there. इसमें sections, इसमें basically इसके लिए अब implement करने के लिए करेंगे कैसे? इसको implement करने के लिए हमने एक SMS वाला system भी वो अपना एक registration of all that also has been initiated. मतलब CCTNS में उसका मोबाइल नंबर चला जाएगा. मोबाइल नंबर चला जाएगा तो ऑटोमेटिकली इंफॉर्मेशन जनरेट हो जाएगी हर पर्टिकुलर पॉइंट ऑफ टाइम पे. One basic thing, because I will not dwell too much about the court aspects, we will finish well in time, is about the victim protection scheme that the states now basically are allowed to make. And if you observe, if you go to BPRD website also and all other things also, Assam has already gone ahead and done a notification of the victim protection scheme. So a state like Jammu Kashmir and a lot of other states will definitely be very interested in doing this, because this is a one major focus area where we need to work. And in this, if you observe, they have created something which is a competent authority. And that competent authority is a committee which includes the judge, which includes the SP, includes the executive magistrate, and also the head of the prosecution of the district. And that is the competent authority which has the power of giving a lot of protections to the witnesses, including change of name and all of sort of things which is expected in modern day India also. उसको फंड करने के लिए कहाँ से आएगा पैसा? उसके लिए भी उन्होंने एक फंड बनाया है, उसके लिए एक प्रोसेस भी बनाया है कि एप्लीकेशन कैसे दी जाएगी. So just for your reference, I have attached this part to it. So, but more or less, we will all have to work on developing a very good witness protection schemes also. ये मैं आपको बताना चाहती थी, आपका ही है जम्मू कश्मीर का, मैं ढूंढने की कोशिश की. So why I had basically pointed out this out is हम सब कुछ अभी कोर्ट रिलेटेड डिस्कस करेंगे कि कोर्ट को 497 मैंने अभी आपको डिस्कस किया कि कोर्ट को ये करना है, मैजिस्ट्रेट को ये रिकॉर्ड पे लेना है, मैजिस्ट्रेट को वो रिकॉर्ड पे लेना है, एक स्टेटमेंट बनानी है. फिर अभी अभी हमने डिसाइड किया कि मैजिस्ट्रेट को ये भी कॉपी देनी है, सुनवाई भी करनी है, विक्टिम को हर बार नोटिस भी देना है. ये सारी चीजें कैसे इम्प्लीमेंट होती है, ये सारी चीजें implement होती है through court procedures. There are provisions which are there, and this is your latest general rules of criminal practice. So you will automatically have to keep a watch on what rules of criminal practice are coming out. BNSS brings in a lot of timelines specifically for the courts. हमारे लिए तो कम है, पुलिस के लिए, कोर्ट्स के लिए काफी ज्यादा timelines have been added. उसको implement करना कैसे है? What is the role of the presiding officer? What is the role of Srishtidar? What is the role of court clerk? So all these things will have to come and get notified into your criminal rules of practice. Every high court has their own different rules of practice. All of them are right now working to revamp it. And as and when it does get revamped, please keep a watch on it, because जो भी हम discuss कर ले, चाहे कैसे भी discuss कर ले, हमें law पता भी होगा, तब भी more important है उसका implementation. और वो implementation सिर्फ तब हो सकता है जब उसका एक legal sanctity हो, एक responsibility हो. हमारे लिए SOP बनाना जरूरी क्यों है? क्योंकि वो black and white में आना चाहिए कहीं ना कहीं लिखकर. जब वो ब्लैक एंड व्हाइट में आएगा तभी हमारा कांस्टेबल उसको इंप्लीमेंट कर सकता है. उसी तरह से कोर्ट के लिए भी जरूरी है, और उसके लिए ये इंटायर प्रोसेस इज बेसिकली व्हाट इज डन. So yesterday this was also asked by some of you that if in a special law, special law we used to give complaints and all other things is there. So if you observe here also, that is still continues to remain complaint only. And everything, the logic of complaint exactly matches the same only. कुछ नया नहीं है, पर properly बस add कर दिया गया है. पहले इसी complaint वाली, जहाँ complaint वाली सब category में इसको assume कर लेते थे, अब वो assumption नहीं है, वो properly बताया गया है. लेकिन special law में the empowered officer, if he is submitting anything, it is still a complaint only, sir. It will always be a complaint only, and that is what exactly the new 210 which has come from 190 means. So complaint to magistrate is same. Obviously हमारे लिए protections आ गई हैं, accused को opportunity of heard, और public servant के लिए तो बहुत अच्छे से protection आई है, जिसमें उसको भी heard करना, और and है वो, because it is not or. रिपोर्ट भी चाहिए हमें एक सीनियर ऑफिसर की. A report of a senior officer is also warranted. We do require that before we start or take a direct proceedings against him. Summons important for us because this has already gone into our mind that first important thing is e-summons have come in. We can electronically summon to it. Another very basic thing is we had this entire provision in which male members of the family को serve करना था. अब male members of the family को नहीं serve करने की जरूरत है, उसकी wife मिल गई तो उसको भी हम serve कर सकते हैं. It is a clarity that has come into our processes. This is related to us, hence it's very important. This is also something which is very important, which is securing attendance of the successor. ये क्या बोलता है कि अगर public, there are these 3 categories है: public servant, scientific officer, medical officer, जिसकी evidence ली जानी है. अगर वो नहीं मिला या फिर वो कहीं है, ट्रांसफर हो गया वगैरह वगैरह, तो अब हम उसको कैसे सिक्योर कर सकते हैं, और वो सिक्योर करने के लिए क्या हम उसका whosoever is the incumbent, can that person be called as evidence? So this is something that very categorically brings in that power that the incumbent, yani ki next person who's sitting on the chair. I was previously the CMO, I have issued a medical certificate, I have left. So another person has come, like I have come in the place of Abhinav. So Abhinav has certified something, and now I have come, I am sitting on this chair. Can I be summoned to the court? The answer now is yes, I can be summoned. मुझे Abhinav को ढूंढने के लिए जाने की जरूरत नहीं है, वो कहीं भी हो सकता है. इसका अब यूज करने के लिए 2 पॉइंट्स हमें सबसे ज्यादा जरूरी है समझने के लिए. इसमें आईओ नहीं है, ये पब्लिक सर्वेंट की डेफिनेशन में आईओ नहीं आता है. जब पहला iteration of BNSS, the first iteration of BNSS when it came, it actually included the word IO. And there was a lot of hue and cry about the word IO, that how can you just give up the role of IO? If the IO changes, then shouldn't he be called? So IO has been very categorically removed from this list. Since the IO has been removed, please understand it is not for us. It is more or less about these 3 category of people, but it should be used by us so that this pendency of cases is gone. For very trivial reasons, the cases are pending, like the person is not being found, या वो गया हुआ है, ट्रांसफर हो गया है, बीमार है, वो सब चीजें अब नहीं होनी चाहिए. ऑनलाइन मोड ऑफ हियरिंग आ गई, अब बस ये देखना बाकी है कि इसको इम्प्लीमेंट हम कैसे करते हैं. वी हैव बीन डिस्कसिंग दिस फॉर वेरी लॉन्ग टाइम दैट इट इज देयर. नाउ इट हैज कम इन द लॉ आल्सो. इट इज गोइंग टू बी अ चैलेंज इनिशियली. कौन बैठा है, कैसे बैठा है, उसको कैसे वेरीफाई किया है. It is going to be challenging initial 5-6 years for all of us, but the orders are there. Timelines, I'm not going to dwell too much because this is court-based timelines. कोर्ट के पास अब टाइमलाइन आ गई है, 90 से 180 डेज तक तुम्हें कॉग्निजेंस लेना है, मतलब कमिटल के टाइम लेना है, उसके बाद आपको फर्स्ट हियरिंग ऑफ चार्जेस भी जल्दी खत्म कर देना है. Theoretically, all of them look very good, but we all understand that there is a lot of obligation, there's a lot of pressure on the judiciary also. Now, this entire second portion of this is the onus of responsibility of judiciary to basically rise up to the matter of how basically they will be able to do that entire process. So this is more or less about timelines. I'll leave the PPT with you also. I'm not too much focusing on those aspects at all. I'll just briefly share you, this is the end of my presentation. This is the brief presentation that I had basically brought for regarding the e-content and new criminal laws that we have developed. We have developed 3 e-contents and we have uploaded those e-contents on iGot. We will request all of you to please use these opportunities also. Sometimes we are not able to conduct these classes or these online sessions for new criminal laws, but we definitely have developed and understood that these are some small snippets of what we have developed in BNSS. It is all based on case by case scenario, what exactly is zero FIR, what exactly is EFIR. All these things have been developed, and the same has been developed for BNS as well as for the Bharatiya Sakshar Adhiniyam. So everything has been developed this, and this is the last portion that I wanted to introduce you all to. We have in NPA something known as a knowledge management system. In the knowledge management system, we have a portal. It has a separate name. I'll be giving you and submitting you the knowledge management system the instructions also. Anybody who has a .gov gov.in can basically be logged into it. Last time we had officers from Jammu Kashmir Police that basically said that our jkpolice.gov was not being accepted, and we had looked into the matter, and I think that that has been sorted. So all of you can basically become members of the knowledge management system. And once you are the members of, if you have to have either of them, then it will automatically open up to you a lot of our video recordings of sessions. We have done a video recordings of sessions, and that can be looked into at a subsequent point of time. Initially, right now, yes, everything is being hosted on YouTube, but later on, it cannot be kept in public domain for a very long time, so it will be removed from YouTube after some time. But it is as of now there on the YouTube links. But it will permanently be there on the knowledge management system. So please utilize this responsibility and this opportunity of utilizing the knowledge management system of whatever NPA is doing, whether it is for national new criminal laws or whether it is for other laws or other fields of policing that is there. So this is all about from my side. I hope you have enjoyed these last 1.5 days and have learned something and have found it fruitful for this entire what we had planned for you. And I will now be actually sharing the link to all of you for the feedback. Just it will take 2 minutes of your time, but it's important for us so that we are able to improve continuously. Just a second. स्टॉप शेयर कर दीजिए. Okay, I'll share with you the e-content links also, sir, and I'll also share you the KMS. If you go to the drive, sir, I've already uploaded my PPT. The PPT regarding the audiovisual thing, I have already shared with you also. And in the group I have shared, I've already uploaded that also there. Abhinav's slides have also been uploaded, and DC Jain sir's slide is also uploaded. Regarding KMS link, I'll share with you the KMS link as well as I'll share you the iGot link also with you right now. Feedback, please share it. You can share it right now also in the chat. We'll note it down. But any other thing, most importantly, I'll request you all to fill up the forms, please. If sir, can I have the details of those things, email IDs which you had already submitted? I'll basically try to look it. KMS link also I have shared. You will have to register it there. Please register in KMS also, and also you can explore our e-content in iGot. Uh, no, sir, Karam Yogi format is not same as KMS. Karam Yogi format is iGot basically, sir. And iGot is for everybody, all public servants. KMS is our thing which is hosted by the NPA. And we have a police only issues basically that here. Some previous question remained unanswered. Okay, sir, I'll have a look at it. Should we register each IO as e-Saksha app in order to use, because only SHOs have created, and right now, no, I believe it is for IOs also, sir, and IOs have created it. You may actually look into it and actually request it. They are doing that verification, and for that verification, there is a single point of contact for the full state. So that is going to be a challenging, and slowly, that is what they are trying to improve into. The other thing, all AVs must be submitted to magistrate. What is the protocol in e-Saksha for that? Please guide. I believe they are trying to link it with ICGS. Otherwise, if they don't link it with ICGS, they are providing you a copy of that, sir. Do we require a video recording of simple seizure of documents produced before an IM? See, if you are quoting any evidence as an evidence tomorrow in court, then it is applicable. Although it only says about 105, 100/165. आप कहे कहीं आपने सर्च किया, उस सर्च में categorically BNSS says that you should record it. What you are trying to ask me question is about 91 or 94. I have asked somebody to give me this document and he comes and produces this document to me in my presence in police station. Should I video record it? Theoretically, just mere reading says no, but then there are already judgment which says that 100 is applicable to that also. If 100 is applicable to that, that 105 also becomes applicable to that. So theoretically, you should be doing it. Not iOS. So that is something which NIC is looking into it, sir. Okay, you basic question. There were some questions about what should be done in the 3 days. Very important thing, sir. If you ask me, personally speaking, since we have finished the session, I can share my personal views about it. Basically, is that if we were waiting for the person to come and sign for 3 days, then there was no need for an electronic FIR to even come into existence. Why was this even added if you're just waiting for 3 days? So if you ask me, we need to actively, proactively go there, verify. And if something is brought to our knowledge which discloses a cognizable offense, we have to act. There is no point. We have got a lot of backlash. You see the present circumstances of the things that are happening. So we are already getting a lot of backlash of not acting despite knowing that there is a cognizable offense that has happened. So we can't wait कि parent देगा complaint तब FIR होगी, वो देगा complaint तब FIR होगी. अगर आपको दिखा है सामने तो आपको FIR करनी चाहिए. And that is what law expects us to do. Nobody is asking us a picture perfect FIR, but everybody is expecting us to do a prompt job with it. Whatever has been brought to us, our knowledge should be registered to FIR. 3 days is very dicey. Please form your own SOPs about it. You have to have crystal clarity on it, because otherwise the subordinate officers have very different interpretations of it. Preliminary inquiry is something which is very, 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 very dicey. You need to be very, very careful about it. Develop something, checks and balances about it, because this can give us a lot of bad public feedback also tomorrow, because it can also be misused, if I may say. Some police stations are created for special act, like tourist police stations. If they get a complaint, are they supposed to register zero FIR? So yes, ma'am, since that, but sir, that FIR is that police station does not has the responsibility of registering FIRs only. Like, see, I don't know what exactly is the TT referred to, but I'll take an example of traffic police station, which is there in my state. I belong to the state of I'm born on the Karnataka border. So if it is there's a traffic police station, and a traffic police station can only register traffic offences. So क्या वो transfer करता रहेगा? There, my understanding says it has to go to the jurisdictional law and order police station. Law and order police station is supposed to do a zero FIR to that concerned law and order police station. It is not supposed to be traffic to traffic or something. My understanding says if you are a very specific police station which is only for this sections, then you don't have to start registering zero FIR for other sections. That will be done by the law and order police station, and the law and order police station will have to do it. Yes, theoretically you will say, ma'am, we are doing the same thing. We are avoiding registering FIR. We are sending him once again to another police station. I agree to your point also, but then somewhere accountability needs to be fixed. If you don't have the powers of registering FIR under the provision of law itself, then how will you basically initiate a registration is what my take on it will be, sir. I think I have answered your question. Tourist Trade Act. Okay. People, sirs and ma'ams, if you are already there with us in our group, please message me on the group and I'll verify regarding your email ID's registration also. Okay, very ये हमारे वालों ने किया है. किसका क्वेश्चन है? बाप रे, very long questions है. Power and functions of the Directorate of Prosecution in terms of are to be read. So C, D, E, what you are trying to refer to is basically about giving legal advice or legal aid. And that always has been what prosecution, we look up to prosecution to be basically doing also. So we do believe that the prosecutions will be doing the same things. I do not think that they basically are confusing it with judicial proceedings. And your role is basically to assist investigation because that Sarla judgment is there, and we also understand very importantly that those are separate. You are a separate part of the criminal justice system, and you have to be independent. You have to be enlightened. You have to be allowed to make independent decisions and observations. What sir was saying yesterday also was the same, that you have a right to have an observation, and that observation has be the IU may factor, may not factor also. So the entire logic to this and the mere reading of it, the plain saying reading of it basically says that it doesn't mean your intervention into the investigation, but it definitely means advice. With the new act, and can the law department has over, and I don't think any department has any overriding powers in any consideration for that matter, sir. Monitoring and supervision of working of prosecutors dealing with criminal appeals west with DOP. The only exception being Advocate General. That is something that is a technical question. So I'm really not very 100% sure of the last part of the question, fourth question. I'm not very aware of that aspect. I'll get back to you if you message me. I'll definitely get back to you about that, sir. Any other thing? Let us check it there. According to our figure, only 52 people have filled the feedback. There are 249 people who are already logged in. Please, we all of you are requested to please fill the feedback. It's extremely important for us to improve. Twenty people have filled it up. Please fill up the feedback form. एक और भी भेजा है, वो तो हमने शेयर ही नहीं किया। कहाँ है वो फीडबैक, वो कहाँ है वैल्यूएशन वो? अरे तो लिंक किसके पास है यार, नहीं दिया उसने। People have submitted feedback, so please, remaining all are requested to please fill the feedback. Dear participants, I apologize. There is actually another form. There was a mix-up of forms. There is something known as a final evaluation form also that we are supposed to fill up. I'll be just sharing that link with you. I apologize for doing making you do it twice, but if you can just fill up that form also, that will be very appreciable. PPT of DC Gen set is also uploaded. It's there in the drive. All officers, please fill up both the forms, and after you fill up both the forms, you can please leave. Both the forms need to be filled up, feedback and the final evaluation. I have put up both of them for you. Please fill up both of them.